A full, yeah. I feel like we didn't get invited to the party.
Cassie.
Yes, sir.
Mr. Walker dressed up today.
Yes, I can see you with your brave
Judge,
colors.
how you doing this morning?
The Fila suit.
I apologize for this, Judge.
That's why I got my Fila suit on under my robe.
Judge Cass and I was wondering if we could go first.
So we're going to call the calendar and then we will make a plan. So I'm not opposed to that, but we just need to figure out who's here, who's not, and what's going to happen. And then we'll take care of that.
Okay.
All right, I'm just waiting on a deputy and then we can call the calendar. I just want to make sure they're able to tell me who's here in terms of folks in custody. One thing I can say, I don't know if Ms. Phillips is dialing in, but if so, she can go. I got the null pros.
Thank you, Judge.
Sure.
Oh.
Hey there. That's all right. We were waiting for you. We will start now that you guys are here. I'm gonna call the calendar. You need a second? We ready? All right. So, ladies and gentlemen, a couple things. We're calling a criminal trial calendar this morning. The trial calendar covers 3 jury selection dates. There'll be no jury selected today, but next Monday, November 8th. And I've sent out an email to the lawyers who have cases on this calendar that identifies the cases that need to be ready to go on Monday, the 8th. Our next jury selection date is November 30th, so just after Thanksgiving. And I've listed the cases in the order in which I'll call them out that need to be ready on the 30th. And then finally, just before the winter break, December 14th is our last jury selection date for this year. And same thing, list of cases that need to be ready on that date. Cases not reached on earlier dates can roll over to the next date, but they will likely fall to the bottom of the list. We'll see how that flows and we'll keep everyone posted if everyone keeps me posted. All right. Position 1 is Mr. Hodge. I think we have to hold. Is Mr. Webb planning on being here in person, Ms. Nelson?
Yes, Judge. He's on
Okay.
his way.
All right. So we're going to hold off on calling his cases. Mr. Peck, is Mr. Peck here? In custody. Great. Mr. Gregory, have you dialed in? Are you in here in person? Not sure. Is Mr. Weidenauer going to be here? We were going to maybe have a Ferretta hearing for Mr. Peck. Okay. Ms. Beza has one of his cases, but the 2 that are going to move everything are his. All right, well, we'll hold off on that. Mr. Oliver, I don't think was brought over. There were some folks we asked not to have brought over because we had too many, I asked for too many people. And it was pretty clear to me that Mr. Oliver is a trial. Is that still the case, Ms. Patel?
Your Honor, I just haven't had a chance to pre-try with the state on that, so I'll definitely work towards doing that.
Okay. Did we bring Mr. Oliver over? Good. Okay. So that's currently one that I have it first out on the 14th for people's planning purposes. And again, it's not a surprise to you all. You should have received that email. Mr. Mitchell.
Kevin Lee Mitchell. Your Honor, I've been in communication with him. I expect him to be here. He might just be running late, and so I
Sure.
will reach out to him.
We'll hold for him, but he does need to be here. And have you received the discovery that you identified as missing?
I'm still receiving discovery.
Okay.
I received a set of photographs yesterday. Ms. Beza and I discussed just doing a side-by-side comparison to just make sure nothing else is left outstanding.
Okay, because I think I heard about the medical records being only a couple dozen pages and that had the same report. Did you get that?
Right, I received those. I
Okay.
received additional police reports.
Okay, and then the whole ID thing, is that what the photos were or the photos are something different?
I am not sure what photo was used. I don't have that yet.
Okay. All right. Well, hopefully he shows up. Ms. Carlin?
Morning, Judge Kevin Ryan for Hallie Carlin.
Oh, and she's with you. Fantastic.
Yes, sir, Your Honor.
All right. What we've done, Mr. Ryan, is put this case, meaning Ms. Carlin and Ms. Bonventura, Mr. Bonventura's case down for December 14th. It is number 2 out on December 14th. It is slightly younger than the Oliver case, so it comes in just behind that. So what that means for you and Ms. Harlan is that if Ms. Carlin, if this case is resolving short of trial, that'll need to happen before December 14th. And I don't know, Mr. Rao was keeping that case.
She is, Your Honor. I believe Ms. Harlan is going to be testifying with the witness of the trial. I know this
Before she resolves her case or after she resolves her case?
before she resolves.
Okay. So then the state would be seeking to sever the two and not have Ms. Carlin go to trial with Mr. Bonventura?
That's my understanding. That I think Mr. Rao had filed a motion for immunity as it pertains to Ms. Harlan, which would then allow her to testify in the trial.
Okay. Mr. Ryan, were you able to hear all that?
Yes, sir, Your Honor. That's our understanding as well.
Great. Is it- that's-
Post-trial the co-defendant.
Okay. But what Mr. Abate said is consistent with your understanding?
Yes, sir, Your Honor.
Okay. So what that means is that your client and you or a colleague need to be available that week of December 14th, should it come to pass that Ms. Carlin is called as a witness.
Yes, sir, Your Honor.
Okay. Mr. Bonventura, I don't believe was brought over, Mr. Franklin, for the same reason we didn't bring Mr. Oliver over. You can keep talking with Mr. Rao, but I'll assume that you'll be ready to go on behalf of Mr. Bonventura on the 14th. We don't need any interpreters from your side of things? Okay, I asked that before, I just wanted to confirm. Okay. Mr. Hinton?
Judge, may we be excused?
Yes, sir, Mr. Ryan, thank you.
Thank you, Judge.
So Mr. Hinton is here. We were asked to hold for Ms. Young's arrival.
My understanding is that this morning will be the negotiated plea to the indictment. Just so the court knows, I'm going to resolve 18 SC 162373, which is the global indictment, including the severed case, and including Your Honor's newest case for Ms. Hinton, which is Mr. Hinton, which is 21 SC 177772. Which is a jail-related case that has recently been transferred to you from Judge Leffert. So I'll close them all today, assuming that that happens. And I do have family members present. The court's ready, I'm ready.
Got it. So the calendar notes an open 21 CP. That's the SC case you just mentioned ending in 772. And your understanding from communications with Ms. Young is that everyone, you, Mr. Hinton, Ms. Young, have agreed on some recommendation that would resolve all the things you talked about.
That's my understanding. Yes.
Okay, well, let's hope Ms. Young gets here. Did you have an ETA for Ms. Young, Ms. Nelson?
No, she did not respond to that email. So she said she was stuck behind an accident.
Okay, thank you. Ms. Phillips has resolved her case. I don't know if Ms. Phillips is here. Doesn't need to be. All right. Glenn Goolsby, we reset. So hopefully Mr. Goolsby was not brought over. Good. And that's Primovic and Wood production now on the defense side. All right. Jamariel Thompson. Mr. Thompson here? All right, we will call that one more time when Mr. Webb gets here. If Mr. Thompson doesn't arrive, I assume, Ms. Hall, you want a bench warrant? Okay. Mr. Norris, did Mr. Norris get brought over? He did. All right. I think I saw Mr. Tolles on the call. You there, Mr. Tolles?
Morning, Judge.
Good morning, sir. How are you?
Doing great.
Good. So your client is here, and we can bring him out at the appropriate time. I learned that his formerly open CP case has become now a murder, meaning it's been indicted. You are on it. You, at least it filed an entry of appearance, and it has been transferred to me. And so when I asked Ms. Hall her thoughts about, well, which of these cases, the two different armed robbery cases that you have with Mr. Norris would we go forward on, she said none of the above. The murder case ought to catch up to in terms of you getting discovery, filing motions, I hear those motions, et cetera, rather than we do a trial on one of the armed robberies. Does that make sense to you, Mr. Tolles?
Yeah, it makes perfect sense, Judge, because it does, because I need to see what the whole picture is.
Yep. Okay. Do you want Mr. Norris to come on out to court so I can tell him what we're doing, or have you already broken that news to him?
It'd probably be best to tell him what we're doing. If
Okay.
we do it now. Yeah.
Okay, we'll do that. But that does mean for your planning purposes, you and Mr. Norris are off this trial calendar as we work through the early parts of the murder prosecution.
Thank you, sir.
All right, you're welcome. So sit tight. We'll get Mr. Norris out in a minute.
Thank you.
Jerry Hodges hopefully was not brought over. Good. That has been reset to the new year. Change in defense counsel. All right. 16 and 17 are co-defendants, Mr. Roberson and Ms. Marable. Hopefully Ms. Marable is here.
Yes, I'm here, Judge.
Good morning,
There
Your
she
Honor.
is. Excellent.
Michael Bernard on behalf of Ms. Marable. Also, John Melnick is stuck in traffic. He's also on the case as well. We believe that this case is a resolvable case as it regards Ms. Marable. And we'll work with, I believe, Mr. Abadi to see if we can't get that resolved.
Okay, couple things about it. One, I did put it on both the 30th, November 30th, and if it's not reached on the 30th, I rolled it to December 14th. So it is on the radar. It's at the very bottom, in part because Mr. Roberson, the co-defendant, his lawyer is working through some things that may make trial complicated for him. But we do need to keep the case on track. Mr. Bernard, you and Mr. Melnick are co-counsel?
Yes, Your Honor.
Okay. The other thing is I noticed you filed a motion to modify bond. Is that something you want to have heard today?
Yes, Judge, if we could. And it's just a small modification, but yeah, if we could hear that.
Okay.
Yes.
We will do that after we get through the calendar. Mr. Abate, have you seen the motion? I think it's about an ankle monitor, but have you seen the motion?
Yes, Your Honor.
Okay. You prepared to discuss it?
Yes, Your Honor.
Okay, great. We'll do that. So Ms. Marable, Mr. Bernard, you all stay on the call. And did we bring Roberson over? We did. Great. So we really need Mr. Webb. Thank you.
All right. Thank you, Judge.
You bet. Mr. Williams, position 18. He's here. Is Mr. Jacobs here? Nope. Ms. Nelson, could you check on Attorney Jacobs, please?
Yes, sir, I will.
Thank you. Mr. Abate, who from your shop is handling Mr. Williams's case now?
I am, Your Honor.
You are, okay. That I have as if Ms. Convery's case goes away today. First out on November 30th. Mr. Jacobs in the past, when this was Mr. Pinion's case, had indicated it might well work out. I don't know. I know you've been doing some other things. Have you and Mr. Jacobs connected on the case?
I have briefly spoken with his trial partner, Mr. Scott Smith, and the same sentiment was sent to me, that the likelihood it is that it would resolve.
Just not today.
Not today.
Okay. Well, we do need Mr. Jacobs here, and we'll talk more about that. Okay.
He's a friend of mine.
Great. Thank you, Mr. Majeski. Positions 19 and 20, Tolbert and Williams, should both be here in custody. Great. Mr. Webb represents Mr. Tolbert. Ms. Patel, you represent Ramel Williams, and that case is 3 levels down, back up on the 14th of December. That works for you?
Yes, Your Honor.
Okay. And as of today, you and Mr. Williams are still speaking?
We're still,
Speaking?
yes.
Okay.
Yes,
Good.
we are.
That's a good status. All right. Position 21 and 22 are co-defendants. That is Kimberly Henderson and Michael Reeves. Hopefully they're both here. Fantastic. Mr. Majeski, what is your announcement as to Ms. Henderson?
Well, my friend, Mr. Walker, started the dominoes falling here, so I expect a negotiated plan.
All right. Ms. Hall, this is your case. Are you ready for a plea with Ms. Henderson? All right. And Mr. Walker wanted to go first. That said to me that he's prepared to have Mr. Reeves enter a plea. Is that? No.
No, Judge, I wanted to go first on the calendar because I had set an appointment. I have a procedure this morning at 10 o'clock and I got to get there. I have to be driven there and driven back because I'll be up on anesthesia. So I can't do it today.
Okay.
He's a plea, but we can't do it today. I called Cassie this morning and told her I got this procedure I have to be, it got to be done today. Having a few issues, but I'm free after today.
Okay. All right. Well, we don't want to make you late for that. It sounds like you need to leave soon. Now I understand why you were saying make me first, not for the plea, but for your announcement.
Yeah, I have to be there at 10 o'clock.
Okay. Well, I doubt we'd get through the plea before you need to be driven to what you're going to have. I hope it goes well for you. But any other time we can find that you are free, you can take this plea.
Okay.
Is that correct?
It is a plea.
Is it a negotiated plea?
Yes, it is.
Okay. Mr. Majeski, could we still take Ms. Henderson's plea today? Or was the vision that both defendants would be in court at the same time taking the plea? Sometimes people want that. Sometimes they most definitely do not want that. They want separate pleas.
I mean, I hadn't considered that, and I mean, based on the posture of the case now, it's not going to change.
Okay. Well, I'm leaving it to Ms. Hall then. I don't mind taking Ms. Henderson's plea today because we've got everyone here and you don't have to come back. But if there is a strategic reason why one side or the other would want it to be everyone at once, I'll defer to that because we will need to talk about this case one more time when Mr. Walker's available. I'm fine doing it either way. Do you have a perspective, Ms. Hall? Okay. What's your preference, Mr. Majeski?
So those types of things like you described, this kind of gamesmanship or something like that, it hasn't happened in this case. So I don't see any reason not to take Ms. Henderson's plea to that.
Let's do it.
Okay.
All right. So we'll do that. That'll be one of the things we do this morning.
Just need to talk to her first to make sure.
Great. So we'll do Henderson today and we will, Mr. Walker, Ms. Nelson will get with you for a date to get Mr. Reeves to do his plea. Would he need to be here in person and would you want him here in person? Or just so I know.
In person.
Pardon?
Can you hear me?
Yes.
I apologize. I would want him there in person to do the plea as opposed to doing it on Zoom. And I want to be there in person myself.
Done.
Thank
All
you,
right.
Judge. May I be excused?
Yes, sir. Good luck with whatever's happening.
Thank you.
23 went away. LaShondra Boyd. Hopefully we did not bring Ms. Boyd over. Good. All right. That was continued into the new year. Devontae Dean.
Judge, that's mine. I believe it's on the 11:30 calendar.
It is. Yes, ma'am.
Judge, if you remember, I received that video last Friday. I did set up an appointment to be able to go out and go through that with him.
And you've got the authority to go do that.
Yes, Judge. I'm hoping to get that done next week.
The
And
video relates to, well, it relates to the bigger case. Okay. What is it? A surveillance video?
Yes, Judge, just a couple of surveillance. And I expect to get back with Ms. Hall after that visit.
Someone was happy with that answer. All right. Ms. Hall, have you had any conversations with Mr. Webb about Antonio Brown?
Yes, Your Honor. We spoke a couple times this week about him. He didn't confirm that it was a plea, but he was leaning toward that.
He was intimating it was a plea? All right, well, we need Mr. Webb. Hopefully he gets here. Ms. Wood, do you need to speak with Mr. Dean or yes, so we'll keep him here. Okay. Robert Fleming, hopefully is, yes, sir.
Hey, Judge.
Hold on, Mr. Pugh, 1 second.
Got a text back from Mr. Jacobs. He said he'll be appearing by 10:15.
Okay, in person or virtually?
It should be in McBurney by 10:15. I'll clarify.
Okay, thank you. Mr. Pugh is here. Mr. Fleming is up. Great. And my understanding, Mr. Pugh, is that this is a negotiated plea.
It is, Judge. I went and visited him at the jail, did the paperwork, and we emailed that up yesterday.
Yep.
So I'm at your pleasure.
Great. We will do it this morning. I've got the paperwork and your client is here. So that'll be one of the things we take care of this morning.
Judge, I have a couple of other virtual calendars. While you're calling this, may I log out and answer those calendars and come back? Is that acceptable?
It is, yeah. How long you think you'll be gone? Just so I can
I
put cases
shouldn't be
in.
very long. In fact, what I'll do, Judge, is I'll use my assistant's laptop and I'll just mute this, and if y'all need me, I can just jump back over.
Sounds good. Thank you, sir.
Thank you, Judge.
All right, position 30 is Antonio Collier. Ms. Wood.
That's gonna be a plea today, either negotiated or non-negotiated. Judge, I'll have a better answer in a little bit.
Okay, but a plea either way.
Yes, Judge.
All right, that is one of 3 defendants. Mr. Webb has the second one. And then I saw Mr. King somewhere, recognize the bow tie. I'm sure there are boots below it. Mr. King, good morning.
Yes, Judge, I do have my boots on today.
Good.
Good to see you. I just want to.
You have Mr. Slayton.
I have Mr. Slayton, Judge.
Yes.
And look, I got an offer and want to continue to have the conversation. Don't need to move it very far, but not ready right now.
Okay. So what we'll do, we will have the Collier plea today. I don't know what's happening with Robinson, TBD, when Mr. Webb gets here. You have time to speak with Mr. Slayton. I know you've been otherwise occupied for a while. I have this case as I have it on for the 8th. And the cases ahead of it look like they are all going away. And then if we don't reach it on the 8th, it's a backup on the 30th. What is your sense of how much time you need to speak with Mr. Slayton and then maybe have a back and forth? I think this is Ms. Convery's case.
Yes, Judge, I would ask that we not be called for the 8th. By the 30th, I would be ready for trial or ready to plead.
It's Mr. Parrish's case. That's right. He even nodded his head when Ms. Wood was saying, look, it's going to be a plea today.
I had a specially set murder on the 15th. So I'm, back into the grind. And, but the 30th, I would ask to put it on for them for plea or trial.
Okay. If it's a plea, we're going to do it hopefully before the 30th, just so we've got certainty as to how the 30th is shaking out. But let me hear from Mr. Parrish on this.
Judge, I agree with just about everything he said. I think the 30th is kind of that drop dead date that we're either going to be at trial at that date or we're not.
Okay.
This is one of those cases where I think dominoes need to fall in kind of a particular order.
Okay.
For everyone to agree to want to do something. So I think if we get 1 or 2 resolved today, putting that last case on the 30th or even 2 cases on the 30th, will give us time to negotiate that and call Ms. Nelson, put it on a calendar between now and then to feed out if we do something like that.
Certainly. Mr. King, if Mr. Slayton is going to be entering a plea, would you want him to be here in person?
Absolutely.
Okay. Just so we can plan. All right. Before you go, because I think this is your only case, Mr. Webb has made it. Good morning, Mr. Webb. You can stay seated while we're talking. I need you to get situated, but I do need to get your report on one of your cases now because he is a co-defendant with 2 of the other defendants here. Are you ready?
Sure.
Great. So Mr. Robinson, it's position 31. He's one of the 3 in the alleged jewelry store armed robbery. One of the defendants, Mr. Collier, will be entering a plea this morning. Mr. Slayton and his lawyer, Mr. King, are considering the state's offer. I need to know where you and Mr. Robinson fall in connection with the case because we'll reach it likely during this calendar.
I need the chance to speak with Mr. Robinson, Your Honor. I got an offer from the state yesterday at 2:45 p.m.
Okay.
And I did not, well, the day before yesterday, I did not have a chance to take it.
Got it. Well, Mr. Robinson is here, so you can chat with him. We'll take a break after I finish calling the calendar and we'll figure out, you and he can talk about that offer. All right. Anything else, Mr. Parrish?
No, Judge, I think that covers it.
So you're ready to go once Ms. Wood has gotten Mr. Collier ready to go, we can take that plea.
I do want to reach out to the victim. She did mention that she was going to potentially give me a impact statement.
Okay.
The conversation we just had via text was that it wasn't. I just want to verify that before we get too far in.
And there may be people on the Zoom call as well who are associated with it from
Correct.
the
And I
victim
think
side.
One of my victims is going to be watching via Zoom. I don't believe she wants to speak, but that's one of the things that I'd just like to reach out to her and dot the i's and cross the t's one last time.
Got it. All right. Mr. King, thank you for being here.
Thank you, Judge. Thank you,
Judge. Michael Miles. Ms. Wood, I saw you got news about the records you requested.
Yes, Judge, thank you.
So I'm sorry, keep going.
Oh, I was just gonna let the court know I do anticipate this being a trial on the 30th.
If reached.
Yes, Judge.
Great. All right. So I need to change that date. You're right. So 30 November. So you'll be ready to go. And I think I saw Siri Patel. There she is. Hello. Good morning.
Good morning.
I don't think you were able to join us. I think people spoke on your behalf when we had our discussion about the calendar. I have Mr. Miles down. I think that's your only case on here as a November 30th case. And based on what I'm hearing on some of these others, we could get to it. Is that a date that works for you?
Yes.
Okay. And it sounds like Ms. Wood now has everything. There was some stuff she was trying to get that you wouldn't have been providing, but that's been addressed. Okay, great. Do you need to speak with Mr. Miles?
No, Judge, he can come back.
All right, great. Adonis Hurd, hopefully he was not brought over. Mr. Harvey is on the call. Good morning, Mr. Harvey. Good
morning, Judge.
Ms. Beza shared with me that a continuance makes sense in this case because of some expert work that's going to be done on the stability or lack thereof of a gate that was not preventing people from falling to their ultimate demise in this case. Is that a fair summary?
Correct. It's a fair summary, and there's outstanding discovery related to that. that is ongoing and the case is definitely not ready for trial, and I join in that request.
Okay. What I'll do is enter an order that moves this to early 2022. That'll be the next round of trial calendars for here. It sounds like there's no objection from Mr. Harvey and Ms. Beza. I think that's consistent with what you were sharing with me strictly procedurally where we are with the case. Is that accurate?
That is
Yes, sir.
We're waiting on MARTA records if they exist.
Okay, got it. So the state's looking to get information from MARTA for itself, but also for Mr. Harvey, so that if there is an expert brought in, that person can see what is knowable about that situation. Okay.
That's correct. Thank you, Judge.
Mr. Hurd was not. Mr. Hurd was not brought over in anticipation of this, so you don't need to stick around, Mr. Harvey. You can let him know what your request was and that it was granted.
Yes, sir.
All right, thank you.
All right, bye-bye.
And finally, we've got Benjamin Brown, who should be in custody. You wouldn't know. You just walked in. That's okay. He's in custody. All right, Mr. Webb, I'm going to circle back with your other cases. You had indicated Benjamin Brown was a likely plea. He is on for a Monday trial. Do you have an update on Benjamin Brown?
I don't, Your Honor, I've been speaking with Ms. Hall, perhaps the state would like to.
Well, I'll ask Ms. Hall. Do you have an update for Mr. Webb on Benjamin Brown? That's the last position. Been in jail for a year and a half on 2 ag assaults.
So it's my understanding that Ms. Snyder didn't have the discovery in her file. So I just re-provided that to Mr. Webb this morning, so he probably haven't even had a chance to look at it. But beyond that, I think he's gonna speak with him and still, if he's able to communicate with him today and show him the videos and everything, we may still have a plea.
Okay.
But I'm not sure how his posture will be for a trial on Monday with him not having the discovery.
Got it. Is that a fair description that you opened the file and it was empty?
It is, Your Honor. And I did see Mr. Brown in jail the other night, and I thought the state's plea offer was very reasonable. The problem was that he indicated he had never been shown a copy of the indictment, he hadn't been given any of his discovery. And I promised, of course, I will do that for him.
Sure.
And I still will work with the state to try to resolve the case. I do feel like it could be good.
Mr. Brown is here, so if you would speak with him this morning and give me an update, that would be helpful. All right. Let me circle back, Mr. Webb, with your other cases. Lefty Hodge. Mr. Hodge is here as always. Good morning, Mr. Hodge. Do you have an update, Mr. Webb, on Mr. Hodge's case?
Yes, Your Honor. In reviewing the file in this case, I know the court granted a demur to one count of the indictment. And then in going through there, I noticed there was an outstanding demur as to the other count that the court had not ruled on. So I guess what I would need to ask the court to do is give us an indication of what the court's order would be on that before we would be able to proceed to trial.
Okay. It's a fair request. The way it had been left with your predecessor was, in light of that one ruling, do we need to wade through the second one, or is there a way to resolve this short of all that? Things were thrown for a little bit of a loop when Mr. Hodge's co-defendant passed away, and that sort of paused things, but I guess we're back. If you're saying right now there doesn't appear to be a path to resolution short of me ruling on it, then I need to rule on it. Mr. Abate, is this now your case? Maybe it always wasn't forever, but is this yours?
Yes, Your Honor.
Okay, I need to rule on the demur.
Yes, the impasse has been the request from the defense counsel has always been some sort of probation, and probation is not appropriate in this case.
Okay, got it. Then Mr. Hodge, I'm going to let you go in a minute. I need to enter an order on a motion that your lawyers filed a long time ago. So it's my turn to get to work on this. And then when I enter that order, Mr. Webb, seated over there, will reach out to you to let you know what the results were. If they're favorable to you, if they're good for you, it may well be you can sort this case out. If it's an order that makes Mr. Webb unhappy, then it sounds like it'll need to be a trial. And we need to make that happen. You have been on probation. Well, you've been on supervised release for a long time now. And I'm reminded of that every month by pretrial services because you are one of the longest serving pretrial services people in Fulton County. So continue to do what you're doing, which is stay out of trouble and follow the conditions of your bond. I will work on an order and that will get this case back onto a trial calendar, but it will come off of this trial calendar. Mr. Abate, anything else as to Mr. Hodges' case?
Just one thing, Judge, could we remind Mr. Hodge that he's had no contact with his other two children who are living with their aunt? It's been my understanding that there has been some contact where one of the daughters is climbing out the window at the behest of her father and they're leaving in the middle of the night.
How old ballpark are these kids?
9 and 13, somewhere.
Okay, so they are minors. They're not only his kids, but they're minors. Okay. So Mr. Hodge, we're not going to get into the middle of what happened or didn't happen, but if it's a condition of your bond that you are to have no contact with your other children, that means you can't call them, you can't write them, anything like that. And that may seem unfair, especially given how many years have passed, but that's a condition that the judge set. And you know, even better than I do, how serious this underlying case is and what happened to one of your children. So it's important that as much as you may love your other kids, that you stay separate from them until we resolve this matter. Does that make sense?
Yes, it does, Judge.
Okay.
It never was a bond condition for me.
Okay, well then, let's make sure. I don't mean to have you do something you're not supposed to do, but I'm surprised that Mr. Abate would bring it up if it wasn't a bond condition. So your bond you got so long ago, you may not even remember what the bond conditions are. I'm going to look right now. Assuming this case comes up in Odyssey.
Why did you have my stuff? Go sit down.
So you're on your original bond. Bless you. Wow. I think pretrial services wanted to come off. Right. This case has such a history. I'm sorry, Mr. Hodge. It's just hard to find the bond. I can't find the bond. Do you have a bond, Mr. Abate? this case is old enough, it doesn't, it just starts with the indictment, but it looks like bond happened before indictment.
I'm looking out to your honor. I was called by the aunt, she was watching the children, and I can't recall if it's the bond or if it's Child Protective Services who, the judge who oversaw that event had ordered not to see the children.
So there is a petition that a lawyer who was the attorney for the legal custodian of Mr. Hodges' two daughters. I'm not going to pronounce it well. Maiza and Tia. Maiza and Tiana. That says that until the cases are resolved, neither Ms. Hannah nor Mr. Hodge should have any contact with them. But that is a petition that an attorney filed, not a prosecutor. And I don't see that an order was ever entered on that. So what I'm going to do is say, for now, Mr. Hodge, you can continue to have contact with your daughters, but if it is brought to my attention that Judge Downs, who had your case for literally years, entered an order saying that you cannot, or if I get the original bond, I suspect the original bond did not say no contact because there were these petitions brought by this lawyer, and then the state even in, that's been 7 years ago.
Through this whole process, they've been trying to reunify me with my children.
Okay.
Especially since what happened to my son. My sister, she's been making it so difficult for me to be with my kids. My kids want to see me, and they've stretched out in every way to try to come and see me and to be for me to be a part of their life.
Okay. Well,
whenever they try to do that, the instant that she's even out the window, she escaped, and she comes to find me. I want to be with her dad. I want to be with my children.
okay. I hear you on that. So Mr. Abate, in 2014, August 11, Mr. Carlton, a former colleague of yours, filed a motion to have no contact with the kids be made a part of Mr. Hodges and Ms. Hannah's bonds. But I don't see that Judge Downs ever granted that motion. So as of now, I don't think it's a violation of Mr. Hodges' bond, but I am open to being shown where in the docket Judge Downs changed that. There were a few things relating to bond that occurred in 2017, but those all appear to relate to some bench warrants, and then the bench warrants were withdrawn. So you may want to file your own petition, and then we can have that conversation. I'm going to work on the demur. I should have done that long ago. There were hopes at one point that short of working on that, the case might resolve. So I want to be real clear, Mr. Hodge. I do not find that you have a bond condition that says you cannot be with either of those two young ladies. So if that happens, it's okay by me, but I'll let Mr. Webb, your lawyer, know if I am shown paperwork that says otherwise. And we'll make sure you get a copy of that so you can see it, because you may want Mr. Webb to challenge that if that is the condition of your bond. Okay? Mr. Abate, anything else on Mr. Hodges' case?
There was an order from October 31st, 2011, signed by Elizabeth Rogan, I believe, where it says stay away from and not be in custody of any children under the age of 16 years old. I think that's what.
Where, so that's not in this, was that when it was a CP matter or?
Yes.
Okay. If you could send that to me and Mr. Webb, please. You can take a seat, Mr. Hodge. Well, that's coming my way. Mr. Webb, so I want to get working on some of these pleas. Did you have any communication with Jerry Peck yet? You startled us all by claiming he was not in jail. He is in jail, and he's going to be there if you're ever looking for him.
startled by that too. I have not, I'll tell the court, I spent the last 2 nights looking for another client. The jail kept telling me he wasn't there.
Okay, well, Mr. Peck is here. He's going to come out anyway. We have to talk about him wanting to represent himself.
But I thought there might be a threat of hearing matter.
Okay.
I'd like to, if I could get some sense on that, I'll be glad to talk to him.
Okay. Let me just touch on your other cases so we know what's going on. Jamal Thompson, did he show up yet? There he is. Woo. All right. Glad you're here, sir. You two need to talk. Make sure you have each other's contact information. We're not going forward on Mr. Thompson's case because Mr. Norris, his co-defendant, has a new murder. And we are holding off to get that murder up to speed with the armed robberies. Okay? Mr. Thompson, once Mr. Webb says you can go, you're free to go, but please don't leave until you and Mr. Webb break bread, all right? Yes, ma'am. Yeah, have we taken care of your cases?
Yeah, except for the pet battery and eating my husband.
Right. Okay. Yes, ma'am. Thank you. Mr. Webb, Mr. Roberson is here in custody. Any update on that case?
I don't think Mr. Goldberg is here, Your Honor.
Mr. Bernard is online. Mr. Melnick will either be online but they represent.
Mr. Melnick was on. He just had to go answer to another calendar, but I am here still.
Great. So Mr. Bernard is on. The 2 lawyers for Ms. Marable. His perspective, Mr. Bernard's, was that maybe Ms. Marable's case can work out. Ms. Marable is online. They have a bond motion that they want to talk about. I wanted your update on the co-defendant, Mr. Roberson.
Well, I still feel like he had a strong defense, Your Honor. I think we talked to the Constant last week about a push for him because he's been in for so long.
Okay.
I didn't realize Ms. Marable's case may work out. If it works out, then that may affect.
I'm not saying it's going to, it just, there was a sentiment that it may be something that results not in a trial.
Okay.
So that may help focus Mr. Roberson. I don't know. And I don't think that's necessarily happening today. I think today we're just talking about the bond motion. Anthony Tolbert.
I can't say to the court right now that case is going to work out. In my opinion, it should work out, but I'm going to have further discussions.
All right, well, he's here if you need to chat with him. I've put that down for the December 14th calendar. It's a little ways down. I don't know that we'll get to it, but he and Mr. Williams are definitely due for a trial. LaShondra Boyd, we continued to the new year. Antonio Brown, you explained you want to talk to him some more.
That's true. I did see him the other night. I'm not sure what his position is today. Yeah, I think that case is resolved.
Well, you need to figure out what his position is today, because that's one that is also lined up for a trial on the 30th. So please do talk to him. Ms. Wood has the co-defendant, Mr. Dean. She's in discussions with him. All right, I think that's it. Let me look at Mr. Hodges' bond situation. How old are your children now, Mr. Hodge?
Maiza, she just turned 10, and Mendiza, she just turned 14.
Okay. Judge Villa-Rogan signed a bond in your case on Halloween 2011, so 10 years ago and a few days. And it indicated that you are to stay away from and not be a custodian of any children under 16. So that's the original bond in your case. There, it's what you are out on now. And so that condition still applies. You may want to have Mr. Webb file a motion to modify that condition, and then we can have a conversation about whether I ought to relax it or not. But another judge who heard a whole lot more about the situation, granted that was much closer in time to the facts and circumstances that led to you being arrested. But that judge said, stay away from and not be a custodian of children under 16. Okay?
What judge is that? I never met that judge. Never heard anything about a situation where I can see my children.
So this looks like it has your signature on it even. So, okay, will you write down the CP number so you can look it up? Because it's not in the, did you find it in the 13 SC case, or you looked up by name and?
I found it in the 11 SC case. It had been re-indicted.
Oh, so there's an older indictment.
Yes, 11 SC 106430.
I'm sorry, could you repeat that, please?
11 SC 106430.
Oh, well, I had that. I thought you said it was a CP.
It was this bond was for, I was asking Mr. Abate, where did he find this bond? I couldn't find it in the 13 SC case. And he said, that's because that was a superseding indictment. The original indictment, which you wrote down, will have this in it. You also have emailed to you a copy of the bond that Mr. Hodge signed on Halloween 2011. It says you may not be around or have custody of children under 16.
I expect you may want to review that, Your Honor. I've never run across that question before, but the bond order, a 10-year-old bond order in a previously indicted case. I'm not challenging the court's authority, of course, but
I mean, until the case is resolved, the bond is in effect. If you want there to be no bond, we can do that. I think Mr. Hodge would like that less than the current bond. So, Mr. Hodge, you and Mr. Webb should talk about this. And if it sounds like you've got some pretty strong feelings about it, you can ask him to do what you want to do with that, and we'll see what happens. Okay? You understand?
I do.
Good. All right. Thank you for being here. You are free to go after Mr. Webb says he got from you the info he needs. Okay? Thank you. All right. So is there anyone here whose case I didn't call? We got a lot of folks in the courtroom. Nope. Okay.
Your Honor, Gregory Oliver's family's here. They missed a call the calendar. If Your Honor could just explain that he was not brought over and that was not my request.
Sure. So I don't know who's here on behalf of Mr. Oliver. His case is set to go to trial on December 14th. It's first out. So it will be a trial on December 14th if it is not otherwise resolved. Because it's a trial on the 14th, because we have limited space in our holding cells because of COVID, there were certain defendants I did not bring over because there was nothing to say to them other than, yep, you're getting your trial date. So Ms. Patel will be in touch with Mr. Oliver. She's been spending time with him. She's ready to go. And his case, if not otherwise resolved, will be what we try by picking a jury on December 14th. So I'm sorry if there was any confusion. No one's trying to ignore the case. We just didn't need to. There are about 6 or 7 defendants we didn't bring over because the answer is yes, you're going to have a trial. Okay? Thank you. Mr. Majeski.
An update on Mr. Jacobs. He has had a conflict in Fayette County. He'll be appearing virtually.
Great. Well, we'll hear from him then.
Judge, you mind if I come around to grab that paperwork?
I don't mind. Why don't we take a little bit of a break? At around 10, we're going to have some visitors coming in to watch what goes on in a courtroom handling criminal matters. And some of them may sit in the jury box, some will sit in the gallery. If we've already talked about your case, you're free to go now. Mr. Hodge, you need to talk with Mr. Webb. But otherwise, you're free to go. Just know that there'll be some other people coming in a little bit. So if I am to make a list of things to do this morning, we've got a plea on Henderson. We've got a plea on Fleming. We've got bond on Marable. We've got a plea. Ms. Wood, you had another one from the jewelry store situation. Was that Collier?
She's not in here, Judge, but that is her client.
Collier, right.
She announced it would either be a non-negotiated or.
Right, but plea either way. Okay. And Hinton, is Ms. Young here?
No, but I saw her last, was that she great again.
Okay. I am open to taking those pleas in any order. So if you want to, we'll spend about 5 minutes just getting organized and people can tell me the order in which they want to do it. And we'll just keep pressing on.
Judge McBurney, on Amarius Norris, if you don't have time to bring him out, I can just go see him at the jail.
Oh, I forgot about that. No, why don't we just have them come to the door right now and then they can take Norris down as well. So I'm sorry, we'll definitely do that. 23, let's see what I wrote. It's a long calendar. Oh, his case has been null pros. Why would Javante Avery still be in jail? Oh, he has a new indictment. New indictment. So he's here. He can go. He can go. Oh, Mr. Avery's family is here. Who's here for Mr. Avery? Hey, how are you? So remind me the re-indictment. Is it a re-indictment?
Yes, Your Honor. It was a re-indictment to add co-defendant. It was assigned to
Judge Carnesale. All right. So Mr. Avery's case has been re-indicted to add a co-defendant. Do you have that case number, Ms. Hall?
Yes.
I'm gonna finish talking to you. Hold on.
I'm sorry, Judge Krause's court. And the case number is 21 SC 177552.
So folks who are here for Mr. Avery, he has a co-defendant in the armed robbery and carjacking. The case was re-indicted to add that co-defendant, so they moved together. Hold on one sec. And it was assigned to Judge Krause, who's a colleague of mine. And I can give you the case number if you want, but tell me what your question is. Well, I'm confused too. But let me look the case up and I'll tell you. So it was re-indicted in April. And it adds a Deshaun Garrison. So that's the case. Well, the first indictment. Hold on one sec. The first indictment was just Mr. Avery. So the old one from 2019, just Mr. Avery. The new one, Avery and the other gentleman.
Confusion may be that we always knew who the co-defendant was, but we went through the pandemic, so we were not able to indict the co-defendant when we indicted Mr. Avery.
That explains why. Okay. And it was transferred to Judge Krause in April. It's moved along. There's a new lawyer for Mr. Avery, Jonathan Oden. He is a conflict defender. So no.
He's moved to appeals, that is my understanding.
Okay.
A new lawyer.
But again, this is all in Judge Krause's courtroom. Okay, thank you. All right, Mr. Norris. How you doing? I'm doing all right. So Mr. Tolles is on this call right now. Can you rotate the monitor, Ms. Patel? Can you rotate the monitor just so Mr. Norris can see it? And that way he can see Mr. Tolles, and we'll put the spotlight on Mr. Tolles. There he is. So there's your lawyer. Mr. Norris, you have a new case. It was unindicted for a while, and you and I talked about that before. It's now been indicted. It's a murder charge. And what Mr. Tolles has very reasonably asked for is, hey, could we get all the discovery to him and to you about the murder case that's more serious than the other charges, so that Mr. Tolles and you can understand what does the landscape look like for you. You've got one armed robbery case with a co-defendant. You've got a attempted armed robbery case, just you, and now this murder case. And Mr. Tolles is asking that we get all those together so you can decide, going to be a trial, is it going to be a plea, or what? If it's going to be a trial, we would likely try the murder case first. It's all the same prosecutor, Ms. Hall, for now. That means we're taking off the trial calendar your 2 armed robberies so that this murder can catch up with it. Mr. Tolles already knew that, but he asked that I bring you out just so you could hear it from me. That's why we won't be trying your armed robbery next week or the week after. Okay? Mr. Tolles, you'll be in touch with Mr. Norris soon?
Yes, I will.
Great. There's our plan. You bet. We'll see you soon.
Judge, that concludes my business. May I be excused?
Yes, sir. Thanks for hanging on.
Thank you, Judge. Good to see you.
All right. We'll take a 5-minute break, and then when I come back out, let's figure out the order in which you want to handle these things. Okay? Thank you so much. Oh, and we need to get Mr. Peck out for, we're not doing it right away, Mr. Webb, but don't disappear on us.
Judge?
Sir?
I think that Ms. Marable's issue probably won't take more than 5 minutes to discuss. If we could handle that maybe when you get back.
Sure, we'll do that first. Mr. Abate, Mr. Bernard was hoping you could reach out to him to talk about the Marable thing. He's going to reach out to you right now.
I'll put my number in the chat.
Okay.
I'll let the judge know.
Yeah, like I said, step by step.
Well, I don't know. But it won't show. It's Nelson.
Yeah.
Can you text Adam, or can you text me that number that's in the chat so we can see it?
And I'll give it to Mr.
Oh, that's what we're saying.
Yeah, I just thought that was like.
Thank you, Ms. Nelson.
Oh.
Oh, you want me to be around? That's my stuff, like, I anticipated. I'm just getting stuff.
Yeah, so maybe.
Right, that's in the yellow folder.
Hey. Oh, sorry. Thought you said my name.
Well, I have to work really hard for 2 straight years.
Prep all this to get everything lined up. Right?
I will really.
Well,
If I don't, I'm gonna deal with your case. I'm gonna get this one.
okay, I appreciate
It's
that.
a part of the. Don't let it fall into my situation.
Yeah, she actually is.
Because she is a.
She is a good player.
She's a good
And somebody that's, you know, that's from maybe in high school or the city. That's what I heard. But I'll let you know, talk to you make that decision. Given that the person like this case already always mess up for this perhaps. So one there's an idea that she already. People.
So we're gonna still get her.
Right.
Yeah, we don't-
Just hold the job.
But we're not gonna get it out there.
They got to have it. Really get out.
Yeah, I think I'm gonna do it. Don't let the faculty too. That's one which is really generic. We're not. There's another one where. I think I'm going to generic. I'm gonna go. Y'all gonna kill me. I said, when I go upstairs, they're gonna like, really can't, I said, look at the case. But it's right on my. Just so I know. I have to. This is the
You have a seat?
I have a serial So Judge, I apologize for being late today. I decided that your calendar was at 9.
It was at 9. We got by without you for a little bit. Your colleagues do a good job of grabbing the phone, like, we'll get him here in a minute. How are you, sir?
Yeah, so we got a lot of trade.
Okay. Are they gonna fit?
Yeah.
Well, they're here.
Yeah, they're here.
Okay. I thought it was 10:20. Okay.
I think state's recommended. So
Yeah, so let me see what Eric sent, because I want to keep you guys on schedule. He's okay. He said 10:20 to 11:30, so about an hour. We do business. And then 11:30, we stop for a half hour of discussion. And I've warned the lawyers involved that if you did something, you may need to stick around so that they can ask you about it. Good. You bet. Happy to. Same. Ms. Convery or Mr. Parrish, which case? We've got an officer who's here. Hinton? Okay, I'm just trying to get people on their way if we can. Okay, great. Then he can observe. All right. My thought is that we have the brief bond discussion and the Marable matter. If Mr. Abate is able to do that, because it sounds like that would be brief. And then we will start with some pleas. Other input?
I have a question, Judge, but I was wondering if we wanted to take up the arraignment on Jerry Tack and for another matter on but I'm here at
He needs to be arraigned on a case on the trial calendar?
well, there's a 17 SC case, on battery. I re-indicted that case last week as part of influencing witness.
Right, you mentioned.
Arraigned on that unless you would wait.
Okay, then let's do the bond motion, and then why don't we get Mr. Peck out briefly, just to take his pulse. If he decides that he wants to continue with Mr. Webb, that's great. If he wants to represent himself, that's a slightly longer conversation. Maybe we'll do it now, or that may be something that we take a couple pleas first. Okay, but let's do the bond matter first. So let's move pleas to position 17. That's Ms. Marable. And let's see, we're getting some feedback on Zoom. Nope, we're all good. All right, Mr. Bernard, tell me, I've got the bond motion here, paperwork. Why don't you put on the record your request? I'll hear from Mr. Abate and we'll go from there.
Yes, Judge. Good morning. We are here on behalf of Mrs. Marable regarding her ankle monitor. She was placed on that ankle monitor back in November of last year. There have been no issues with her since she's been on the ankle monitor. However, the cost of this monitor has been extremely restrictive for her. And so we are requesting that the bond be slightly changed to allow her not to have to wear the GPS ankle monitor now.
Is Ms. Marable working now?
She is working, Judge. Ms. Marable, where are you working?
At the security company in Duluth. But I travel to different locations.
Does the ankle monitor in any way limit your ability to do the work you do?
Not really, but it's the cost of it that's really like a lot.
What is the cost?
It's $300 a month.
And what are you earning with the security work?
$12 an hour.
How long have you been doing the security work?
It's like off and on. It's like whenever they call me.
But to try to quantify that, does that mean you work in 4 days a week, 4 days a month?
Probably like 2 days out the week on the weekends, and that's when they call me. So probably like 4 days out the month. And then I was trying to get another job, but I don't want to be at the job with an ankle monitor on.
What kind of job is that?
It's a grocery store job.
Okay. And you've been on bond now for about a year?
And I've been on bond since October the 1st of last year. So it's been a year.
Okay. Mr. Abate, it sounds like Ms. Marable has complied with all the conditions of her bond now for over a year. I understand the request. It sounds like it's more financially driven than I'm not able to live the lifestyle I want to live. What are your thoughts about amending the bond only to the extent that the ankle monitor comes off?
Judge, I don't have a huge reason not to agree with it, to be perfectly honest with the court. I would leave it in the court's discretion. I would bring to the court's attention that through Ms. Shea Alexander, we are able to convert her monitor to where the county would pay for it. That way, we could change. That would be an additional way to maybe, or another option to amend her bond in order to remain where she could be tracked, since she is on a bond for a pretty serious case. And it sounds as if too, with Mr. Bernard's announcement, his previous discussions with Mr. Pinion and probably Mr. Rao, who else was before me on this case, that Ms. Merrill will be probably a witness that will testify within the trial of the case when it goes. So that would be just my suggestion.
Okay. What is the process for getting the ankle monitor? Would it remain the same physical device, or whatever device Ms. Marable has now is turned in and then she gets a new county issued one?
I think the device will remain the same. It's my understanding. It's just the billing is what's changed. I can call Ms. Alexander as soon as I get out of here and find out from her.
Okay.
It's the same company as A&A, all county monitored. So I believe they can just switch the biller to Fulton County versus Ms. Marable, but I will find out for her.
Okay. Ms. Marable, tell me, you were thinking about switching jobs, but you didn't want your ankle monitor for that. Explain.
Because it's very, very big and people can see it, and it's like they don't really want to hire me with this big ankle monitor on my leg.
It's not a sleek little like piece of ankle jewelry.
No, I could show it to you. It's big.
No, I know what they look like. It's like having well, it's not like an Apple Watch around your ankle. It's a big old box.
It's like a microwave.
A microwave. Wow, that is. Maybe you got the extra large version, and we could get you the smaller version. Okay. Mr. Bernard, what's your thought about what you heard from Mr. Abate?
Judge, we still stand by the removal. Again, even given Mr. Abate's comments and mine in terms of the way, as it relates to Ms. Marable's case, the way that will work out, we would just ask that it be removed. But we understand that it's essentially a financial reason why. And if Your Honor feels more comfortable going that route, then that'll be fine with us. But we would ask that it be removed.
Okay. Ms. Marable, have you been in the same residence during this year you've been on bond?
No, but I had contacted the ankle monitor company and gave them my new address. They have it on file.
Okay. And in your household now, is it only you, or are there other people who stay with you?
My 2 sons, my 2 nieces, and my sister.
Okay. And your sons are how old?
16 and 12.
Okay. All right. So Mr. Bernard, I think given a year under our belt of Ms. Marable being where she needs to be and being available, and the connections that she's got to our community, I'm comfortable removing the ankle monitor. no need to keep that microwave on the ankle, in particular if it will help Ms. Marable pivot to a job that is more full-time and allows her to better provide for her household. I'm going to look to you, Mr. Bernard, to submit a proposed order in Word format to Ms. Nelson that would modify the bond, keeping all the other conditions in place.
All right, I will, Judge. We'll get that to you today.
All right, sounds like a plan.
Thank you, Judge. I think that concludes my business. May Ms. Marable and I be excused.
You may, thank you.
All right, thank you,
Thank
Judge.
you.
Good seeing you.
All right. I would like to take the Collier plea next. Is that one we're ready for, or would that be a problem?
Judge, he signed up. I need to tell him something real quick before he walks out. But
Okay.
it's ready to go.
We don't have Mr. Parrish, though. Did he go far away? No? That'd be great.
Yeah, right there. Yes. Thank you.
No, Mr. Parrish.
No, Mr. Parrish. Well, phooey.
He's gonna be close.
Great. We'll do that. Ms. Young, it's good to see you. Thank you for being here. I hope you got here safely.
Yes, sir. I'm sorry. It's been over 2 hours to get here. I apologize.
We have been able to do lots of other business. Ms. Convery tells me that Mr. Hinton is going to be a sort of global mega plea dealing with the case you and I are familiar with, plus the new indicted case that flows from some incident at the jail.
Your Honor, I don't represent you on that. That's what we're talking about. I have no objection standing in if family doesn't need to hire me. If the court's okay with that, I believe that there's either a C3 or private counsel on that case. So I don't want to step on toes. But if the court's comfortable with that.
If you and he are comfortable with it, I am, but let me look up the case. There's Mr. Parrish. We're going to do Mr. Collier first, if that's okay, Mr. Parrish. All right, I've got the new case number. Xavier Head is a co-defendant. It's assigned to Judge Leffridge, but we're gonna, oh, you said it had been, it. Of course.
I didn't click on it, so maybe it was, I don't know, I was just wanting to keep it, but I don't think.
Nope, there it is. Well, but it's interesting. It's the order of transfer. Judge Cox transferred it to Judge Leffridge. Not sure.
Maybe one of the, well, I know head office is here. And it's not their code.
Mr. Hinton, we would think would have, well, yeah, there are let me go back to the indictment. Head, Hill, Hinton, so the H's, and Jones. Are they like housed alphabetically?
Okay, so maybe you can just.
Yeah, we could take the plea. I am confident Judge Leffridge's people would say it's fine to take the plea as to Hinton. I'm not taking the case.
I was suggesting that because I want to be for you. So if it's another courtroom, my recommendation for what of course is going to need to run it concurrently with this sentence I'm already recommending.
Okay.
So I'm happy to do that in Lethbridge at a later time as well. Especially if it's more comfortable with that. I was just trying to use that.
Yeah, it's probably cleaner to just leave that with Judge Leffridge. Attorney for Mr. Hinton is Crail Lewis, who I think is that's C3 now.
Which I had previously spoken with Mr. Lewis a while back. So he was aware that there was a case here.
Okay.
And I'm certainly happy to come back if the board turns out that that's necessary.
Well, let's tackle the big one today. That's the important one. That's the one on the calendar. That's the one with the charges that move the needle a whole lot more than the case that Mr. Hinton has with Mr. Head. Great.
So we're ready on that.
Fantastic. Is Mr. Collier ready?
Ready, Judge.
Great. If we could bring him out and tell me where you all want the defendants to sit today. We've got this funny L shape that we don't need anymore. Oh, that's right. They'll be at the podium for a plea. Great. Ms. Nelson, do we have anyone from probation on the call?
Let me check with Ms. Crawford.
Great. Because I thought we had Ms. Crawford through the end of the week before.
Yes, let me reach out to her.
Okay, thank you. Are you ready to go?
Ready, Judge.
Parrish? Ms. Wood, you ready?
Ready, Judge.
All right, Ms. Rivers, we good? Okay, this is. One second.
I'm gonna ask you questions and we'll just follow.
Position 30 on our trial calendar is State versus Antonio Collier, 20 SC 175651. Good morning, Mr. Collier.
Good morning.
Good to see you again. Mr. Collier, Ms. Wood tells me that you are prepared to enter a plea in your case. Is that correct?
Yes, sir.
All right. We're going to go forward in just a second. Mr. Parrish is going to put you under oath. Once you're under oath, it's important that you answer his questions and mine, and we'll both have some questions for you, that you answer those questions truthfully and completely. Will you do that?
Yes, sir.
Okay. Number two, it's important that if you have any questions, if we talk about something that you don't understand, or it's different from what you and Ms. Wood have been talking about, it's important that you let me or Ms. Wood know that you're confused about something. Will you do that?
Yes, sir.
Last thing, you're going to need to speak up a little. We'll move the microphone up. You're tall, but it's important that Ms. Rivers, the court reporter, be able to hear you. Okay?
Yes, sir.
Great. Good job. Mr. Parrish?
Thank you, Judge. As you said, we are here on 20 SC 175651, State of Georgia versus Antonio Collier. Count one is going to be armed robbery. Counts 2, 3, and 4 are aggravated assault with a deadly weapon. Count 5 is possession of a firearm during the commission of a felony. Count 6 is possession of tools for the commission of a felony. Count 7, terroristic threats. 8 is going to be criminal damage to property in the second. Count 9 is willful obstruction of a law enforcement officer. That's the misdemeanor version of that charge. And finally, the last count is possession of a firearm by a convicted felon. State's recommendation in this case, Judge, 35 years total. The first 25 of that to be served in confinement, the remaining 10 years to be served on probation. He is to have no contact with any of the named victims, and he is to remain away from the incident location.
Which is a jewelry store.
It is a jewelry store, Judge, and I'll put that address on the list.
Sure. All right.
Judge, State's case would show that at approximately 4:30 on January 25th of 2020, at 6631 Roswell Road in Sandy Springs, Georgia. 3 defendants walked into the Alex Jewelry Store. Defendant Slayton pointed a BB gun that looked like a handgun at one of the victims, Brendan Gorta.
Can you spell the last name, please?
I'm going to, Judge.
Okay.
Gorta. He was a customer at the store at that point. Robert Gale, Gayle, who was also a customer. In Esfira Abramova, that's Esfira, last name Abramova, the store owner. Defendant Collier pointed a real handgun at the victims. And the final co-defendant, Mr. Robinson, was armed with a hammer. He smashed the jewelry cases, put watches and jewelry into a bag. The 3 accused then attempted to flee the store. As they were going out the front door, a witness, the store co-owner, Arkady Yakubova, that's Arkady, last name Yakubova, UBOVA, struck Mr. Slayton in the head with a bag full of heavy bottles, more specifically, a Publix bag filled with pickle jar,
An actual pickle
an
jar.
actual pickle jar, Judge. That's my understanding.
Okay. And he hit Mr. Slayton, the guy with the BB gun.
Yes.
Okay.
The witnesses then held Slayton until police arrived on scene and arrested him. While detained on the scene, the accused, Mr. Slayton, continued to threaten witness Yabukova, stating that we're Bloods. I'm going to come and have my people come back here and get you all. Co-defendants Collier and Robinson fled in a car driven by an unknown person, but that was immediately chased by law enforcement who were near the scene, saw the report of the car leaving the scene and gave chase. The car crashed a short distance away. The accused fled, Officer O'Donnell on foot, but they were apprehended a short distance away. And that is the foundation for the case, Judge. The criminal
The
history.
driver apparently got away
Yes.
because we have 3 defendants now.
That is correct.
Okay. All right.
Judge, the criminal history for this defendant, we have 3 felony convictions. We have a robbery out of Fulton County in January of 1996. We have a burglary out of Cobb County in September of 1997. And we have a robbery out of DeKalb in July of 2008.
You said a robbery, the last one out of DeKalb.
Yep, a robbery in Fulton, a burglary in Cobb, and then a robbery in DeKalb.
Okay.
Sir, can you raise your right hand for me? You swear or affirm that the testimony you shall give the court without an outstanding shall be the truth, the whole truth, and nothing but the truth, so help you God.
Sir, yes, sir.
Go ahead and set your hand down. Make sure you speak up nice and loud for the court reporters. You've got to take down everything you say, okay?
Okay.
You go ahead and state your true, correct, and legal name for the record.
Antonio Kari,
How old are you?
43,
And what's your date of birth?
5/27/78.
Are you now under the influence of any drugs, medicine, or alcohol?
No, sir.
How far did you go in school?
10th grade.
Are you able to read and write the English language?
Sir, yes, sir.
Have you read and examined the charging document in your case?
Sir, yes, sir.
Did you go over it with your lawyer?
Sir, yes, sir.
You understand fully what you're charged with here today?
Sir, yes, sir.
You understand that you have the right to plead either guilty or not guilty to these charges. And if you choose to plead not guilty or remain silent, the state will be required to try you on these charges before a jury.
Sir, yes, sir.
Have you reviewed the waiver of rights form with your attorney?
Sir, yes, sir.
Have you signed that waiver of rights form today?
Sir, yes, sir.
Have you had enough time to speak with your lawyer about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Sir, yes, sir.
Do you need any additional time to talk to your lawyer before continuing with this plea?
No, sir.
Are you satisfied with the services of your lawyer?
Sir, yes, sir.
Ms. Wood, do you waive a formal reading of the indictment?
So waived.
And do you waive any and all defects in the indictment, including any with respect to the name of the defendant?
So waived.
Has your attorney advised you of the minimum and maximum sentences for each charge you're pleading to?
Sir, yes, sir.
You understand you're entering a blind plea or a non-negotiated plea. The state does make a recommendation to the court.
Sir, yes, sir.
Are you aware of the state's recommendation in this case?
Sir, yes, sir.
I just said it a moment ago, you're aware that we're asking for 35 years total, first 25 years in confinement.
Sir, yes, sir.
You understand the court can impose any sentence authorized by law, including a higher sentence than the one recommended by the state, up to the maximum sentence on each charge.
Sir, yes, sir.
You understand that if you enter a non-negotiated plea, you do not have a right to withdraw your plea once the sentence has been announced.
Sir, yes, sir.
You understand that this is a guilty plea, which is permanently recorded on your criminal history.
Sir, yes, sir.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts.
Sir, yes, sir.
Are you currently on probation or parole for any other offense?
No, sir.
You understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special condition of probation without being subject to revocation for the balance of your sentence.
Sir, yes, sir.
You understand that you are not allowed to possess a firearm while on probation.
Sir, yes, sir.
Are you a United States citizen?
Sir, yes, sir.
You understand that you have the right to, You understand that there may be other adverse or unfavorable consequences as a result of this guilty plea, just as there would be from a conviction following a trial. For example, your guilty plea may affect your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Sir, yes, sir.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a separate felony, which may carry a sentence of 1 to 15 years in prison.
Sir, yes, sir.
You understand that you're waiving any and all defenses, including anti-mental health defenses, by entering a plea of guilty.
Sir, yes, sir.
You understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify yourself or to remain silent and not incriminate yourself.
Sir, yes, sir.
You understand that by pleading guilty, you're giving up the following rights: the right to have a jury trial, the right to remain silent and not incriminate yourself, the right to confront the witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges at trial.
Sir, yes, sir.
Has anyone used any force, threats, or promises to get you to enter a guilty plea here today?
No, sir.
How do you plead to the charges in this indictment?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Sir, yes, sir.
You understand that you may only have a limited right to appeal this guilty plea conviction.
Sir, yes, sir.
You understand that you have 30 days to file a motion of appeal for this case.
Sir, yes, sir.
You understand that that if you wish to file a motion to withdraw your plea, you must do so during this term of court.
Sir, yes, sir.
You understand that you have 4 years from today for any felony charge and 12 months from today for any misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea.
Sir, yes, sir.
I believe that's all. The one thing I would like to state, Judge, I did speak to the victims on this case. Some of them are on the Zoom. They all expressed that they are still suffering mental anguish. Some of the individuals who held down one of the co-defendants in this case are still suffering some physical damage as well. They do understand the state's recommendation. They're on board with what we're recommending for all 3 of the defendants. They think that they are their recommendations. They would just ask the court to follow what the state recommends.
So we've got what we'll call customer victims, people who were in the jewelry store, and then the owner with the pickle jar, and then the female you mentioned, was that an employee of the jewelry store or a co-owner? Okay, so 2 owners, 2 customers.
Yes.
Got it. All right. And you are sharing with me their thoughts and sentiments. They don't want to add anything more at this time.
No, Judge, I spoke to them all about the potential of giving a verbal statement here in court or a written statement that they wanted to read. They just wanted me to convey their thoughts and feelings about it, that they're trying to put it in the past, but that it does still weigh on them all every day.
Got it. I can understand that. Ms. Nelson, did we end up getting anyone from probation on with us?
No, Judge, I have not been able to locate someone. I'm going to have to reach out to Mr. Smith.
Okay, thank you. Ms. Wood, I want to hear from you on any topic you want to cover. If you would start with whether you're aware if any of Mr. Collier's older convictions are still open. I suspect the ones from the 90s are long since closed. The 08 in theory could still be something that's on probation. I just want to make sure we don't have a surprise for Mr. Collier. And we're working on getting someone from probation on here, but maybe you know too.
Judge, it's my understanding that he doesn't have any open probation issues, but yes, I would like to confirm that.
Okay. All right. Please tell me about Mr. Collier and your perspective on the case.
Thank you, Judge. First and foremost, I inherited Mr. Collier's case about 3 months ago. And I think it's important for the court to know that day one from speaking with Mr. Collier, he has been upfront, honest, ready to accept responsibility, forthcoming, and not trying to dodge anything. So I wanted to let the court know that. Mr. Collier is 43 years old, Judge. He grew up here in Atlanta. He's the oldest of 3 children. He has 2 younger sisters, one who is present today. Ms. Vanika is here in support of her brother. Judge, he grew up in a household with a single mom. His mom actually had cancer when he was a child. So in the words of his younger sister, Kenyatta, who was unable to come today, Mr. Collier did have to grow up real fast, a lot of circumstances that he had to deal with that not all of us have to deal with. So I just wanted to let the court know that much. Judge, his mother recently passed away October the 14th of this year. So he is also still dealing with that. He has one son, a 21-year-old son. He has a 10th grade education. He does not have his GED yet, Judge, but he is planning on working towards that. He has previously worked in the restaurant industry in the past. And Judge, we are here today asking the court to take into consideration that he is willing to accept responsibility. He's been in custody since January 27th, 2020, roughly 647 days on this charge thus far. He has no issue with a no contact order, a stay away from the location. He's completely understanding of those provisions. We are asking the court to consider sentencing Mr. Collier to a total of 25 years, with the first 15 years to be served in custody. It's Mr. Collier's hope that by the time he is released at around the age of 60, he would have a life ahead of him. We do anticipate that he will get that GED while in prison. We hope that he will be able to enroll in some classes and perhaps even learn a trade while he's there. Like I said, Judge, he's been willing to accept responsibility since I came on board. And we just asked the court to consider the 25 serve 15 in this case.
Okay, thank you for sharing that. Mr. Collier, you have an opportunity to say something if you want to. You have a right to say anything you want because this is your plea and sentencing, but you don't have to say anything if your lawyer has said things for you. Before I ask you that question though, Ms. Wood, did Mr. Collier's sister want to say anything, or she's here showing support but doesn't want to add anything?
I think she was here just to show support. I did speak to her and the other sister at length. They just expressed he did grow up in a hard situation. Also, perhaps was unable to seek all of the mental health treatment that he should have sought at certain times throughout his life. But,
sure. Okay. Mr. Collier, is there anything you want to say, or are you good with what your lawyer said for you?
I'm good with what my lawyer said for me, sir.
Okay, well, we'll stick with that. I've got a few questions. Mr. Parrish, you mentioned Mr. Slayton had a BB gun. Mr. Collier had, your word was real gun. Was that gun recovered and that's why you're calling it real, or it just looked real?
I believe it was recovered.
Okay, so whenever this car crashed and people were caught, either on Mr. Collier there was a gun or in the car there was a gun.
I'll double check that, but I'm fairly certain it was recovered.
Okay. Ms. Wood, is it Mr. Collier's intention to speak with the jury truthfully about what happened if this case ends up going to trial for other folks? Or has he not decided that yet?
that has not been decided as of yet, Judge.
Okay. We're working off a copy of the indictment. Do you have any issues flowing from that?
Yes, Judge, we have no issue with that.
Is there a guilty plea form that you filled out with Mr. Collier?
Yes, Judge.
Great. And have you signed that form, Ms. Wood? The very last page should have your signature on it.
Yes, sir.
Mr. Collier, the form that Ms. Wood is holding, did she talk to you about that and help you understand it so you could put your initials all over it?
Oh, yes, sir.
And did you sign the second to last page indicating you understand it?
Oh, yes, sir.
Do you have any questions about that form or anything that we've talked to you about today?
No, sir.
All right. So, Mr. Collier, it does sound like you have had to endure some struggles in your life. No dad. Sounds like your mom was doing her best to raise you and your sisters. She was sick sometimes, and of course, the tragedy of her passing, and you weren't there for that. That's a tough one. Hard for your sisters, obviously, but particularly for you because you couldn't be there for your mom in her final days. Those are complicated circumstances. It's also complicated that this case represents your fourth time getting in trouble with the law, with two of the priors being robberies. I'm not saying burglary is not serious, but at least there's no immediate victim. And you broke into someone's house or business, and that's very upsetting for those folks. But at least they're not there when it happened. But a couple times you took something from someone else right there in their presence, and it seems to have escalated to this, which was a real serious situation. We are fortunate that the most serious thing that happened was maybe Mr. Slayton got bopped in the head with the pickle jar, and some of the victims who were basically performing the police's work till the police could get there may have sustained some injuries trying to restrain Mr. Slayton. But someone could have gotten shot. You could have shot someone. The high-speed car chase, someone could have gotten killed in the car chase. And fortunately, that didn't happen. But that's how serious this has become. And I don't know if it's you running with Mr. Slayton and Mr. Robinson. My recollection is they're a whole lot younger than Mr. Collier, which is an interesting dynamic because we usually see folks who are about the same generation getting mixed up in something like this. But this is taking it far enough that there are going to be some pretty serious repercussions. I don't know what kind of sentences you got with your other cases, but they didn't take you out of commission for that long because then you were picking up new charges. And it is time for you to take a break and reflect. You've got an adult child, and I think that person, what's your son's name?
Vantavius.
Vantavius? Is he in the Atlanta area?
Sir.
Okay. I think he'd like to have you in his life, but that's not going to be for a little bit. Mr. Collier, I think given the severity of what happened and the fact that this comes not immediately on the heels, there was a break in time between your most recent conviction out of DeKalb and this, but just given the nature of those, that a significant sentence is appropriate. Here's how I'm going to structure it. It's going to be, in the end, a sentence of 30 years to serve 20 years with a balance on probation. But here's how I'm going to break it down. Count 1, the sentence is going to be 15 years to serve. Counts 2 through 4, I want to make sure I'm looking at all the right counts. Where did it go? It is counts 2 through 4 will be 20 years to serve. They'll run concurrently. That means at the same time with count 1. The only one that has to run consecutive, Mr. Parrish, is count 5, I believe. Okay, just want to make sure this math works. And the only misdemeanor is count 9, misdemeanor obstruction. Okay, so count 5 is going to be 5 years. That will be probated. That will run consecutive to count 2. Count 6 will be 5 years probated. That will run concurrently with count 5. Count 7 is 5 years probated. That's concurrent with count 5. Same with 8. 9 is 12 months to serve. That'll run concurrently with count 1. And then, oh, I got that. I messed up number 5. Poor Ms. Nelson. All right. Count 6, 7, 8, and 10. 6, 7, 8, and 10 are all 5 years probated, concurrent with each other, consecutive to count 2. Count 9, the misdemeanor, 12 months to serve, concurrent with count 1. And then the tricky one is count 5 that has to be consecutive to everything else, is 5 years probated, consecutive to count 6. So the way that stacks is 10 years probation following 20 years to serve. It'll be a special condition of your probation, Mr. Collier, that you have no contact with any of the victims in this case or with Mr. Robinson and Mr. Slayton, your co-defendants. You'll need to stay away from the jewelry store on Roswell Road where all this happened. And I'm also going to ask you to get your GED. You're going to have some time in custody to do that. And I bet that's what you're going to do, is focus on something like that. But I do want you to try to get your GED when you get out, if you didn't get that certification while you're in custody. Importantly, Mr. Collier, you will get credit for every day you've been in. So you have already served Ms. Wood did the math, but well over a year. You're fast approaching a second year. So that's baked in. When I say it's 20 years to serve, you've done about a tenth of that already. Mr. Parrish, anything you want to add in connection with that sentence, those conditions?
No, Judge, as I wrote it down, I think your math added up to that 30 to 20. I don't think there's anything else for the state to add.
Mr. Collier, I skipped a couple things I need to share with you. One, I'm sentencing you pursuant to what we call the Probation Options Management Act. All that means is that when you're on probation, that'll be a little ways down the road, if you have what we call a technical violation, like you miss a meeting or something like that, you and probation will sort that out. You don't have to come back and see me. But if it's you get arrested on new charges, something like that, that comes back to me. And finally, I do need to make clear on the record that I find there is a factual basis for your plea. In other words, if the state were able to prove all the things they said happened, that you came in there with Mr. Slayton and you had a gun and Mr. Robinson smashed and grabbed all this stuff and you guys fled, that the state could prove your guilt beyond a reasonable doubt with the jury. I also find, Mr. Collier, that your plea is knowing and voluntary. A voluntary plea just means that while you're probably not real excited about what's happening now, you are taking this plea because you, after talking with your lawyer and maybe your sisters, have decided that this is the right way forward for you. Is that correct?
Sir, sir.
Okay. And then a knowing plea simply means you've understood the things we've talked about. And that I already asked you. You told me you understood everything after Ms. Wood explained it in the form you signed, and you've understood the things Mr. Parrish was talking to you about. Is that a fair statement?
Sir, sir.
Okay. Ms. Wood, do you have anything else on behalf of Mr. Collier?
No, Your Honor.
Okay. Mr. Collier, good luck out there. I hope that when you are released, you're able to plug back in with your family, okay?
Okay.
Thank you.
Thank you, Judge. I'm needed in Judge Carnesale's courtroom very briefly. Can I go there before I come back?
You may, and I think if this is your one case, then I think you're just waiting to see if Mr. Webb has an
Co-defendant, you must have a
update.
conversation with the co-defendant.
Great.
I'll come
Okay.
back and double check on that.
Sounds like a plan. Thank you, sir. Can we bring Mr. Peck out briefly? Mr. Peck, he should come up to the podium. And after Mr. Peck, why don't we can do Henderson or Fleming? I'm fine either way. I don't know if Mr. Majeski is in here right now.
Your Honor, said that he had a couple of courtrooms that he needed to appear by Zoom.
Okay.
But if you want to do Mr. Fleming, I'm ready.
Okay. Mr. Pugh, you out there? If you want to text him or something, I know he was juggling two courtrooms. Mr. Pugh, that's Fleming's lawyer. So whoever we get in here first, either Mr. Pugh virtually, and I think he's still on, or Mr. Majeski in person. Is his lawyer back there? Is Mr. Webb back there? Yeah, this will be brief. I just need to hear from Mr. Peck which way he's sailing. Deputy Gordon, do we need to get them to take that? You don't need to do anything right now, but would it be helpful if that table got removed now that we're done with the multi-defendant, just for the movement of? No, you can put it wherever you want, but we can get Dream to come in and get it out with that. All right, we'll put in a request for that. Thank you, sir. Mr. Webb, I'm just going to hear from Mr. Peck real briefly about his thoughts about representation. We won't do the Feretta hearing right now. We're going to do one more plea. You can get back there and keep talking with your clients.
Okay.
But I just wanted to take his pulse. If you just slide back a little bit, Mr. Peck's going to go up to the podium.
Oh, here, I can move.
No, it's,
It's easier for me to stand there.
You sure? Okay. Yeah, we just took a plane.
Good morning, Mr. Peck.
Good morning.
How are you, sir?
I'm okay, Your Honor. How are you today?
I'm well. We're going to have a brief conversation right now. We may have a longer one later today, but it's been a minute since you and I have seen each other.
Yes, sir.
And I needed to hear from you directly what your thoughts are about representation. You've got a couple cases. Your oldest case was just re-indicted to add another count to it. But we can't move forward with any of them, the more recent ones or the one that was re-indicted, until we sort out who's going to be representing you. Mr. Gregory, who had two of your cases, told me that you were pretty clear with him that he was off the cases, that he should not be representing you. But I needed to hear that from you. Mr. Webb from the Conflict Defender's Office has been assigned to it's your newest case. It's not going to be the newest indictment because of the re-indictment, but the newest case you've got. So he's your lawyer for that. I need to know what you want to do, because we've had conversations before where you've indicated you may want to represent yourself, and you've got all sorts of rights in this area. I need to understand your preferences so that if it is self-representation, then later today, we're going to have a pretty long conversation about why that's a bad idea, but why you have an absolute right to do that if that's what you want to do. If that's not what you want to do, then we need to sort out, is Mr. Webb going to be picking up your other two cases because you have directed Mr. Gregory to step down? Your turn.
Okay, Your Honor, no, I would not like to go pro se. I am not a lawyer, okay? And I know only what I know by reading the law, okay? I have put in several motions, and I like all of my motions to be adopted by this very guy right here, as of today.
Okay.
Now with Mr. What's the other lawyer name?
Mr. Gregory.
Mr. Gregory took my money and ran off with my money, disappeared, hid from me. When I would pay him, I would go to his office and I would pay him by cash, okay? Personally, so I could sit down and have a conversation with him. Well, when I gave him almost $5,000, he started changing his phone number, changed his phone number more than 20 times.
Okay, so I'm gonna, because he's not here to give me his side of the story. It sounds like you're frustrated. I understand that. Are you asking that Mr. Gregory come off your other two cases and that those go to Mr. Webb, so you've got one lawyer covering all your business?
Well,
or do you want Mr. Gregory to stay on?
I want this guy to be on it, but I want Mr. Gregory to do what I paid him to do. I want them both on the job. I've been here 5 or 6 times just to sit in the bullpen and not come in front of you.
Well, here you are.
2 years, okay?
It's been a while.
And I'm not guilty, sir.
Okay. And we've talked about that before. This isn't the time for you to start talking about your case in that way.
All right.
But what I'm understanding you say, I want to make sure I'm getting it, is that you filed some motions. Of course, you know, because you've done some reading, if you've got a lawyer, any motion you file, I disregard. I only look at motions that come from your lawyer.
Yes.
You're going to have a conversation with Mr. Webb about whether he should adopt some or all of those motions. And he, because it's a conversation, is going to give you his legal advice about whether some, all, or none of your motions are good ones to file. That's where he's the expert and you're not. So he may look at one of them and say, there is no such thing as a motion to dismiss an indictment, which is legally correct. We get that from defendants all the time. Judge, dismiss my indictment. I don't have the authority to dismiss an indictment. The state can say we want to dismiss it. What I can do is get it in front of a jury. And if the jury says not guilty, that's sort of like the indictment being dismissed. So Mr. Webb needs a chance to read your motions and then share with you his view of, that's a great one. And I'll certainly file it. I'll adopt it, make it mine. And if it's Mr. Webb's motion, then I need to address it. I need the state to respond to it. I need to enter an order saying yes or no or something in between. So that's step one, is that the two of you will talk about that.
Okay, but the other thing I want to explain to you, Mr. Lewis Carell and Mrs. Mary Beth Snyder, along with this guy's from the same office. Mr. Lewis Carell went in on my bond hearing. I put in a motion to get in front of the judge, asked me, what can I tell him that would help him so he could get me a bond? I told him exactly what he needed to do. He went in there and he told Judge Richardson that she could not give me a bond. Later on, after 11 months, I was indicted. Once I got indicted, I'm not qualified for a bond. You know, that's a violation against my constitutional rights. Okay, now this lady, I wrote her letter. I even wrote the state bar on Mary Beth to tell what she had did.
She is not with that office anymore, and you're not the only one who got frustrated. So I understand that, but we've got a new guy batting for you, and we're going to give Mr. Webb an opportunity to look over the files, plural, and also to consult with you about your motions, and we'll figure out what we're going to do.
Yeah.
That's the piece. I said we were going to keep this short.
Yes,
We've got
sir.
a bunch of other folks I need to work with, but I'm hearing you say, yes, Judge, I'm willing to work with Mr. Webb. He's got some work to do, and he knows that. And the two of you will take it from there, and I'll make sure we get you back in here to deal with your motions or to get you a trial, because you said it better than anyone. You've been stuck in jail for a while.
Yeah, I lost my business. I train professional fighters. Okay, I've been a boxing coach for years and years and years. I lost my gym. Okay, I lost everything. I lost 2 vehicles. I lost my home. Okay, because I've been in jail.
Okay. Well, we need to get you in front of a jury so the jury can decide whether that's where you stay or if you got to get back out and be about your business. Okay. All right, Mr. Webb, will you please spend some time with Mr. Peck and his files to figure out which motions you're going to adopt and what you're going to do with that. Okay. All right, Mr. Peck, it's good seeing you. We will get you back here soon with Mr. Webb to figure out which of those motions we're going to tackle. Okay.
Thank you very much, Your Honor. God bless you, sir.
All right. Take care.
You too.
Yes, sir. So we should get the new case. It'll be on a P&A. I mean, that's how we'll take. I know you were going to do that today. I'm going to let them connect a little bit more, and the re-indicted one we'll just put on a plea and arraignment.
Yes, sir. I'll be in touch with Mr. Webb.
Okay. Thank you.
You want to see it?
So what are we doing? Are we going to take care of Henderson? We got Mr. Majeski. Should we do Ms. Henderson?
Well, I think I interrupted Mr. Joe from his proceeding. He jumped back on. I think he will be faster than this.
Okay. Mr. Majeski, if you want to go back to where you were, we can reel you back in.
Done with everything, but you before 11:30.
Okay.
Whatever.
Well, we're going to pause it. We're going to do one more plea, and then we're going to pause for a little bit. And a few of you are going to stay. We're going to have a conversation with some of the folks who are here. I'm neutral as to how we do the next. Mr. Abate.
Before we, John, can we, for Mr. Jacob, he's here on Mr. Williams' case.
Yes.
Which is going to be moved. He's already set for, I believe, November 30th. We're going to get pre-tried. It will likely be a plea prior to that November 30th date.
Yeah, so November 30th will not be a day to take a plea. November 30th will be a day to pick a jury. So if you are hoping that Mr. Williams's case comes off, and he will be first out that day because the one case ahead of it is pleading today. So Williams is what we try on November 30th, unless before the 30th, it's been a plea.
Okay, I think we can get a plea. He's going to talk to the victim's family, and I think we're going to try to work the case out by next week.
Great. Just work with Ms. Nelson. We'll get you in here. Would your preference be, Mr. Jacobs, that Mr. Williams is here and you are here in person? It just affects the day we do it. You'd like it to be in person.
I think that'd be appropriate.
Good. I think it makes more sense, but sometimes people say I'd prefer remote. So we'll do Mr. Williams in-person plea sometime soon.
This is Dinah Jones calling back.
And that'll take it off of the November 30th trial date.
And if for some reason we don't reach a plea, then we'll be ready on the 30th.
Good.
So,
Excellent.
okay.
Thank you. All right. What are we doing?
Your Honor, I just want to let you know that position 6, Heavenly Mitchell, is here. Court.
Great. Good decision to show up, Mr. Mitchell. What was the delay? Oh, you had an appointment. Okay, all good. Just let Ms. Patel know that. No, don't leave. I just didn't know that. Let Ms. Patel know that next time so she can say he'll be here, but he's somewhere else. Okay. All right. So Ms. Patel, this remains on as a backup to Oliver and Bonventura for the 14th, and Mr. Mitchell knows that.
Yes, Your Honor.
Okay, great. He's free to go.
Thank you, Judge.
All right. So which one did you think would be a more discreet plea? Okay, let's do that. Mr. Pugh, are you ready?
I am, Judge. Thank you.
Great. Let's bring Mr. Fleming out, please. All right. Are you ready, Ms. Hall?
I am.
Ms. Rivers? Good morning, Mr. Fleming. How are you?
All right.
Mr. Fleming, your attorney, Mr. Pugh, is on the screen in front of you. You see him?
So,
You have a right, Mr. Fleming, to have Mr. Pugh here in court with you by your side in case you've got any questions or concerns. Mr. Pugh assured me before we brought you out here that he's been spending time with you. He actually has filled out a bunch of paperwork on your behalf. I need you to let me know if you are comfortable proceeding with Mr. Pugh virtually by your side, but not physically by your side.
I'd rather have him by my side.
You rather have him by your side?
Yeah.
So you want to not enter your plea today?
Judge, if I may, I went out to the jail last night or yesterday and spoke to you, Robert, and told you I would be virtual today. But if you want to reschedule it for me to be present, we can do that.
It's your right. And so I'm not leaning on you one way or the other. Mr. Pugh can see and hear everything, and he's going to be saying a bunch of things on your behalf. But if your preference is to have Mr. Pugh literally standing by your side, we just need to bring you back here. You are set to be tried on Monday. So if you want this to be a plea, it has to happen today or tomorrow. And so we need to figure out a way to get Mr. Pugh through the World Series parade. But you're comfortable going forward?
Yes, sir.
Okay, well, let me say this. If at any point during our conversation, you become uncomfortable with going forward, you should tell me that and we'll stop. We'll just pick up where we were when we can get Mr. Pugh right next to you, okay?
All right.
Second thing, if at any point I'm saying something, Ms. Hall is saying something, or Mr. Pugh says something that doesn't make sense to you or is different from what you and Mr. Pugh talked about, please let me know and we'll stop and make sure it gets explained or corrected if someone said something that was incorrect.
Yes,
Does that make sense?
Yes, sir.
You'll do that?
Yes, sir.
Great. Ms. Hall?
Thank you. Ms. Fleming, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
May lower your hand. Please state your true, correct, and legal name.
Robert Fleming.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you're going to take that you have not been given today?
No, ma'am.
How old are you and how far have you gone to school?
I'm 41. I completed 8th grade. I went to 9th grade.
And are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? Trafficking in heroin, obstruction of a law enforcement officer by use of threats or violence, possession of marijuana less than 1 ounce, and obstruction of a law enforcement officer misdemeanor.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
No, ma'am.
You haven't had enough time to speak with him?
Yeah, but
So,
You need more time to speak with your attorney?
I really do.
Okay.
okay, well then that's another reason we shouldn't go forward today. So I just want to remind you, Mr. Fleming, you need the time you need, and Mr. Pugh has been retained by you, and he's going to need to spend some more time with you. My plan is to have jurors come down on Monday, and we'll start your trial. So you're gonna need to work through that with Mr. Pugh. But I want to make sure, I don't want to take your plea if you're not certain about what's going on and you need more time to talk to him.
I want to take the plea though.
Okay.
Judge,
So those are
if
two
I
different
may-
things.
Yeah. And Judge, may I just real quickly?
You may.
If it's all right. So I'm glad to do whatever Robert needs me to do. Robert, I came to the jail. I talked to you earlier this week and I came to the jail. Went with you. If you need me to come back, I can. The state has filed a notice of recidivism. So if we don't get this plea done, you'll be sentenced as a recidivist. And I went over that in great detail with you yesterday. So if you don't want to go forward with the plea today, and we don't get it done tomorrow, we're looking at a trial Monday, and they've already filed the notice of recidivism. I went over that with you yesterday when I met with you.
Mr. Fleming, without going into details, because your conversations with your lawyer are privileged, confidential, what is it that you want to cover more with Mr. Pugh?
Really about what I only got to talk to him like one time.
Okay, but my question is, what other things were you hoping to discuss with him?
I really want to go and get this over with.
Well, but I hear you, but you also, if you've got things you want to cover with him, this is your plea. It's not Mr. Pugh's plea. It's not Ms. Hall's. We've got other folks we can work with. If you feel like you need more time because you're not sure what's happening today, or you're not sure what the recommendation is. I mean, I've seen the form you signed, and as I understand it, it's a joint recommendation. Everyone's recommending the same thing. So at some point, you signed a piece of paper that said, I get what the deal is, and I'm okay with that. You're free to change your mind. If you're not okay with it anymore, we should stop.
Okay, we.
So what do you want to do?
Along with the plea.
Okay, well, let's keep going. But again, if you have a concern, let's stop and make sure Mr. Pugh has a chance to talk to you about it, okay?
Thank you, Judge.
You would ask your question again. We'll go from there.
Mr. Fleming, have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defense?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you waive formal reading of the indictment?
Robert, that means do you want her to?
That was a question for you, Mr. Pugh.
Oh, I apologize. Yes, I do waive it. Yes.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes, ma'am, we do.
And do you waive moving forward on a copy of the indictment?
Yes.
Mr. Fleming, have you been arrested on these charges?
Yes, ma'am.
I asked because the state is unaware of any outstanding warrants for these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No, ma'am.
Not to these charges. He does have a probation hold out of Douglas County that he and I spoke about as well.
Has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
The minimum maximum sentence for trafficking heroin, 10 years minimum. The maximum is 30 years to serve. The minimum maximum for obstruction of law enforcement officer by use of threats or violence is 1 to 10 years to serve. And your 2 misdemeanor charges, possession of marijuana with less than 1 ounce and obstruction of a law enforcement officer are both 12 months to serve. You understand?
Yes, ma'am.
You understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of, for count 1, trafficking in heroin, 12 years to serve 10, balanced on probation. For obstruction of a law enforcement officer by use of threats or violence, 2 years to serve. And for the remaining misdemeanors, 12 months to serve. But the court does not have to accept that recommendation. The court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another. Do you understand?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would, and this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you may be guilty of a felony, which may carry a sentence of 1 to 15 years in prison? Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
Oh, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yeah.
In indictment number 20SC 175603, how do you plead to the charges of trafficking in heroin, obstruction of a law enforcement officer by use of threats or violence, possession of marijuana less than 1 ounce, and obstruction of a law enforcement officer misdemeanor?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Repeat that again.
Are you doing this on your own will and voluntarily? Someone's forcing you to take this plea today?
Oh, ma'am.
Do you understand that you only have 30 days from today to appeal this guilty?
Yes, ma'am.
You understand you only have 30 days to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, the state is aware of 7 prior convictions by the defendant, dating back to 1999, which was
You don't need to list all 7. What's the most recent?
the most recent 2 were a violation of the RICO Act out of Douglas County and a possession of a Schedule 1 or 2 controlled substance with intent to distribute out of Twiggs County. The Douglas County conviction was August 26, 2015, and the Twiggs County was February 19, 2015.
Okay.
Had this case proceeded to trial, Your Honor, the state would have proven that on February 25th, 2020, at 359 Fairburn Road, Atlanta, Georgia, in Fulton County, officers were traveling behind the vehicle that the defendant was driving. When they ran the registration came back suspended. They initiated their sirens and their lights. The defendant pulled into a resident. When he got out of the vehicle, walked towards the officer's car, the officer asked if he had driver's license. He indicated that he did, and he would go back to the car to get them. Officer advised him not to, but he still proceeded. And at that point, he took off running. Officers pursued him. They end up detaining him. But during the tussle to try to detain the defendant, he did bite 2 of the officers. They did get him arrested, and he was checked out by Grady because he complained of some breathing issues, but he was ultimately transported to the Fulton County Jail. Search of the vehicle that the defendant was driving. There was heroin that was found in the center console. They weighed it on the scene. It came back to 12 grams of heroin. But once it was tested by GBI, the actual amount was 18.8 grams. There was also marijuana that was found in that vehicle as well. The officers actually could smell marijuana coming from the vehicle before they started to search the vehicle. And that is all, Your Honor.
So the officers are okay.
They are.
And Mr. Fleming turned out to be okay, the breathing difficulties. Okay. It sounds like the Douglas case is open and active because there's a probation hold for Mr. Fleming from there.
Yes, Your Honor.
And at this point, you are not seeking to recidivize Mr. Fleming because he's resolving the case short of trial.
Correct, Your Honor.
But if he went to trial, you'd file a recidivist notice such that any jail time he'd get, and it's a mandatory 10 years for the trafficking, would be without parole.
That's correct.
But Mr. Fleming is eligible for parole the way that you've structured your recommendation. Okay. Understood? Mr. Pugh.
Yes, sir.
Tell me what you want to tell me about Mr. Fleming and this plea.
Judge, Robert's been in custody for 21 months at this point. We've had a motion or two for bond, and you actually granted the motion to try to let us get to Douglas County, if you may recall, to resolve the probation matter, and Douglas wouldn't come and pick him up. So then, Your Honor, revoked the bond. I do believe it's in his best interest. I've talked to him several times over video, multiple times over the phone. Drove out yesterday and met with him face to face to go over the plea work. I think he just got a little nervous and confused this morning. Robert's been very congenial about this, and I think he's ready to get this behind him and then close out the Douglas case and get on with his lives.
All right. Mr. Fleming, you have the right to say anything to me. If there's anything you want to say, you don't have to say anything at all. I think I understand what the allegations are, and I'll let you know that I do find a factual basis for your plea. And all that means is that if all those things Ms. Hall just said, she could actually prove to a jury, the jury could find beyond a reasonable doubt that you were driving the car, you were the only one in the car, so the heroin goes to you, whether you say it was yours or not. The marijuana, not going to move the needle. That goes to you. And then the felony charge is the obstruction. And if officers came in and said, yeah, this is the guy and he bit me, there's your obstruction count. So I don't mean to suggest it's a simple case. No case is simple. It's your case. It's an important case. But I do think that the state has a factual basis. Tell me if there's anything you want to add to any of this, or if you have any questions about anything. Okay. Well, Mr. Fleming, I find that your plea is also knowing and voluntary. And on the knowing piece, I'm pretty comfortable with that. That means you've understood everything we've been talking about. You seem like a smart person. You've led a busy life, but is there anything you have any questions about that you've heard us discuss? All right. The voluntary piece, though, I need you to tell me in your own words whether this is a voluntary plea or not. Voluntary doesn't mean you're excited about it. There's no reason for you to be excited right now. You're pleading to something serious, and your sentence is not a short sentence, although it's a parolable sentence. I think your criminal history is catching up with you a bit, and I understand why the state offered what it did, and why if you went to trial, they'd seek to recidivize you so that you do every day of any jail sentence that you got. But in the end, it's not my plea, it's yours. And so I need you to tell me whether you believe that the right way forward for you is to go forward with this plea as opposed to go to trial on Monday. Because happy to do that. We got all the jurors we need now.
I'm gonna go forward with the plea.
Go forward with the plea? All right, then I'll accept it. I'm going to sentence you pursuant to the Probation Options Management Act. And all that means, Mr. Fleming, is that while you're on either parole or probation, and we know there's a probation piece, and I'll bet there'll be a parole piece. If you have a technical violation, you miss a meeting, you get 1 or 2 positives for marijuana or something, you and probation work that out. If it's anything more serious, a new arrest, something like that, that comes back to me and we work through whether there should be a revocation or not. I will follow the agreed upon recommendation of your lawyer and the prosecutor. I'll sentence you on count 1 to 12 years to serve 10. with the balance on probation. Count 2 will be 5 years to serve. That'll run concurrently with count 1. And then counts 3 and 4 are both 12 months to serve. That's also concurrent. So they all run together. So the one that really moves it is the trafficking count, 12 years to serve 10, balance probated. And the only condition I'm adding to your probation, no one talked about it, but I want you to get your GED if you haven't done that while you're in custody. You may have stopped school in the middle of 9th grade, but I get the sense that it would not be difficult for you to get that GED.
I already got it.
You already got it. You kept that secret. Then you don't have any special conditions of probation. Did you get it before you went in, or you got it since you've been in?
Before I went in.
Okay. How long ago did you get it?
2018.
Well, good for you. Done. So no special conditions of probation. Anything else, Ms. Hall? Mr. Pugh, anything else?
No, sir. Thank you for your patience. And Robert, I'll get with you soon. We got to work out that other matter.
Yeah, so last thing for you, Mr. Fleming, I'll sign the final disposition today or tomorrow. That ought to get you to Douglas County. And Douglas is going to do what Douglas does, but in my experience, when another jurisdiction sees a sentence like this, they say that took care of it. And I don't know that there'll be more repercussions in Douglas, but this kind of resolution ought to address that situation as well. Okay?
Yes,
All right. Thank you, everyone.
Thank you, Judge. Have a great weekend.
You
Thank
too.
you.
All right. What we are going to do now is pause our formal proceedings. We have a number of guests with us from the Leadership Atlanta class of 2021, which is the second best class ever after, I think it was 2015. It may have been 2016, and I'm going to get beat up for not remembering. Whatever class CJ Stewart, he is one of my classmates, whatever he's in. And I want to open it up so that you all can ask questions of any of the participants here. We've got some very seasoned prosecutors. Ms. Hall's been working in this courtroom since I came to this docket. Mr. Abate is a homicide prosecutor. Ms. Convery is a gang prosecutor. We have on the defense side, Ms. Patel and Ms. Wood, who've been with the Public Defender's Office for a long time. Ms. Young sitting behind them is a private defense attorney. And we're all happy to answer questions you may have about what you learned this morning from the overview presentation you received, what you've observed here in court, what you didn't observe. You may have been expecting X would happen and X didn't happen. But I'm happy to open the floor. You're going to get shooed out of here just before noon, so you stay on schedule. So the time is yours to use as you see fit. You don't get to leave early if there are no questions, so you might as well ask questions. Yes, ma'am. If you tell us who you are, and then we'll think about answering your question.
Thank you so much, first of all, for allowing us to be here. So I wanted to thank you for that. And my name is Lisa Clark, just last ever 21, 22, because we had ways to get together. But one of the things that I'm curious, because for what I observed, is that a lot of these folks present here, I didn't see more than they never finished high school now. So besides that, I wanted to find out if while they're serving this sentence, are they being trained on any trade skills? Is that an opportunity that they have while they're serving?
Sure. So I'll say a couple things, and then I'll turn to the defense attorneys because they may have more knowledge about that because their clients may ask them about that. You saw only a small slice, but in some respects it was representative. I would say 95% of the criminal defendants we see didn't finish high school, maybe have a GED, but what you saw is not uncommon. 8th grade, usually they made it past 8th grade, usually get a couple years into high school, and then their lot in life is such that they're done with school and other things have gotten in the way. So that's fairly common, although we just did have a trial where just by the look of it, a shooting at a nightclub, you'd think it'd be more like this, but the folks, a guy with a master's degree, college graduates, et cetera. So, but that was an exception. That was very different. Everyone who's a usual participant in these things, oh my gosh, these folks went a whole lot further. There's not enough is the answer to your question. So that's Department of Corrections, state agency. It's not a county. The county has the jail. Once you've been convicted, if you're serving time, you go to the Department of Corrections, state agency. The answer is there's not enough. There are programs. You don't graduate or you don't get released as a doctor, obviously, but you can get some certifications of trades because as a trustee, you can work in the kitchen and get a culinary thing. You could work on HVAC, that kind of thing. So you're not going to leave with a technical degree, but perhaps with a certification. That's been my experience. Anyone from the defense side, is it worse than that, or are there other opportunities?
I'll say that currently COVID has changed what the jail can offer right now. It really depends on your age, your history, as well as your charge. My clients that sit in on murder charges are not eligible for GMB classes.
And I'm sorry to interrupt, but right now you're talking about folks who are here in the county. So they have not been sentenced yet.
Prison.
Right.
But I had a client that was in jail for about 9 months who completed his GED in jail. He was 20 years old, so he was eligible for a youth program there. The prisons unfortunately vary in terms of the classes that they're able to offer. You can actually start some college in prison, which is great. Most of them have GED, and then there are some certifications.
Yep. Yes, sir.
I am Debbie Parsons, 2 classes, 21 and 22.
So they're like 150 of you? Like they double the size? That's scary. All right, yeah. You better have impact.
So 100% of the defendants I've seen today were Black, 3 Black women. So 2 questions. What's the percentage of defendants that are Black? And then the percentage of people who represent them, like the folks sitting at the table here, the lawyers. I'm not seeing the same kind of demographic.
So on the defendant side, if we just look at the jail population, it's probably 85% Black, a few more percent brown, and then some white, but it is predominantly Black young men. I mean, the typical inmate at the Fulton County Jail is 17 to 23, 24 Black male who did not graduate from high school and come from a small number of zip codes throughout the entire county. And there are exceptions. If I went through our trial calendar, there are a few, but you are seeing the demographic that is in the jail. On the professional side, it is much more diverse. I don't know, you weren't here earlier, but there were several defense attorneys who are Black who were on the screen. They didn't come into court. The district attorney's office is very, very diverse. The public defender's office is very, very diverse. And that the DA is every prosecution. Public defender's office is 4/5 of every defense case, because the other factor I didn't mention is that they're all indigent. So the folks who are typically going through the criminal justice system can't afford their own lawyer. Not everyone. There are private defense attorneys. Mr. Pugh, who was on the call, and it's not surprising. You can do the logic. The drug traffickers can hire their own defense attorneys. I simply had a hit of heroin, have a public defender. So, but I invite the prosecutors and the defense attorneys to chime in. I think that's about right with the demographics of the population you all work with, meaning your clients.
That's good. I just wanted to add, our office is very diverse. I'm definitely in the minority in our office. I'd say over 60% of our attorneys are.
Right. You replaced Mr. Franklin, who was the senior public defender in here, Black guy who moved one courtroom over because he's senior and is now running the show over there. Yes, ma'am.
I'm Gilda Guerra. So of the two that we saw here, they were locked up for 21 months and 600 and something days, almost 2 years. What is the average time that they sit there before they can enter a plea? And is that normal? And if so, why does it take that long? It just seems like a long time for someone sitting on the bench.
It is a very, very long time. Everyone you saw today had, unfortunately, for the system, for victims, for defendants, for the public wanting to see their criminal justice system moving, 18 months of COVID baked in. There was time when we couldn't bring them over here. This whole Zoom didn't exist when COVID hit. So we're spending months figuring out how do we communicate with defendants who have to stay at the jail? How can we connect lawyers with clients so they can talk about, should you take a plea? Should you go to trial? Then the ultimate hurdle, how do we get jurors back in the building? We didn't have jurors in the building until a few months ago. This is a trial calendar. These folks are pleading because we were finally able to say, hey, put up or shut up. If you want to go to trial, let the state tell 12 people from the community what you allegedly did. And you can understand why Mr. Collier wasn't interested in a jury hearing about that. I mean, it's real graphic. There, it was an armed robbery, gun, broken glass, real scared people. So he didn't want to go to trial on that. But we didn't have jurors for a bunch of months. And so it's harder for a defense attorney to say, you're looking at a lot of time. The state is offering you 20 years. It's hard to walk into a room and say, I will plead to 20 years if your other option is, you know what, I'm just going to sit tight for a while. Maybe a witness forgets who I am, or the DA decides this case isn't important anymore. So there's an extra 18 months baked in for almost everyone. That's not to say people haven't been sitting too long. Mr. Hinton's plea, which we're going to take after you all go, he's one of the oldest cases I have. He has been in jail for, is it almost 4 years now? 5 years. So 18 months is COVID. Everything else is the system doesn't move quickly enough. And it's not any particular, it wasn't my case first. So is it my fault? I don't know. I should have moved it faster when I had it. Should the other judge have moved it? Should the prosecution have moved it? Should the defense attorney have moved it? Collectively, we fail folks who are presumed innocent and sit in jail for 5 years. There are explanations for some of the cases. Mr. Hinton is facing all sorts of serious charges, including murder. And it may be that he and his lawyers, and he's had several, decided, why would we rush this? We know what the facts are. You're going to get a life sentence if you go to trial. Maybe I can get you less than life. Are you okay with waiting? And sometimes defendants say, I would rather wait and see what we could do. But you are also seeing the worst of the worst. And by that, I don't mean the cases or the defendants. I mean how old they are. We are resolving cases every day. We took a plea yesterday off a plea and arraignment calendar with someone who had been in jail for 21 days. That's how it ought to work. But if it's a murder or it's a child molestation, it's not going to resolve in 21 days because the defense is going to want to see all the evidence. Maybe there needs to be an expert to interview the child victim. Maybe there's ballistics evidence, there's DNA. There are things that structurally slow things down that are perfectly appropriate to slow it down. Most cases are pretty simple and most cases resolve pretty quickly with pleas. You saw cases that weren't simple, serious charges, add on the 18 months, and you're hearing these numbers that ought to disappoint you that someone's sitting in jail that long. We're frustrated by it. Fortunately, with help from the sheriff and all the lawyers involved, we're able to start moving cases along.
One of the things, when I hear 5 years, and I've been a long time, one of the things is there were different judges involved, but there was 2 years in, there was a re-indictment, 5 cases, put it together, and then I had to catch up to speed on 4 cases where I didn't represent it. Then there was an appeal to the Georgia Supreme Court, and so that took some time. This was all happening as the pandemic was doing. So when you look at, it sounds like an enormous amount of time in advance, but as the judge said, there's a lot of things that go into why they would take that period of time. So when you look at how hard everybody, and I used to be a division prosecutor, how hard everybody, the public defender's office, private attorneys, and prosecutors, and the judges work. Sometimes it takes that long because of the number of cases and the complexity of a lot of the cases. If somebody is driving down the street and gets stopped for a traffic accident, then they have cocaine sitting in the console, that's not difficult, right? But when you get a lot of the cases that the judge sees, that public defenders and prosecutors litigate, they're very, very complex. They make the TV court look like, everything's scripted, they all know what's happening. In real life, it's so much more than what he does.
Mr. Fleming's case was a great example. His case was not complicated. Trafficking quantity of heroin in the center console of a car he's operating and no one else is in it. Legally, he owns those drugs. But he caught those charges just before COVID. And so he would have entered that plea, and you heard he was reluctant, but he was not going to go to trial. He would have entered that plea a year and 4 months ago because we could have put it on a trial calendar. But for a year and a half, I couldn't put it on a trial calendar. And he wasn't going to take that medicine until the other option was go to trial, be designated a recidivist, which means you don't get parole. And he would have done 10 years to the door for that same heroin. Now he'll probably get out in 4 years and be on parole. So that's just an example of one where that 18 months made a big swing. The one other thing I want to tell you, I don't know what your lecturer said at the beginning. I used to give that initial presentation and talk about speedy trial rights. Defendants have mechanisms to move their cases along if they want to. A defendant can, when he or she is indicted, demand a speedy trial, and that person has to be tried within 2 terms of court, which in Fulton County is 4 months. The term of court is how long a grand jury is here. So defendants have that right. Very few do that because their experienced lawyers typically know you don't want to rush this thing. Going slow generally inures to the benefit of the defendant. But there is a mechanism for a defendant to move something quickly. And we do see it. And it's usually one where there's a great defense, like self-defense, or there's just something unique about that case. Every defendant can do that. And the lawyers know how to do that, but they rarely use that. The second one, there's something called a constitutional speedy trial. If you've been sitting in for too long, you can file a motion to say, my due process rights have been violated. I'm presumed innocent and nothing's happened with my case. And a judge can say, you're right. It doesn't really matter in the end whose fault it is, as long as it's not the defendant's fault. If it's the judge's fault, the state's fault, and the judge can dismiss the charges. That happens too. Again, it's seldom. It needs to be several years before something like that happens. And the courts have been pretty clear. COVID is not a proper basis to say, yes, your speedy trial rights have been violated, because that's one of those acts of God that really doesn't fall on the shoulders of any of the actors within the system. May have been more detailed than you wanted. Sir.
Bernard class of 21, 22, the best class is really long class. I think the one thing that really struck me are mandatory minimums. They seem, just as an outsider, I'm not in the legal profession, or unduly harsh. How do you mitigate that? And is there any leeway you have at all? I heard different probationary periods, different sorts of things like that. If you could explain that process and just how they are seemingly really harsh.
So the part of what you saw today that was not a good cross-section was that both those were mandatory minimums. Most cases are not mandatory minimums. Burglary, aggravated assault, most drug cases till you get to trafficking is a big old range that gives the judge discretion, gives the parties the ability to say, well, you know what? This is a first-time offender, so let's just do probation. Hey, it's his second, so maybe it's a little jail with some probation. So let's just take burglary as an example. That's 1 to 20 years. That's a big range. There's no mandatory anything in there. The sentence could be 5 years jail, 5 years probation, 1 year jail, 1 year probation, or a mixed sentence. You happen to catch an armed robbery, which has a 10-year mandatory minimum, and then the trafficking 10-year mandatory minimum. Hands are tied. Judge can't do anything about that. The legislature has spoken, and the legislature has determined through its policy perspective that certain drug offenses, there ought to be a floor. And for armed robbery, there ought to be a floor. There is a safety valve for armed robbery that the state can use if it wants to. There's a statutory provision. If the state says, Judge, we're invoking this statutory provision, that gives the judge the discretion to go below the 10. And we see that come into play for, usually it's a youthful first-time offender and is a sidekick. So 3 guys do an armed robbery, and there's a 17-year-old who's never been in trouble before, and he just sort of stood there. He was the lookout, whatever his deal was. That's one where it's still 10 years. It was an armed robbery. You were party to that crime. The state may well say, Judge, we think you should go below the 10. We recommend 6. Maybe the defense recommends 3. And if the state invokes that, the judge can go below it. Mr. Collier did not fall into that category. I was not surprised that Mr. Parrish didn't say, Judge, I think you should go below 10. This is his 4th. He had 2 prior robberies. This was not your our typical armed robbery is what you'd think of as a mugging. And maybe there's not even a gun. It's one of these things. But if the victim perceives there's a gun, that makes it an armed robbery legally. This was your full blown, we're lucky no one died. I mean, you heard me talk to Mr. Collier. So the state could have said, Judge, we think you should be able to go below the 10-year mandatory minimum. That's their discretion. That then gives me discretion. Most cases don't have mandatory minimums. Do you want to chime in on that from the state side?
No, I think you covered it. Just, Mr. Collier's case was mine originally, Mr. Parrish was mine. Mr. Collier, the situation that Judge described with the 2 other offenders and were significantly younger. He was sort of the connection that really served me as a supervisor in that unit. So when we come into resolve the other 2 defendants, it's not going to look similar to Mr. Collier's situation. And then taking a look at his history, not only does he have the reference, just relief from the DOC system, goes right back out to community, recruits and recruits these other 2 guys, and comes into Silver Springs to go super violent invasion of their store, really. And yes, someone got shot. We're very lucky for that, but it very seriously impacted the folks inside the store. That's going to change their day to day in a super meaningful way. So we see Ms. Hall probably more than me, but there's a lot of flexibility that we have for the statute that the judge talked about. We use it all the time. That's why I know a lot of people recently joined our office from other professions because there's a lot of good we can do from our perspective in the DA's office, and we do it all the time. So I don't want everyone thinking we're just like mandatory minimum because there's a lot of flexibility that we have, and we should, and we use it a lot.
I know you've got a question. I will get to you. I've just been working my way down. I want to add one thing. I don't want you all to leave here today saying, oh my gosh, what I read in the newspapers is true. There's just only violent crime and it's scary stuff. Most of our cases don't reach a trial calendar. Most of our cases are real simple pleas to probation, shoplifting, a burglary. And I'm not suggesting burglary isn't serious, but it's a first-time burglary. Or it's folks who are committing an entering auto, meaning they break into your car because you left what they think might be valuable on the back seat, smash your window, they take it, and they're a drug addict. And the real issue for them is that they need help. And we've got accountability courts, and we push lots of folks through there where the focus is rehabilitation and not incarceration. You didn't see that today. Some of your colleagues may in another judge's courtroom, but that is a very, very significant part of what we do. This just happened to be trial calendar day. And what ends up on trial calendars are the messy cases that don't plead out real easily because the offer is a big number. And that's the forcing mechanism of I guess I better work it out because otherwise I'm going to face a jury. So please don't take from this that they're awash in armed robberies. And this armed robbery, I mean, it was TV level coverage when it first happened. That is an outlier. We have plenty of violent crime. I mean, the newspapers aren't lying, but they just don't report about the other stuff that is really more the bread and butter of what we do, where defendants come in through that door, just like you did. They leave through that door. They've been on bond and they're staying, they're not on bond anymore, but then they're on probation. That is much more typical of what we're doing. Yes, sir.
Yeah, thank you. Lane Tran. The gentleman, I think he was the boxing gym owner. I knew there had to be a story there, but it seems like he was filing motions. Is that a big part of the system? I mean, I'm assuming it sounds like you called Saul. You better call Saul, right? And I know there's 2 sides to every story, but is there a healthy bit of that where it's kind of stuck in the clerical court, and emotions are being held, or is there a system that kind of can knock down a lot of
We do fine with the motions. Motions are things we were actually able to work through even during the darkest parts of COVID. Because once we had remote connections, we could, hey, this lawyer can appear, and we can have that argument. Mr. Peck he falls into the category of, I don't want to represent myself, but I'm going to anyway. And we have a few of those defendants. Every judge does. He's got a real clear view of what happened. He has 2 separate rape indictments. He's got a real serious situation. And I suspect that he's not going to ever get out again, but the system will play through. And if there's a trial, he'll have his trial, and he should have a lawyer. He'll need it. But he is sort of grappling with that reality. And his pushback is, I'm just filing motions. Like, you should dismiss my case, or the victim is a liar. And that's what his motion is. The victim is a liar. Well, maybe, but that's for a jury to figure out. There's no such motion as the victim is a liar. But because his lawyers don't give those motions traction, he fires them. He's on his third or fourth lawyer. So I don't know if he owned a boxing gym or not, but he's got some pretty serious legal issues. Mr. Webb is going to work with him for now. It would not surprise me if that's not his last lawyer in the process. So the issue wasn't he filed motions and we ignored them. If a represented defendant files a motion, it's what we call a nullity under the law. You can't, because you've got a lawyer. And in talking with his lawyers, they have said his motions aren't meritorious. We wouldn't file them because they're frivolous, and lawyers are under an obligation not to file a frivolous motion. They need to help their client understand that, but they should not file a frivolous motion. If the client doesn't understand that, the client fires his lawyer. And that's been Mr. Peck's situation so far. So I don't know if that directly answered it, but
Yeah, I just want to know kind of like, I mean, how, like movies, right? How many quote innocent people are there just who can't afford a lawyer or who?
well, everyone is presumed innocent right now. Everyone in the Fulton County Jail, everyone on our docket's presumed innocent. They'll either plead guilty or we'll have a trial and the jury will say guilty, not guilty. The jury never says innocent. The jury says the state didn't prove beyond a reasonable doubt. So unlike TV, there's never a, oh, you're innocent. It's the state made these allegations. The state couldn't prove them.
Mr. Peck was my case, very briefly, I came to sex crimes. I think it's more along the lines of what the judge said. He just doesn't like what his lawyers are telling him. The public defender's office have fantastic lawyers. Every one of them that I've dealt with have been.
Does Webb say it's okay?
So they're giving him good, solid.
He says, because they're his cases.
He just doesn't like it. He doesn't want to take that fact at the end of the day and accept that that's the truth. And this is going to go a certain way. It's probably not going to go your way. So he's going to try to do something else. It's basically that's throw everything on the wall, hope that one of his weird motions to dismiss catches the judge's eye and gets free. So I think there's that misconception is existing in his mind that the public defender's offices are lower level attorneys and they're not going to give me the things that I want to do, even though it's warranted. So that was my read of him. And I do think he actually did own a boxing gym in the cabinet.
There you go. Other questions? Yes, sir.
Yeah, one real quick. I'm David Duncan. Thanks again for letting us experience this today. From a technology standpoint, what do you expect going forward? You said all of this arose as a result of COVID, and none of us know what the future of COVID is, but do you expect 1 to 5 years from now, this technology to still be integrated into the process?
I do. It's more complicated on the criminal side because criminal defendants.
Called me last night and said some guys came over.
Hold on one sec. Criminal defendants have rights to be present in court and to have counsel present. You heard that with Mr. Fleming. On the civil side, those rights aren't the same. And so we'll be doing Zoom or whatever the latest technology is on the civil side going forward. It's so much more convenient. There are certain things you want to have in court, but there's a whole lot. The lawyers love it. They can just be at home and they appear in DeKalb and then Fulton and then Clayton, all in the blink of an eye. I'll let the lawyers speak to how it has worked or not worked, but I know the courts will continue to push for certain things to occur remotely because you can get more done in the same amount of time than in the past. You don't have to fill up the courtroom with people sitting around waiting. When is it their turn to simply say, yeah, we're ready, judge? And then they get to leave. If you could be waiting online, you can be doing other work. And then when you hear your name called, you can simply say, judge, we're ready. Thanks for being here. And then they can go. I'm interested in the defense side first, because they're the ones who've got the concern about, well, what about the defendants?
I will say that prior to us having Zoom, a lot of our clients in unintentional ways were being punished for the fact that they might not be able to afford a ride to the courthouse. I don't think you guys might not have known this, but let's say you're just passing through Georgia on vacation, they find cocaine on you, you have to come back to Georgia for every single court date, and that is not something that a lot of people can afford. And so with our Zoom court dates, our clients can zoom in on their phone. A lot of them do have smartphones, even if they qualify for our services, or they can borrow a family member's phone. And so it's allowed them to stay in touch with the court and avoid getting a bench warrant and being locked up for missing a court date simply because they couldn't afford or don't have the transportation to court. And so I am happy to hear the court say that they see this continuing in the future, because before it was very stressful. Sometimes we have to send our investigators out to pick clients up to bring them to the courthouse so that they wouldn't be benched.
I got the high sign that you've got about 10 more seconds.
You have 4 minutes.
Oh, 4 minutes. Okay. It was all right. So it's a little better than that. Yes, sir.
Thanks for, appreciate all the work that helps you do, especially the cops out here, all the miles offices. You guys do. My question was, I have two, I'll just ask. Presentation matters a lot. You know, when you come see me in my office as a physician, definitely matters here in court. And I was curious about like, that everyone's coming in cuffs and chains, Fulton County prison on the back. And is that more of a safety issue that you probably pull in the people out there, or is there any opportunities for them to address better, or does that matter at all? Since it's not a jury trial, and what you both sides think.
The latter is the answer. If we had impartial fact finders working through a trial, those folks all would have been in street clothes. Absolutely. And we're very, very careful about that. If they, for security reasons, need to have something funny on their legs so they can't run, we make sure they are seated before the jury comes in. For something like today, I don't hold it against. First of all, I know they're in custody when they come in. Jurors don't know, is this defendant on bond or not? They shouldn't be thinking about that. They're thinking about, has the state proven its case? And certainly seeing an inmate in Fulton County jail togs, like, whoa, there must be something to this case because the guy's in jail. So it is a carefully concealed fact, unless the defense wants to go there. Sometimes the defense is okay with letting a jury know that a defendant is in custody. But for proceedings like this, I am aware it does not affect the sentence that I give the person. Well, gosh, if you've been wearing a tie, I might have just given you probation. That's not something that would affect me. If we had a suppression motion today, where the defense is trying to suppress the heroin that was found in the console because maybe the officers made a bad stop, again, Mr. Fleming would have been dressed the very same way, because we're not evaluating Mr. Fleming as a person. We're evaluating the legal arguments about the stop. So we are very mindful of it when the defendant will be presenting to the community in the form of a jury. Yes, ma'am?
Thank you again for having us. Pooja Mishra, which I think a great health system mentioned earlier. That's where I'm from, and I echo everything that my fellow classmates have said about. Thank you for everything you're doing. The question that stuck out to me was when the person said, I have not spent enough time with my lawyer. And there was this back and forth. The question that was in my mind is, how much time is enough? And when we have a system that is clearly under stress, how does the court decide that this individual's case isn't being rushed through, that this individual is truly getting full support of a system that is designed to help him or her?
For some defendants, there's never enough time. And for others, they are so ready, they're like, don't even, where do I sign? Can I just say yes to every question up front? Because I'm ready to move along. Mr. Fleming, I think, was falling towards the end of the spectrum of I'm reluctant, and so maybe I need more time. I don't know how much time he spent with Mr. Pugh, but I'll invite our defense attorneys to respond to that, because I know from cases they've had that they have spent hours and hours and hours with the client. But when it comes to that final moment, all of a sudden, my lawyer hasn't, I don't even know anything about my case. And you can see the pained look on the lawyer. But in the end, it's the defendant's decision. And you can have your trial instead. We don't need to do the plea today. We got 60 jurors coming in on Monday. Mr. Fleming didn't want that, but I needed to give him the space to say, all right, I'll do the plea because the trial is not going to be a good outcome. But as our final responses, tell us experiences you all have had in that area.
It's tough. I had a client who called my supervisor, said he'd never talked to me before, and I talked to him every day, almost every day. But there was another situation where there was someone in custody. Our office does not represent this person who's been in since January of 2020, who has not been seen by it. And that to me is frightening that someone could be in custody for that long. And so when you're the judge, you sort of have to, you have the clients that exaggerate. I've never seen my attorney in books that they'll get somewhere with that, but there are individuals incarcerated who are telling the truth when they say that they've only interacted with their attorney once over the phone. Those cases make me sick, and all I can do is report it to the person that I think can do something about it.
We also know there are very few strangers on the bar, meaning prosecutors and defense attorneys. And so generally judges have a pretty good sense. If the defendant says, I haven't seen my lawyer, like, I bet you haven't. And that is a problem. And so we bake in more time, and I fuss at the lawyer a little bit, as opposed to the lawyers you see here when the defendant says, I don't even know my lawyer's name. And I'll say, okay, well, let's work through that. Ms. Patel, why don't you introduce yourself for the 15th time to your client? Everyone's got an angle on it, but it's an overstressed system, but it's a system that, for the most part, provides pretty amazing support. The public defender's office, district attorney's office is staffed with lawyers who are really committed to getting just outcomes. The state will dismiss cases if the state is convinced this isn't a case that should be brought. The wrong person was arrested, or I don't believe the victim anymore. Based on what we've learned, the victim's testimony is not credible. We shouldn't go forward with this case. And they're not ashamed or reluctant to say, Judge, this is a case the state's dismissing. And these defense attorneys, this is their career. I mean, this is not what they do for fun on the side. They're very, very much committed to this. So defendants got stuck because of COVID, but they are in a system that I believe strongly does an impressive job of protecting their rights. Does that mean, to your question, sir, is there ever an innocent person who comes? Sure, that happens. The police arrest who they think they've got probable cause to arrest. Everyone makes mistakes. Our goal is to try to get that innocent person out of here as soon as that can be identified. You guys got to go. I'm getting a definite high sign. Thanks for your time.
Thank
You are.
So thank you all for sticking around for that. Mr. Webb, why don't we get some of your announcements, and then I've got our monthly bench meeting that starts at 12:15. I have to present on one thing, and then I'm going to come off that call. So I'm going to give folks a lunch break while I go deal with that. And then we can come back, and I know we've got a plea in Hinton and hopefully still Henderson. I don't know if Mr. Majeski quit on us. I don't blame him, but good. So we'll take care of those, please. We have an afternoon calendar as well. We'll deal with that as well. But I see Henderson and Hinton as still being out there. I need from you, Mr. Webb, your announcements. Let's go through this in order. So Mr. Peck, you're gonna work closely with. Good luck with that.
I'm a little bit confused because of the other cases, and I don't know, I'm not representing him on the 20 SD.
You're representing him on the one that's gonna go to trial first, so that's what matters.
Okay.
What's happening with Jamariel Thompson? He was the gentleman who was here. He came a little late, but he showed up. He's on bond, co-defendant with Norris.
Is Norris the one that picked up the murder?
Yep.
Case, Your Honor?
You're just gonna hold tight with him until, okay.
So we see what happens.
All right. How about Mr. Roberson? That's Ms. Marable's co-defendant.
Right, I thought I heard an announcement that that case, Ms. Marable's case might be resolved.
You did hear that announcement? I'm asking you your announcement on Mr. Roberson.
Well, I'm not ready to resolve it, that's for sure.
Okay, so it should stay trial ready.
Yes, sir.
All right. Mr. Tolbert, co-defendant with Mr. Williams, murder case.
Right, that should have been trial ready, although he wanted to pass the state to a plea office.
Okay, we've got the right people in the room. Ms. Boyd, we delayed. Antonio Brown. That is Antonio Brown.
I would like for him to be brought in to the courtroom in the state to put their offer on record to him. He's young.
Okay.
He needs to understand the offer rules.
We'll do that before we break. And then Mr. Robinson, one of the co-defendants in the jewelry store robbery where Mr. Collier just pled and got 20 years to serve. I think Mr. Robinson is allegedly the guy who actually smashed the cases and took stuff out.
That's not what I was told in an interview with his mother. I will have to get him trial ready on that. I need time to get that case ready, Your Honor. But I'll do it in the course of the year.
Okay, he may be the last man standing. That may influence what he wants to do. Benjamin Brown.
Mr. Brown is in a posture where he needs the discovery in his case, I think.
This was the empty folder you got. Okay.
Yes, Your Honor. I didn't want to throw in.
No, I just did. That helps me understand where we are. So, do you now have the discovery?
I think as of this morning, I think Ms. Hall emailed it. We haven't had a chance to look at it.
Okay, but you've got it.
I've got it.
Okay, then let's bring Mr. Antonio Brown out, please.
Getting Mr. Antonio Brown out. I'm happy to wait for this after the break, but could we bring Ramel Williams out just for your honor to let him know he's on December 14th?
Yeah.
For a trial, I just.
That would be helpful.
See you.
Okay. Is he gonna need to talk a lot or?
No.
Okay.
He asked if he would be brought out and I said that I thought that.
All right, good. It's now afternoon. Good afternoon, Mr. Brown.
Good afternoon.
We're going to get on the record real briefly. In your case, which is position 28, it's 20 SC 174164. I'm going to ask Ms. Hall, who's the prosecutor who has your case, to share with me what the state's offer is, so I can make sure you understand it and that I can understand what it is you want to do in terms of working the case out or going to trial, okay?
Yes, sir.
All right. So Ms. Hall, Mr. Brown is charged with armed robbery, aggravated assault, and possession of a firearm during the commission of a felony. I think I'm familiar with this case. This is the Lenox Mall where the woman was shot, I think, in the stomach as a result of the situation. Those are the allegations.
Right.
Okay. Tell me what the state's recommendation, if Mr. Brown enters a guilty plea, is.
For the armed robbery charge, you're gonna be 20 to serve 15, balance on probation, 10 years to serve on aggravated assault, and 5 years to run consecutive to count one.
All right, we're back. So it's 20 to serve 15 on the armed robbery.
Yes, 10 to serve on aggravated assault, and 5 years to run consecutive to count one for the possession during the commission.
So total sentence of 15 years in custody followed by 10 years on probation.
Yes.
Is Mr. Brown in a position to be recidivized if he goes to trial?
He is not, he has no prior conviction.
Okay, so if Mr. Brown enters a guilty plea, 15 years custody followed by 10 years on probation. This offer is open until,
Sorry, I was thinking. So I would like to,
he's on the calendar for the 30th
correct.
for a trial.
Oh, probably another 2 weeks, Your Honor.
Okay.
I'd just like to know so I can prepare for trial.
Sure.
Our victim, she moved away from Atlanta because of this incident, so I would like to make sure she has time to get here and all that if we're going to trial.
Understood.
So I'll say 2 weeks.
Okay. So Mr. Brown, first question, do you understand what the state would recommend if you entered a guilty plea?
Yes, sir.
That you'd serve 15 years in custody followed by 10 years on probation. You understand that?
Yes, sir.
You understand that Mr. Webb is not required to recommend the same thing. He could recommend something less. Armed robbery has a mandatory minimum of 10, so he could not recommend less than 10, but he could recommend something a little less than 15. And in the end, I'm the one who decides what the sentence is. So Ms. Hall will tell me what she thinks. Mr. Webb will tell me what he thinks. I'll decide what your sentence is. You understand that?
Yes, sir.
Do you understand that if you enter your plea now or in the next few days before the state withdraws its offer, you can withdraw your plea if I sentence you more severely than what your lawyer asked for. So I'm going to make it up. Mr. Webb says, you know what, it shouldn't be 15 years, Judge, it should be 12 years. And I disagree with him, and I agree with Ms. Hall, and I sentence you to 15. You could back out, no questions asked, because, hey, I was willing to do 12, but I'd rather go to trial if it's going to be 15. You'd have the ability to say, no, thank you. Do you understand that?
Yes, sir.
Do you understand that after this time expires, you can still enter a plea, but you will not have the ability to withdraw your plea if you're unhappy with your sentence? You understand that?
Yes, sir.
And of course, if you go to trial and you're found guilty, I don't know what the jury will do, but if the jury finds you guilty, you don't get to withdraw anything. If I hear all the evidence and hear from the alleged victim and whatnot, and I sentence you to 25 years, that's your sentence. I'm not saying that's what I do. I might give you 10 years, but whatever sentence you get after trial, that's your sentence. There's no withdrawing anything. You understand that?
Yes, sir.
Okay. Any questions about anything I said?
Yes, sir.
Mr. Brown, is it your decision to enter a plea today, knowing what the state's going to recommend, or do you want me to keep your case on the November 30 trial calendar?
I would like to keep it on the trial calendar.
Okay, that's what we'll do. We will get you back here on November 30th to pick a jury and go forward with the trial. Yes, ma'am.
My apologies, Your Honor. No, I'm serious. Your Honor, I meant to say 2 weeks before trial, so
Yeah.
I would like to change that to 7 days.
Sure. So we're clear, Mr. Brown, the state is leaving its offer open, the 25 to serve 15, for a week. So through next Thursday. If between now and then, Mr. Webb says, I've talked with Mr. Brown and this is what we're going to do, you can take that plea. After that date, all bets are off. I don't know what the state will recommend. And that's when your ability to withdraw your plea expires as well. So you got 7 more days to be thinking about it. If you want to be able to withdraw your plea if you don't like your sentence. After that, like I said, I'm happy to take the plea, but you wouldn't be able to withdraw. And you've got the fallback of trial on November 30th. So if things don't work out the way you want them to between now and then we'll get you in front of a jury and the jury will decide if the state's proved the case and we'll go from there. Any questions about anything I just said?
Yes, well, not about what you said, just have questions. Okay, I understand about the serious of this matter and everything like that, but 15 years to me is too long. I know about this situation, it is serious and a person got hurt and this shouldn't happen at all, but can I try first offenders or something?
So a couple things. One, you cannot get first offender for armed robbery. That's just the law is armed robbery, no first offender. Second, Mr. Webb is free to argue basically what you were arguing, that 15 is too much. He could argue 10 is the floor. You can't go below 10 on an armed robbery. That's the law. I don't have that authority. But Mr. Webb is in a position to articulate to me why 15 is too much. And I will listen to that. And you get a chance to say something too. The state has a different perspective. I'll listen to that. Ultimately, I decide, is 15 too little, just right, too much? And I'll tell you what the sentence is going to be. So there is a chance to do that. Even if you go to trial and you're found guilty, you'll still get a chance to say, hey, this is too much. And it should be something different from what the state's asking for. You always have a chance to be heard at your sentencing, whether you do it now, in a few days, or after a trial. Okay? Any other questions?
No, sir.
All right. I got to go. So if you have anything more you want to talk about with Mr. Webb, you can do that. Otherwise, he'll be in touch. Just know 1 week from today, the state's offer expires and your ability to withdraw your plea expires. Okay?
Yes, sir.
All right. Thank you.
Have a nice day.
You too. If you could bring Mr. Williams just to the door. And Mr. Webb, did we cover everything or do we need to bring the other Mr. Brown out?
No, I don't think that's necessary, Your Honor.
Okay. Then my request would be that you focus on that Mr. Brown.
I will.
We've got the other Mr. Brown on our trial calendar for Monday, but that's the one where you just got discovery. So I need to take that off.
Yes, Your Honor, I would appreciate that.
Okay.
I will diligently work to get the case ready, but I need a little more time than we get.
Okay. Understood. Thank you.
Judge, when we're talking about Mr. Webb's case, is Robinson appearing on Monday for trial?
TBD. I will let you know before the weekend.
Okay, thank you, Judge.
Sure.
Could I ask the state how long we might anticipate that trial might last?
It'd be relatively short trial, less than a week.
All right. Anyone else, you're free to go to a lunch break. Someone needs to stay for Mr. Williams from the state side. I'm just going to tell him right there. Mr. Williams, how you doing? I am well. I just wanted to let you know where we are in the process. Your case is as promised on our trial calendar. And I have a couple trial dates coming up. And your case is on for December 14th. The prosecutor, Mr. Abate, has said he's ready. Ms. Patel, your lawyer, of course, has said she's ready. So whether we reach it or not, I'm not sure. There's an older case, believe it or not, than yours that's ahead of it. But you are on for the 14th. I just want to make sure you heard that from me as well. Okay. So that would be the day we'd have you brought back over here if it's going to actually go out. And Ms. Patel, keep you posted on that. Okay. All right. Thank you. Ms. Nelson, are we keeping this same Zoom session for our afternoon calendar?
Yes, sir.
And
All
so
right.
I'll have to connect those booths. I think it's booths.
All right, I'll let you do that.
What time?
You make
If-
me the host, Judge?
Sure, I'll make you the host,
Okay, thanks.
please.
How long is it?
I'll be back at 1. I'd be back before then. I just given Ms. Young till 1.
I wasn't sure if that was one or hold on.
Oh, 1 o'clock. All right, thanks.
So based on the fact that it's
That's why I told you that. I need to hold her. Work things out.
That's right. I don't see any way I could be effective when they in trial.
Look at the video, let me know, look at the video with you, model, when you guys do it.
It'd be great for me.
I don't know.
I would know about if you do all of it.
I mean, you know, the case is what it is. I can't change much about it, but it's, you know, it just depends on it. They don't like it. I got it.
You're gonna grab her.
So. Murder. No, felony. But like, I mean, only because the shootings, but every, the witnesses have to. Yeah. Yeah. By yourself, 45. Side hip. I have there.
I think that's the legal province. I don't know.
Yeah, I think it's. Actually, you're. So yeah, I feel like I'm just gonna work on her so I can focus on Williams.
I told Ms. Nelson I won't.
Oh, no, no. I don't know.
Sorry, I have for Robinson. Who did you just brought out? Yeah. That was the other one. Okay. Brought out. Well, was not the same week. That was the wrong week, right?
You know, if there's any shakes out there.
No.
Buddha's got, jerk chicken today. Hopefully I get the wings, if not, I'll take the regular chicken.
Yeah. Too many Williamses, ah! I don't know.
You got the wrong
Yeah, it was the wrong Williams that was brought out, who also has dreads like my client. That wasn't Ramel. That wasn't Ramel. I don't know. I was like surprised.
I've never met him.
So let me go in the back and see if he wants to. Can I go in the back and see if he wants to be brought out? If not, then I can just update him and.
So this happened.
And then like the other one goes down.
So, I don't know, I'll present it to you, but even with that, you know, you have everyone here today, so maybe come out here and look at the video and decide if he doesn't.
I know exactly.
So, yeah, no. Benjamin Brown is first out on list. Antonio Brown will try, but he doesn't decide, he won't take plea by next Thursday. I just think it's nothing, I'll let Lacey. Yeah. I mean, all I essentially do is, I was sitting by a person I can see. Yeah. And so I would potentially have him give us a broader, because this is the guy who's shot her. Your guy is the one who actually shot her. So, you know, but my thing is, the judge is giving you an opportunity to be wrong. So, they're always having to do that, and it's 10 years, he didn't, oh, I said, and go ahead, it was going to trial, I don't know anything he's gonna get.
Did they send it back yet?
No, make sure they don't send them back, because you know you're supposed to be talking to both of them, so. Or Benjamin Brown.
Or Benjamin. I had already told him he said that sent it.
Right, but so Benjamin Brown is tried because I don't think the judge cares whether it sounds like.
So he wants me to go in this a weekend. Try to.
No, or maybe.
I told the judge, I thought he's got a letter from the doctor. No.
No, I understand. I understand. But I think Benjamin is not on you.
Yeah.
Right. And he's on camera. So I changed on the offer, maybe bring him, I can show him the video.
Yeah.
They don't read this stuff.
Let's do that.
And then he can make a decision whether he wants to take that.
Because that's
He
part of
is
it.
out today. You know, I'm giving him the time he served 5 years. The time he served 5 years. He
Just noticed.
He served.
I didn't know.
Yeah, that's right. Yeah, no, remember I changed it from 8 to 19. I made it 5. He's already served, so he didn't get out on probation. So just let him know, you know. But maybe he wants to see his discovery, show him his discovery, but let him know the offer has changed.
Okay.
You know.
All right, thank you for that.
You're welcome.
I know, Right, exactly. Oh my God. But you know, even with words. He's been. Oh, yeah, exactly. Just even. You know, exactly. Exactly. So I'm gonna run. I need to go try to make sure I get these numbers for you with her.
Thank you. Do I have to leave? Okay.
Ms. Wood, if anything changes, please let me know.
Absolutely. Thank you so much. Thank you so much. I don't know, what time did he say he was coming back? Like, well, then there's no point in me leaving either. Do you have the 1 o'clock calendar with you? Marcus Brown, I think is one
Yes, we do have an afternoon calendar at 1 o'clock, guys.
Miss Nelson.
Yes.
Hey, I'm so sorry. I left. I thought I would have time to go get my afternoon calendar for my office. Do you know, is Demarcus Brown on this afternoon calendar or tomorrow's calendar?
He is, he's on today's at 1 o'clock.
Perfect, thank you.
You're welcome.
Mr. Robinson. Appreciate it, thank you.
I'm sorry?
Do you have Mr. Robinson?
No, what's his first name? So Mr. Webb, I think he's actually back there talking to him right now. The gentleman that's the Friday.
Yes.
So that's what we representing. The record mistakes. Wow. I think they were actually.
Miss Nelson, are you there?
I think it was a different one. 'Cause you
Yes,
have-
ma'am.
Hi, I did not get the email
Oh,
I'm pretty sure it's.
for Zoom.
okay, I'm sorry.
That's
went on
okay.
to
I
doing-
know how super busy you are.
I had started to do something else and I was like, oh, okay, here it is. Let's see, paste. Nope, that's not it. Okay, I'm sending it right now.
Okay, great.
One
Thank you.
second. Mhm.
Appreciate you.
Yes. I can't say much because we're still on YouTube. Yes. But, you know, I'm sorry that the previous attorney didn't miss it. Right. So I have to come back. We're coming back. So that's what I'll be back next time. So I'm gonna come back, but he said one, yeah. Okay. So I'm gonna grab some lunch. Okay. I'm trying to get to Boston to see.
Yes, sir.
Oh, you have to come back. I'm just gonna say. Do you want me to, is your plan that, or do you want me to like? move it up? Okay. I don't want to put that on you because you'd just be like. Yeah. Right. Okay. But I'm trying to think of what's close. Whatever, I know I'm good with this. Paris just said like food set up somewhere. I don't know, he didn't say where, we should flew out. Food is set up. Food out, like the. Oh, what, really? Yeah, he said it's like chicken or something. Actually, you know, I'm just gonna get a soda and a bag of chips and that, I'll be back, but I'm gonna leave my jail bag. You're fine, yeah. Jeez. Hola. Hola. I'm sorry, do you know how you log into this? I don't have the access code because I was coming to court today, but it is, it's on YouTube. So if you go to Fulton, I think it's fultoncourt.org, and you click on live hearings, and then it'll show like all the judges, and you click on Judge McBurney, and it's all streaming. Oh, it's on YouTube. He might have paused it while we were discussing with the leadership planning team, but it's live streaming. I'm just going to see. No. What was that? Thank you. Thank you.
Is he represented by agriculture? If it's, he's been.
Yeah, I think.
That one can go back, yeah,
Yeah.
because Walter had like a.
Yeah. But he puts it clearly, like.
Right.
Yeah. So yeah, I don't know what the footprint is. I forgot to say about you, or not, you want to go back.
What about Mom's back there.
Yeah.
Let me talk to him. I wasn't going to, but I can talk to him.
All right, so then you just put on, you got 30.
That's fine, I'm just reminding him. What we're looking at. Good, how are you? So I'm sure the next step, I'm gonna get to the. I'm gonna concede. Stop.
So what you want to know?
They said somebody in court, they said the trial starts Monday. So when they call me.
No. He wants to see this. The chassis called me.
Robinson.
Yes.
Okay. We have to be back Monday?
Yeah. I can't remember if the judge said he was on the calendar. Yeah, he was, let them know that's, yeah, he'll let us know. Yeah. So you can go.
Cool. Good to see you, Miles. All right, hang in there.
Thank you, Mr. Webb.
You're welcome. So we'll just keep. So these comments back. I can show them this. What? Well, she has a video for him to see. I don't know if she. Maybe back with the jury. How about back there?
This is possibility.
Can you just hold up? Did you put it in the catch bench?
Yeah. So we'll get right up.
Okay, good. I'll stay here.
Yeah.
I don't know why, the judge told me out of this 30-something cases on the calendar, 10 of them were violent, 4 of them were murder cases, 1 was rape. And the judge told me that he put all my cases on the calendar because he knew I wasn't going to be around. So in January.
First floor, so take the elevators down and make a right and then a left, and you'll see a sign that says cafeteria dining, and they have that. I don't know if they're ever gonna be open or. That's it. Last name is what you're asking.
Yeah. Why don't you cheat? Makes it listen. I think the first, one of the selection,
I just think you brought up the wrong Williams, so my decision for to say the same thing again.
And the first one, they, I filled out the sheet and everything, and she's, oh, wait, it's on the table. So I said, okay, this is the other thing. So I came back and she said, well, we're short-handed and I can't find it. What it is. I said, tell me. I told you, can't find it.
Right.
And this is after 17 others. So I left. I went back. And then they'll have the same thing, or to the kids. So up there, the guy who leads this went to McPherson. So I told him, you know, my client was, this is what I looked at. I sit there until 8:15. So I go back downstairs to the front desk. I need to see. So she says, we call there, and she calls up there, she says, well, we promise you, he's in the field, ahead of this time. I said, I'm going up there, I'm gonna walk her. I'm not in 2 weeks, so she said, okay, we call. She comes in, she said, he's here. So I go up there, wait to fear say there. Guys, he's on for probation revocation tomorrow. He's got 2 cases and 3 probation.
they don't have a room upstairs. They do it late.
The vents, the bathrooms are still not, they've been out.
Oh, I was there.
Since last week. I'm surprised. The people are nice enough. They're always very polite.
You should use that downstairs room and make them bring them out, so you don't have to take them, walk her to the elevator. There's a room, so when our clients have walkers or wheelchairs, rather than having, because they can't take the stairs, if they do. There's a room like right when you're at the presentation, you make a right, and it's like right there, it's like, there's a room that it's, I don't know, it's not really a room.
Yeah, it's like this weird little like code, it's like right by the bonding stuff.
Right by the bonding stuff, it has a door and everything.
Yeah. Yeah.
They won't tell you that.
Right,
You
I
have
was
to,
saying,
you have to
yeah.
ask for it.
The one reason I do not think is that one that you together. And I talk to them, they say, oh, we have this room.
Has your guy's family left?
I just talked to his mom. Yeah.
Yeah. Because it's short, they should, right?
Well, that's right, so that's separated. Yeah. so, Separate sheet. Drug, search warrant. Search warrant.
That's great.
Yeah, I was really happy, I was shocked.
Yeah.
And, so, all those things.
Great.
No. You're right. Yeah, you're right.
No. We'll use the offer because I can't use it. It's closed or frozen. The offer takes some pressure.
Yeah.
Sometimes it's better than understood. Oh, so
Right. Right.
what? Too late. That's. You good?
2018.
I'm gonna go to general. So. You say what?
Well, readers up and down, they transfer. Everything's on. So when cops get such a huge backlog of indictment cases, so they took forward some of the most challenging cases and transferred them to Judge Reader before readers started as Judge Jackson. So they achieved that. They. Years later, you know, and just get everything, right? Why do I? I'm sorry, this judge chose transfer. And then now he has a whole thing. I mean, it's really. Yes. This is my feedback. Yeah, it's a match like 5th and 6th. I'm just Supreme Court case. I asked her, she granted me. As a question. So I could write it down, it's like 20 ever. All of these. Just being church, gives your idea tomorrow. I'm taking the car, like, what it to, you know. And they start having, and my client is up forever. Any reason. Great emotional consider. For the market, especially. Now. everybody knows.
Oh, boy. Can you make me the host again, please, Ms. Nelson? Thank you.
Judge, are you back on the bench?
Not for, I mean, we're starting.
Can I pass this off? I forgot to
Please,
give it to
yeah,
you.
yeah, yeah. No, I'm back on the bench and I wanted to get a sense from you or Ms. Patel how some of these probation revocations are gonna flow.
Perfect.
And then we can get rolling. And we've got 2 pleas, we've got a bond hearing and some probation revocations, 1 plea and ring.
Your Honor, so Ron Williams was brought out, so Ramel Williams still needs to be seated.
They didn't look like.
Yeah,
I was like,
I don't think that's my guy either.
okay.
We took him down. He was okay with it.
He may have been thrilled. He may have been wondering what the heck, like, I don't have a trial. Who are you talking about?
Well, he just had a question about his habeas, which
Ramel Williams, is the correct Ramel Williams here?
he said that after, he told the deputies he was comfortable, I guess, going back down after speaking with me.
Okay, so I'm clear. The correct Ramel Williams appeared. You spoke with him. He's good. He gets it that on the 14th. He, and not this mystery Ramel Williams, who's not Ramel Williams.
Right.
Okay, I wonder whose defendant that is.
That was,
Oh. Oh, I hadn't seen him in forever. Okay. Got it. He does have a trial. I was off by a couple weeks. He's November 30th. Good. Okay. Well, so it was a Williams and he does have a trial. All right. I'm glad I didn't say anything about Ms. Patel. So Timothy Fox, who's handling Timothy Fox?
He's fine, Judge.
Okay. Is that something that you and Siri Patel have discussed? You need to discuss with her?
Judge, I was gonna ask for a reset. He's got 2 new felonies. He has quite a bit of probation left on this charge.
Okay, and that's all good. We'll get him out here to do that, but you don't think it'll be resolved today?
Good.
I just want to make some notes as to what to expect. DeMarcus Brown. Oh, that's yours?
Yes.
Okay, and we'll need Ms. Hall for that. Quadravius Berry.
It's listed as gray, but I believe he's got new cases that have Roderick Bridges on. I'm not
Okay.
sure.
All right, that sounds familiar. How about Dontavius Barber? Ms. Madden. Okay.
Good afternoon, Judge Leah Madden on behalf of Mr. Barber.
Hey, we're not doing anything. I'm just figuring out who's got whom, but thank you, Ms. Madden, for being here. How about,
310.
Lonzie Johnson?
To go and.
Okay. And is that simply waiving arraignment or more? TBD?
Thank
Okay.
you.
And then, Mr. Cullen, you are here for Mr. Yancey. Great. Okay, and we've got Mr. Abate for that. So my thought is we can leave out Mr., just so we get some folks off the booth, we can take care of Mr. Fox. Maybe Mr. Brown and Mr. Johnson. We need Ms. Hall. Can you all see if Ms. Hall's working her way back? Please. Thank you.
Mr., what's the defendant's name?
Which defendant?
The last one.
Hey, this is Lieutenant Barry.
Yancey?
Can y'all pull Quadravius Berry out of two?
Hey, you.
Yes.
In place of-
It's a rehearing of bond motion. This is the guy who, did you-
It was an unindicted bond.
yeah, it's unindicted. It's the three brothers. They get out of the car. I watched the video. Mr. Cullen watched the video and had a very distinct sense of what ought to happen because of that video that differs from mine. But we're going to talk about it with Mr. Yancey zoomed in. Yes. What was your question?
I didn't know it was on today.
Oh, it's position 6.
Yes. From last week. And I just
We're doing other things. It's okay. You're familiar with it. I don't believe there's anything new other than
Berry, how you doing?
it's watched, and we need to have an on the record discussion about.
Ricardo Johnson and 214. Lonzie Ricardo Johnson.
All right. What about, did we lose?
Number 1 for the judge.
Oh, we need Ms. Hall. Okay, but we certainly have Ms.
Booth 1.
Ms. Pondry. So I think what we're going to do is
Thank
knock
you.
out a couple of the quick Zoom ones, and then we can turn to that. How about though? Well, you're just asking for a reset on Fox, so we don't need Siri Patel. We've got a prosecutor in here. Okay. All right, let me turn that on. Good afternoon. Who is it, Lieutenant Dooley or Lieutenant Barry, who's going to be my guide for our booths this afternoon?
Good afternoon, it's Lieutenant Dooley.
Hey, Lieutenant, how are you?
Really good, how are you?
I'm hanging in there. We've had a busy morning. We got some spillover from that, but we're gonna, I think, be able to knock out a few of our booth occupants. Do you have them appearing in a certain order, or are they on different floors so they're all ready?
They're on different floors and they are not in the booth. I see one person in 6 North. I'm calling the floors now to get your, get them in the booth so we can get them seen.
Okay, and 6 North would be, who is in now?
It looks like position 6.
Okay, he's gonna need to sit tight. That's not one we're doing right away, but he should stay there. That's great. Okay,
Okay, I'm gonna put you on mute and call the other floors.
great, thank you. Ms. Madden, have you had a chance to talk with Ms. Hall about Mr. Barber's situation?
Yes, Judge, we did speak. She provided me with copies of the police report and she sent me late yesterday a video which I need to show my client. We've talked about working something out to resolve both the underlying charges as well as the probation revocation. So I think we're close. We were going to request at least another week and I think we may have a resolution to both.
Okay, well, when we get Mr. Barber in a booth, let's do that, and you guys can certainly have a little more time, especially if it would resolve both things. Is the new case indicted, or is it something that Ms. Hall has indicated she would accuse as part of the effort to close this out?
It is not indicted. I'll let her speak to that, but I think she, if we're able to consent, that she can probably just accuse it. She just needs to get with her victim so she can give me a firm recommendation. And like I said, I do want to go over the video with my client. I'm gonna probably have to go in person, make arrangements to bring my computer to the jail so he can see it. But like I said, I just got it yesterday,
So I can offer this up if you, I don't know if you can share screens in a breakout room. I could put you and Mr. Barber in a breakout room once he gets in his booth, if that's a way for you to share the video with him.
Actually, that would be good. That may work.
Why don't we try it at least? If it doesn't work, I mean, I don't know that I could figure it out. You may be able to figure that out, but I can certainly get you and Mr. Barber into a booth, and then you can have a conversation and see if you can make that work.
Okay, thank you, Judge.
Sure. So Mr. Yancey is there, and that looks like that's it so far. Hello, Ms. Hall.
Hello, Your Honor, my apologies, I was stuck in the clerk's office.
No problem. Do any of you on your screen have a live transcript going by? There's this new feature that has shown up. There it is. That's terrible. Yeah, how do we turn that off? It's this new thing that suddenly. Yeah, well, I'm sure. I just don't know how. I will learn that and we'll turn it off. That is not something that I have intentionally activated. Live transcription. Wow. It's like we're at the county commissioners meeting again. Oh, here, look at this live transcript. Disable. Oh, nice. It's gone. All right. You shouldn't have it anymore. You're all welcome. I wonder why that turned on. Mr. Webb, do you have anything else? Or are you good?
Well, Your Honor, I wanted to get the discovery from Ms. Hall for Mr. Benjamin Brown.
Great.
Because she had changed her offer, I didn't realize it. I conveyed it to him, the new offer, but he still wants to see the discovery. And then he makes a decision. So I asked the deputies to hold on to him if there's a place I could do that.
Great. I don't know, is the discovery handable or it's electronic?
Well, there's paper discovery, but probably what he wants to see is the video of it.
Okay, so that's not gonna happen here. Did Mr. Majeski disappear?
No, he was, when I left, he was outside, he was in first appearance court.
Okay,
He believed that was gonna be a while.
okay,
I told him we were running into our 1 o'clock calendars.
Right.
It would probably be a while as well.
Okay.
I think he's still here, he's just on that time.
great. DeMarcus Brown, which is position 2 on the afternoon calendar, is that a resolvable situation or?
It is, and that's what I was at first office trying to handle. We're gonna do a global resolution on it, and we're gonna get SC number today. We're actually about to do it then, but I had an error on my accusation, so I came here first. Whenever we're taking another plea, I'm gonna run and handle that.
Great. Well, my guess is Ms. Convery and Ms. Young will take a few minutes, so that's when you can do it. Mr. Barry, have you been interacting with Mr. Bridges on that case with no one? Don't know? Okay.
It's still unindicted, and I'll focus my attention on that. I know it's been a while, but
Okay. Mr. Barber, Ms. Madden is on the call and she shared with me that it's probably workoutable where it would be resolving both the revocation and the new charge that you'd be accusing, but that wouldn't be today. But there's a video Ms. Madden wants to share with her client, and I'm going to drop them in a breakout room to see if we can do that. But you agree with the timeline that not today, but hopefully really soon?
really soon.
Okay. Good. Well, if you prioritize cases that are actually indicted in this unit, that'd be good too. Are you handling number 5, Mr. Johnson?
Number 5, yeah.
That's a plea and arraignment. So
Yeah.
all we're doing an arraignment plus. There's something that we're going to talk about.
Right.
Okay. That's it for your stuff. Okay. Well, we're just waiting on people to start occupying these booths. Oh, there's Mr. Fox. Let's do that. I'm going to turn, so 3 South.
And Your Honor, that concludes my business. May I be excused?
Yeah, what were we still, it was just to let me know about the real Ramel Williams?
I thought he wanted to be seen, but he did not.
He did not. I mean, he wanted to be seen by you. Mr. Fox, can you hear me?
Yes, sir.
Great. I'm going to spotlight you for a sec. We're going to go on the record in your case, Mr. Fox. This is case Z 89781, and I have a probation warrant that a colleague of mine signed at the end of August that alleges that you committed a couple of crimes in May of this year. So those are the allegations that would be the basis for revoking your probation. I have Ms. Wood here in court. She's waving at you. Can you see her waving?
No, all I see is me.
All you see is you. I'm going to unpin you. I just thought it'd be helpful to have you right there. So
I can see both of you now.
great. So there's Ms. Wood. You don't need to see yourself. You know what that looks like.
Yes, sir.
So I'm going to let Ms. Wood share with me and you, more importantly, her thoughts, and then we'll see if the state has anything they want to add to that. Ms. Wood?
Thank you, Judge. I did speak with Mr. Fox last week, and then I spoke with the state yesterday.
State being Siri Patel?
It was actually Cassie.
Okay, great. Ms. Hall?
But he has 2 serious felonies that are the basis for this revocation. So I am asking the court for a reset. I'm hopeful we can come to a global resolution. I just need a bit of discovery and to go back over everything with Mr. Fox.
So I noted from the petition, they're both arson allegations. Are they, other than that they're connected to Mr. Fox, are they connected in some way, or they are unrelated events?
Yes, Judge.
One building, sir.
Well, yeah, Mr. Fox, you don't want to say anything right now.
Judge, I think there's also an aggravated stalking that's related,
Okay,
that's also floating out there.
Okay.
It is all related, yes, Judge.
got it. Fair enough. So you're going to do a little homework, but you think perhaps the state may be in a position to say, here's how we handle everything.
Yes, that is our desire.
Okay. Mr. Fox, I am comfortable with that request. I think it makes a whole lot of sense for you to try to resolve things all together rather than in piecemeal. If in the end it's going to be piecemeal, I'm all right with that. But what it would mean is that we would have a revocation hearing at which the state has a much lower burden of proof to convince me that you did any one of these alleged crimes. I wouldn't be finding you guilty of those crimes. I'd be finding by a preponderance of the evidence that you violated the conditions of your probation. But then I could revoke some or all of your probation, and it's my understanding you've got a lot left. So I'm going to give Ms. Wood that time to work with the prosecutor and obviously to consult with you. It's your decision in the end. See if there's a way to resolve not just this revocation piece, but these new charges and whatever they're mixed up with. Do you understand what I'm describing, Mr. Fox?
Yes, sir.
All right.
Can I talk to Ms. Wood when we're all done?
Yeah, we can definitely do that. She's got a couple matters that she needs to deal with right now, but then if you'll stay in that booth, Ms. Wood could dial in on her phone and I could move the two of you into a breakout room, okay?
Yes, sir.
So you stay put and we'll connect the two of you, all right?
Yes, sir.
Thank you. All right, do we have? Yes, we've got a few more folks. 5 South. Hey, good morning, good afternoon. Who's in 5 South?
Here.
I can. Who are you?
Quadravius Bear.
Mr. Barry. All right. Mr. Barry, do you know who's representing you on you got some new charges? Have you talked to a lawyer on the new charges?
No, sir.
Okay. Well, Ms. Hall, I'm not sure who you've been dealing with, if with anyone, on the revocation. Ms. Wood saw that Mr. Bridges might be working on the 2 CP cases.
That's what I thought as well, Your Honor, but I haven't spoken with anyone, so I'm not sure.
Okay. She's got a decab case from almost 2 years ago and maybe something May. Okay. All right. Mr. Barry, we're going to try to figure out if we can find Mr. Bridges, who may have been looking at your cases. Can you stay put where you are?
Yes, sir.
Great. Thank you. Ms. Nelson, can you reach out to Mr. Bridges, please?
I will.
Thank you. Good afternoon. Who's in 1 North? Yes, you.
108. 108 Johnson.
Got it. Mr. Johnson, good afternoon. I'm Judge McBurney. How you doing?
I'm fair, Your Honor.
Mr. Johnson, you have been indicted for aggravated assault. You are here today for your arraignment.
Yeah, all the regulars gone right there. Yeah, put them down.
Hold on 1 sec. We got someone on an iPhone yapping. All right. So I'm going to ask Ms. Wood, who is the lawyer assigned to your case, to tell me a little bit about what's going on, okay?
Okay.
Ms. Hall and I negotiated this case yesterday. We are looking for a creative solution. It's a virtual PTI offer. We just need to get program in place. I do have Ms. Patterson working on that. I just don't have the official placement yet.
Okay. But it would be a PTI type format where if Mr. Johnson complied with the conditions, this is a case that would be dismissed rather than further prosecuted.
Correct.
Thank you.
So, Mr. Johnson, it sounds like your lawyer's been coming up with some pretty creative thoughts about how to work through this. She needs a little more time to work with her colleagues who will be looking for the things you need to do to satisfy the prosecutor that things are going all right. And then it sounds like the prosecution will freeze your case while you do those things, whether it's get counseling or do community service. And I don't know what it is, so don't quote me. And once you do those things, the state would dismiss your charge. Does that make sense?
Okay, what do I have to do? Because like I was telling the other guy, I don't want to lose my things in the storage bin. I've been in here almost 5 or 6 months now. And something, like I said, I'm the one was aggravated. And, I was explaining to her, I get tired of that each and every time. This is not my first time coming in with all this. And like I told her, I cannot take this pressure every day. This eye swirling going back. I mean, my eyes are uncontrollable. I asked to see the doctors or something to look up my backside. It's just a whole bunch of stuff going on, Your Honor. And I would like to get out to take care of it.
Okay.
It's hate crime and discrimination in the dorm that I'm in. Like I said, I'm going through a lot, and I explained that to her.
Okay. I'm hearing you loud and clear. And I also heard Ms. Wood loud and clear that she senses your urgency and that she and her colleagues are working pretty hard to find a program for you. None of us are going to let you out. There needs to be something to which you're going. And I'm going to let Ms. Wood have a little more time to do that.
I can't be let out. I have to stay in here.
Well, today is not the day for that to happen. It sounds like it's in the next few days. But again,
thank you.
Okay. So we will get you either back in one of these booths or we'll bring you over here to court to make this happen. And it may be we don't even need to make you come to court if the prosecutor agrees to what Ms. Wood lines up. I just need to sign something. That'll get you out and you can go about your business. Just need to be smart about it, okay?
What's going on?
It broke up. I can't hear you.
I'm sorry. Ms. Robinson spoke over us. We just need to make sure when you get out, you're smart about what you're doing, okay?
Okay, thank you, sir.
All right, Mr. Johnson, you take care. You're free to go back. We will get you out soon.
Okay, thank you.
So the expectation is virtual PTI, and you will keep working on it. I guess just so that folks don't forget, not that you will, but we'll put it on a status calendar in the near future.
Thank you, Judge.
Okay. So do you have anything else, Ms. Wood, or could we, I guess you got Mr. Brown. I don't see him there yet. So could I get you to step out, drop Mr. Fox into the breakout room once I see you on, and then we can take care of him. And my thought is, we got Mr. Majeski here. Why don't we do Ms. Henderson's plea while we do that? Mr. Majeski, I trust you're ready. So, Mr. Fox, once I see Ms. Wood having joined from her phone, I'm going to put you and Ms. Wood in a breakout room so you two can talk, okay?
We need recliners in the hallway for this attorneys doing hearings between live hearings.
We'll work on that with all the ARP funds.
Yeah,
I don't know that they're designated for the lawyers, but we'll see what we can do.
Well, I mean, it's a government project. They usually run under, right?
That's true. Always under. She should be right where the podium is, and just move the microphone towards her a little bit, please.
Appears to be connected to the.
Oh, no, bend the stop towards her a little bit. Yeah, thank you.
Serious.
Yeah, because.
Are we okay?
I don't think so, Judge.
Okay.
Um,
You need to talk to Ms. Hall, to me. Not you. Hold on. First, your lawyer.
Okay. I don't even want to have a trial. I just want to get another attorney because first of all, this is my first time hearing about a plea. This the final plea. I ain't got no discovery pad. I done talked to you 5 times. Just, I'm not gonna do that.
Judge, I'll tell you what. When you have me sit down for trial on this?
This case, well, first of all, co-defendant's pleading, and it's going to tell us all about Ms. Henderson. So Mr. Walker's, we were going to do that today, but he had to deal with something else. So it would be just Ms. Henderson, and currently it's for Monday. So we've got 60 jurors coming in Monday morning. Ms. Phillips was the one case ahead of Ms. Henderson and Mr. Reeves. I think it was in light of that, Mr. Walker and his client, Mr. Reeves, decided to enter a plea. And that's what Mr. Majeski had shared with me, that it was going to be a plea. Ms. Anderson, you of course make that final decision. If you're not interested in entering a plea, then
I'm interested in permission to speak.
Please.
I'm interested in hiring another attorney because when I just got back there, I haven't had a discovery pad. I've been locked up 2.5 years. I haven't had a discovery pad. This is my first time me hearing about a plea. When I go back there, this is the final plea. I don't know what the first plea was. I don't know what the second plea was.
well, there wasn't. We can just call it final plea. It's that there's no first plea or second plea. This is just.
But there was offers made, and I didn't know nothing about it.
Well, we've got the prosecutor right here. She could let us know if there've been lots of offers or if this was the only offer. This is a case that was held up for a while. It had nothing to do with your lawyer. It had to do with the witness for the state.
We were waiting on a tape. They said a tape recorder.
Could be. I just know there was something with one of the state's witnesses that had to get resolved before we could either decide, should this be tried, or is it a plea, or is there some other disposition? So I don't know if you want a little time right now to speak with Mr. Majeski, or what you would need to find a pretty special attorney who is ready to go to trial on Monday, because I wouldn't extend this. To your point, you've been in jail for a long time. So I don't know what attorney would be able to learn everything Mr. Majeski has about the case between now and Monday. But you've got the right to the attorney of your choosing that you can afford. So if you're telling me, Judge, you know what, I'll be there Monday, and Attorney X will be there, and Attorney X is not going to be grousing about the fact that he or she is going to trial the first day that he or she's been working with me, then we're good to go. If you'd like a little time to talk with Mr. Majeski, we can certainly do that. I got other things to do this afternoon, and then we can hear back from the two of you as to how you want to do this. But your choices are, you can do a plea today. You don't have to. But then if you don't, then on Monday, we will start picking the jury in your case. And Mr. Reeves won't be in the mix because he's pled. I mean, he hasn't literally pled yet because his lawyer had to go, but he has resolved his case. Yes, ma'am.
I'm also about recidivist, so she should be aware of that if we go to trial on Monday.
Okay, and Mr. Majeski can explain to Ms. Henderson all about recidivist if she's got any questions about that. Mr. Majeski, if you don't mind, spending a little time with Ms. Henderson back in lockup, then you can let me know if we're gonna go forward today or if there's a different plan. Thank you. All right, Ms. Wood and Mr. Fox, I'm gonna put you in a breakout room. Let's see if I can make this happen. Sound. All right, they're in a breakout room. Hopefully that works well. See if we got any of our other inmates. We still have Mr. Yancey and Mr. Bridges' client. Should we handle the Yancey matter right now? Okay, Mr. Abate, you ready? Yes. Want to do your thing? Mr. Parrish, I'm keeping you here for what? Or you're spectating?
I am hoping to get a resolution on the third co-defendant on the jewelry store / pickle jar case.
Meaning Mr. Webb's client or?
Hoping to get some information on Mr. Webb's.
Fantastic. Then you guys stay here. I'm open for business. All right, let me get Mr. Yancey front and center with us. That's 6 North. Mr. Yancey, can you hear us?
Yes, I can.
Great. Mr. Yancey, we are going to talk a little bit more about bond in your case. Your lawyer, Mr. Cullen, is here. Mr. Abate, who handled your bond hearing before, may not be the lawyer who handles your case if and when it gets indicted, but he's here for bond purposes for the state. He is here. When we were last together, Mr. Cullen shared with me about this case and how the allegations are that you and your brothers jumped this guy who ultimately passed away. It was represented to me that you were so drunk, you fell out of your car onto the street and never really got up until the incident was over and done with. The video that I watched and that your lawyer has watched doesn't show that. It shows something very different. And in light of what I saw in the video, I was not comfortable setting bond in your case. But Mr. Cullen appropriately pointed out that we all watched the video in a vacuum and not together. And so neither the state nor Mr. Cullen on your behalf was in a position to say, let me tell you why it's not such a serious thing, that thing you saw on the video, or why that's not my client, or whatever it is. So I'm going to give Mr. Cullen a chance to discuss that and anything else he wants to add on the question of bond. Then I'll hear from Mr. Abate and we'll go from there, but we're going to pause for 1 second. Ms. Wood, did you finish speaking with Mr. Fox?
Yes, sir, I think he left already.
Okay, that's okay. I just want to make sure that that breakout room is all done.
Yes, we are good to go.
Okay, great. Mr. Cullen.
Yes, Your Honor. I believe that's an accurate description of the video as you just described it. And at Mr. Yancey's last bond hearing on September 28th, the state promised the court that it could produce a video that would show Mr. Yancey was simply too much of a danger to be released into the community on bond. And our issue is the difference between what was promised and what the court received. The state described footage showing Mr. Yancey driving around, searching for the victim, finding the victim, attacking the victim. The attack is supposed to involve Mr. Yancey and his brother Gregory Yancey. And during or just after the attack, Mr. Gregory Yancey is supposed to step back, draw a gun, and shoot the victim. What we got was a videotape, Your Honor clearly remembers, that shows a scuffle from which all the participants walk away. A scuffle where it is impossible to tell if the victim of the shooting is even involved. Is the victim supposed to be one of the people who's on the ground wrestling around? Is the victim supposed to be the gentleman in white at the end of the video who seems to look toward Gregory Yancey and start to run? We don't know. Obviously, if the state had produced the kind of incriminating evidence it described at Mr. Yancey's first bond hearing, the evidence could serve to show that the court is correct in saying Mr. Yancey is a danger to the community and should be detained without bond. What the state showed the court is that Mr. Yancey lost a fist fight, a fight everyone walks away from, the same night his brother is charged with committing a murder. We don't know how close in time this fight was to the murder, and we don't even know whether the victim is actually involved in the fist fight. And these two things are essential for the court to determine under Ayala that Mr. Yancey is too dangerous or that he poses too great a risk of committing a felony before trial to be let out. Otherwise, the court is holding someone who has no criminal record to speak of, really, because the state produced a video of them getting into a fist fight. Now, the defense accepts some responsibility here. As we heard the video described, we believe that the video would show a fight ending in a murder, and thus we did not object to Mr. Yancey's participation in that fight as a reasonable basis to determine Mr. Yancey's eligibility for bond. The problem is the video we all agreed would decide Mr. Yancey's fate is not what we received a week after the bond hearing. We do not think a video of someone getting into a fight with another person, a fight from which all parties walk away apparently uninjured, is sufficient basis to deprive someone of the ability to remain free before trial, to do things like work, make their house payments, to effectively aid in their defense. Therefore, we respectfully renew our request this court grant Mr. Yancey's $25,000 bond, allow him to be on an ankle monitor under the restriction of a curfew if he is able to make that bond. Again, under Ayala, Mr. Yancey has very, very little criminal history. He is not a risk of flight. He has no history of violence. He's not a risk to intimidate witnesses or commit felonies before trial. The only thing holding him, it seems, and because we agreed to it, is this video. However, this video is not what it was represented to be. Thank you, Your Honor.
Question. Did you see your client in the video? Is your contention, yeah, that's my client, one of the three who jumped this guy, or not only is it not what we were told we would see, which is a fight culminating in a shooting. I didn't see a shooting either. And that may be a different segment of the video, but regardless, I didn't see a shooting either. Or is it, it's an interesting video. This could be from Toledo, Ohio. I don't see my client in there. I don't recognize that car, any of that.
Your Honor, I don't recognize that car. I believe from my interactions with Mr. Yancey that I could say with a reasonable degree of certainty that Mr. Yancey is in the video. And I am assuming that the person who seems to be in more control of themselves, who doesn't fall on the ground, as it seems Mr. Yancey does, who is kicking someone who is on the ground, I believe that is Mr. Gregory Yancey, based on what I know about his features. My problem with the video is that it simply does not show what the state representative was going to show.
Okay. Mr. Abate.
So I never once represented that the shooting was on video. That was never anything that I said during the bond motion. I indicated that the shooting happened a couple of feet outside of the view of the video, but the entire fight, which is what I said, Your Honor, and defense counsel, was captured on video. I have now since been able to get the entire night video surveillance, which I haven't had an opportunity to go through. But what I am told from the detective who has viewed all of the footage, that the shadows of the actual shooting, you can see it flash and then the victim go down, shadow on one of the angles of the video surveillance. But as I represented in the bond motion, I never once said the shooting was on video. I indicated that the defendant, who Mr. Yancey, Bobby Yancey, was the driver of the vehicle, and they circled, which can be seen on the video surveillance, over and over again looking for the victim. The victim was walking across the street, which is when, as Your Honor saw in the video, all three brothers immediately get out of the car and start assaulting the victim, who is then shot moments later. That is what I represented was on the video, and that was what I said to Your Honor and defense counsel. This is an unindicted case, and the state isn't required to produce any discovery to support the defense counsel, but did anyways. And I'm happy to know for sure over the rest of the surveillance video footage prior to indictment, and they can go through every single angle prior to indictment. No issue with that. But what I represented was on the video, was what I said to Your Honor, and I would stand on the argument that I made previously in the first bond motion, that Mr. Yancey is not an appropriate candidate for bond.
Okay. Mr. Cullen, your response, other than you remember differently what Mr. Abate said than what he remembers he said. I get that. There's a difference there. I don't have a specific recollection. Like you, Mr. Cullen, I thought there was some statement that the shooting ultimately is captured on film. To me, that's neither here nor there for your client, because never did Mr. Abate say, and it's Bobby Yancey who did the shooting. It's always been, it's his brother who did the shooting. And I think there was even a relative who said, I can see this is one brother, this is another brother. So I was not laboring under the misperception that somehow your client was the murderer alleged, as opposed to party two. What I took from Mr. Abate's presentation was that Mr. Yancey was a party two. The big difference was state representing that Mr. Bobby Yancey was just as much of a part of the initial beatdown as the other brothers, as opposed to the impression I got from you, not having seen any video, appreciate that, that nope, this guy could barely get out of his own car, which he was not driving, and just sort of lay there on the ground. And I think the relative that someone called, I assume it was you, had only been shown a still when your client was on the ground and said, yeah, that's my uncle Bobby Yancey who's there on the ground. And that appears to be at one point where he was, not the part I was focused on. So having said that, I do want to give you a chance to add anything more you want to add.
Yeah, all of that is correct, Your Honor. That's a very good memory for what was said and what occurred. The things that I'm uncomfortable with about Mr. Abate's statements here are that it's going to show the person, seconds later, they're going to shoot the victim. Well, the person, the victim of this beatdown, he's walked off this way, okay? They all seem to be getting back into a car. There's another person who goes this way. I still don't really know, who the victim is here. I also think that the court was correctly under the impression that this beating, this attack, was very close in proximity in time to the murder. I think, again, we've got, well, I heard from a detective who said that XYZ. I don't think that's good enough. I think that the video needs to show us this is serious violence. This is not someone got into a fist fight on the same night his brother was charged with a murder. This is someone who participated or very closely participated, approximately in time and space in a murder. And that's why we're holding him. That's why we're saying that despite the lack of a criminal history, despite the risk of flight, we are holding him in jail until his trial.
Okay. I hear you on that. And I think you should take Mr. Abate up on the offer of getting the rest of the video so you can watch it. If you want me to watch it, I will. What influenced me was not where's the guy getting shot? Because I wasn't expecting to see your client having anything to do with that. Maybe if what you learned from watching the video is that it was 3 hours later that the person got shot, and by then your client had left, we should re-engage on this. What influenced me was, you call it a fist fight. I'm going to use different terms, but basically these three guys stopped their car in the middle of the street. Car still, I don't know if they turned it off, but it's not even pulled, like middle of the street. And they rushed this guy, and all three of them are pounding on him. And it may be that you would say, well, one guy was kicking more than the other, but this was a group violent beatdown of someone. That's why I said no bond, not because I thought that somehow Mr. Bobby Yancey's role had escalated or evolved beyond what I had heard the state portray it as. This is a grown man who, as you pointed out, has led a relatively successful life, and on paper, and certainly through your presentation, led a happy, stable existence. That's not what the video shows. And I would be comfortable denying bond to any of the three people who jumped that guy, unless and until someone showed me that that was somehow like self-defense, that what they were doing, that the guy had a bomb on him and they had to disable him so he didn't set the bomb off. That's what influenced me. I don't think in the end, if you were able to show that the murder was 12 minutes later versus 2 minutes later, it would influence that. It was more the savagery of what I saw on the video. So I'd invite you, if you want me to revisit this another time, to share with me your thoughts at a later date as to why you think that's not your client who was part of the threesome that jumped on and brutally beat this guy. And I hear you when you say it doesn't look like anyone was injured, but I think you say that because the guy they jumped on actually got up. He wasn't left as a bloody lump on the ground. It doesn't mean he wasn't injured. It means his adrenaline got him up and he wisely tried to get away from these three guys who jumped him. So there is a world of difference, I agree with you, from murder and assault, aggravated assault, whatever it might be. But videos are powerful things in both directions. They clear people, they implicate people. And this was a video that says to me, Mr. Yancey needs to sit tight until he resolves his charge. The longer it takes for that shooting to occur, the more likely it seems to me that Mr. Yancey's charge ought to be assault, battery, aggravated assault, whatever that may be. And that may be something you engage the state with before it gets locked in as an indictment. And then you know very well it's sticky and it's hard to move from a charge that maybe didn't quite fit Bobby Yancey's involvement in the situation. So for now, I'm going to stick with what I did, but I remain open and I will be the bond judge until this gets indicted. The second and final thing I'll share with you, Mr. Cullen, of course, is if months pass and your client's not indicted, we need to talk again because I need to adjust. Obviously, after 90 days, I need to adjust it, and I will. That won't be it won't be a mere formality, but I will certainly, if it hasn't been indicted by then, change the situation for Mr. Yancey. Okay.
Thank you, Your Honor.
Appreciate your time.
Your Honor, that concludes my business. May I be excused?
Yes, sir. All right. Let me see if we got anyone else. We still don't. Lieutenant Dooley, any update on where Mr. Barber might be or Mr. Brown?
Barber is on 5 South. And so the gentleman that's currently there would have to walk out and allow him.
Got it. Let's swap them out because the gentleman in there now, Mr. Barry, we're trying to track down his lawyer.
Okay, Barry,
Thank
can
you.
you step out and let the other gentleman come in, please? Thank you.
Thank you both. So Ms. Madden, we are about to get Mr. Barber and we'll talk as a group and then I'll get you and Mr. Barber into a breakout room.
Yes, Judge, thank you.
Hey, are you Mr. Barber?
Yes.
How you doing, Mr. Barber? I'm Judge McBurney. We have your attorney, Ms. Madden, on this call, and prosecutor here. We're going to talk real briefly about your probation situation. And then I think Ms. Madden and you are going to go into a breakout room so that she can try to share with you a video that the state shared with her, okay?
Okay.
I am trying to get my hands on your petition. What? I could have sworn I brought that out here. Fox, Ferry. Give me a second. Oh, that's right. I didn't have your petition. I just got these warrants that South Fulton arrested you. So does anyone have a petition on Mr. Barber? The attachment I got is
I think I have one in my email, Judge. I'll have to go and look.
okay. And you don't need to get it to me. If you just let me, I want to understand what the purported basis of the revocation is. It sounds like
My
it's
understanding the basis is just the new felony charges. I think there was some arrearage, but it was minimal.
okay.
Maybe less than $100 from what
So
I.
the main thing is the new case.
Yeah.
Okay, got it. Then, Mr. Barber, what I'm going to do, Ms. Madden believes that she and you are close to reaching an agreement with the state, but she did want to try to share this video with you. So I'm going to have you guys go into a breakout room. I don't think we're going to resolve it today because Ms. Madden wants to negotiate with the state a little bit more. Do you have any questions before I put you in the breakout room? Because I'm not sure I'll get you back after that.
No, not mom.
Okay. I got
Before we go in a breakout room, and I'm not sure how long Ms. Hall thinks she needs, but we talked about maybe a week or two for a reset date.
Sure. Ms. Hall? Yeah, so we'll get it back here in the next couple weeks, either virtually or in person, depending on which day of the week it falls. And I did just get a copy of the warrant. And the main allegation is this March 5th aggravated assault with a deadly weapon. And then you're right, it's a $5 arrearage. So minimal was the right word.
It's even less than I remembered. Okay.
Yeah, so clearly the focus is what's going on with, there may be two cases. There's a March and then there's something about August 10th, but that may have simply been when he got arrested on.
That's correct, Judge. He was arrested at a later date.
Okay. Then I will move you and Mr. Barber to a breakout room. Mr. Barber, when you are done speaking with Ms. Madden, you're free to head out of the booth, okay?
Okay.
All right, let's see if I can make this happen. So. All right, they're there. Mr. Yancey, if you're free to go. We finished your situation, okay?
Okay.
Thank you.
Can I hear what?
I made him get quiet. I didn't mean to do that. Mr. Yancey, I'm sorry, I didn't hear what you said.
I said, I want to know what's going on. What is the deal on this survey? What we doing? Did he get the video or whatever y'all need to find out about what went on?
Yep, he got it. I got it. And that's why I did what I did. I think your lawyer's going to get the rest of the video and then he may come talk to you about that. Okay. Thank you. All right. That is Barber, reset. And then Brown, is Brown ready to go or did, oh. Anyone get a sense of what's happening with Ms. Henderson now that Mr. Majeski came out?
Judge, may I don't have an answer on that, but it might be helpful if I just go back and do a breakout with Mr. Brown just to make sure he's good to go with our global resolution.
Okay. The only risk is that I had trouble, Mr. Fox never came back. In other words, when I closed the room, his booth stayed in there.
Oh.
As a technical, Mr. Fox didn't do anything wrong. He can't touch the computer. It's on the other side of the glass. So if they're not coming back, then we lose them.
That makes sense. Well, we can stop because what is happening is what Mr. Brown and I have talked about. So if there's any questions, we can just pause.
Okay.
This. Thank you, Judge.
Is Mr. Brown ready to go? Did Ms. Hall get what she needed?
I think that's what she went to get.
Okay.
Perhaps.
Mr. Majeski, how are we doing with your surprise?
Much better, Judge.
Okay, should we try again?
Yes, sir.
Great. Let's bring Ms. Henderson back out, please. All right, let's get back on the record again, please, in Ms. Henderson's case. Ms. Henderson, we took a break in your matter so that you and Mr. Majeski could talk some. Are you in a more comfortable position right now in terms of moving forward with a plea in your case?
Yes,
Okay. Are you prepared to do that?
yes.
Okay. You should know that throughout this process, if you've got questions or concerns, you'll be able to raise them. It is not a one-way conversation where Ms. Hall says things to you and you simply say, yes, ma'am, or no, ma'am. I'll be asking you at several points. Do you have any questions? Do you have any concerns? We're not rushing anyone through this process. And in fact, I'll ask you please to let Mr. Majeski or me know if at some point something is said that is inconsistent with what you thought was going to be happening, okay? Will you do that?
Yes, sir.
Great. All right, Ms. Hall.
Thank you, Judge. Ms. Henderson, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may lower your hand. Please state your true, correct, and legal name.
Kimberly Henderson.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
I'm 40 and I done took two parts of the GED test, math and science.
You passed the hard ones. When are you going to do the easy ones?
I got to have them done. I'm been trying to get them done, but they had the COVID, so we couldn't finish.
Got it.
Are you able to read, write, and understand the English language?
Yes.
Your Honor, for the record, the state is no processing count one for Ms. Henderson kidnapping.
Okay.
Ms. Henderson, do you understand that you've been charged with the following offenses? Armed robbery, aggravated assault with a deadly weapon, 2 counts of just straight aggravated assault, trafficking in heroin, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon.
Yes,
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
yes,
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
yes,
Do you need more time to discuss this case with your attorney?
no,
Are you satisfied with his services?
yes,
Counsel, do you waive formal reading of the indictment?
Yes, ma'am.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes, ma'am, but I'd note that I independently reviewed the indictment and found no errors in the indictment.
And do you waive moving forward on a copy of the indictment?
Yeah. Yes, ma'am.
Ms. Henderson, have you been arrested on these charges?
yes,
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No, ma'am.
I don't have any, no, ma'am.
Ms. Henderson, have your attorney advised you of the minimum maximum sentence for the charges that you're pleading to?
Yes,
For armed robbery, it's 10 to 20 or life. For aggravated assault, it's 1 to 20 years to serve. Trafficking and the amount that we're dealing with today is 10 years minimum. Possession of a firearm during the commission of a felony is 5 years to serve, consecutive to any other count. And possession of a firearm by a convicted felon is 1 to 5 years. You understand?
yes, ma'am.
Do you understand this is the negotiated plea of guilty, which means the state will recommend to the court a sentence of, for the armed robbery, 15 years to serve 8, balance on probation. For the aggravated assault with the deadly weapon, 15 years to serve 10, balance on probation for all the aggravated assaults. And I believe, Your Honor, they would merge. The trafficking charge would be 15 to serve 10. The possession of firearm during the commission of a felony would be 5 years, suspended consecutive to count 1. And for the possession of firearm by a convicted felon, 5 years to serve. Do you understand that the court does not have to accept that recommendation? The court can sentence you to the maximum on each of these charges and can run these sentences consecutively or one after another.
Yes,
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
ma'am, repeat again, please.
Do you understand if by taking this conviction or this plea today and becoming a convicted felon, taking another conviction, if you're currently on probation, this could affect the convictions in other jurisdictions? I don't think.
So you're about to enter a plea today. The fact of entering this plea will give you a new conviction. If you're on probation somewhere else in the United States, that jurisdiction could say, come on, Ms. Anderson, you violated your probation because of this new case. I know it doesn't feel new, but it would be a new conviction. And that could subject you to being revoked in that other case. If you're not on probation anywhere in the US, you don't need to worry about it. I just don't know your situation, which is why she has to ask that.
And also what she's saying is, you remember how we talked about the recidivist notice? Yeah, if you get in trouble again, this could be another entry in that little sheet.
Do you understand if you're placed on probation?
Well, before we go there though, you understand that this conviction could be used to revoke your probation if you're on probation anywhere?
Yes,
Okay, and that this conviction will add to the list of convictions you have in terms of being a recidivist. It's one more conviction on that list.
yes, ma'am.
Okay.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence, which is what we just explained.
Yes,
Do you understand that you're not allowed to possess or use a firearm while on probation?
yes,
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
yes,
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
yes,
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
yes,
Do you understand if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
In indictment number 19-SC-169005, how do you plead to the charges of armed robbery, aggravated assault with a deadly weapon, 2 counts of aggravated assault, 1 count of trafficking in heroin, 2 counts of possession of firearm during the commission of a felony, and 1 count of possession of firearm by a convicted felon?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have 30 days from today to file an appeal on this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Ms. Henderson. Your Honor, the state is aware of 2 prior convictions by the defendant, both being drug convictions dating back to 2010 and 2009.
Is one in Barrow County?
Yes, Your Honor.
All right. That's apparently still an open case, meaning that Ms. Henderson is on probation out of Barrow County.
Yes, Your Honor.
Where's the other one from?
The other one is on my computer over there.
Oh, it's not critical, but they're both from a while ago.
Yes.
Okay.
And Your Honor, had this case proceeded to trial, the state expected the evidence to show that on June the 10th, 2019, at 3376 Lake Alley Road, Atlanta, Georgia, in Fulton County, officers received officers were dispatched to a hospital after being notified that the victim had run through the woods with no clothes on after being hogtied in the back of a vehicle. During the investigation, they learned from the victim that he and the defendant are childhood friends or were childhood friends, and they dealt business together. Victim said that he gave the victim some hair for her to sell. She called him over to her house so that he can pick up money from her selling that hair. When he got to the house, they were in her living room having a discussion when 5 males, one being Mr. Reeves, who's the co-defendant in this case, came out from her bedroom, and they started to beat him with all of them had guns or rifles, and they started to beat the victim. Ms. Henderson stood, and from the recounts of the victim was the person they were taking orders from. They would stop beating him and go over and ask her questions as they were trying to get information from him as to where money was. They were trying to rob him of any kind of money that he had. And they kept asking, where is the money? Where's the money? They would stop and go over to Ms. Henderson. And then he would say that they would come back over and start beating him, like, tell me where the money is, tell me where everything is. At some point, they tied him up and put him in the car that he came in, put him in the back seat of that car, drove that car about 15 minutes away from that location. It is unclear whether the defendants actually shot the car or just shot in the air, but the victim inside that car heard about 6 or 7 rounds go off. He was able to escape from the back seat. On the other side of the car, he ran through the woods where a postal service man was able to help him call 911. They got him to the hospital. When the lead officer was investigating this incident at the hospital, they did have officers sit on the home while they were trying to figure out what was going on.
The home meaning Ms. Henderson's home,
where the incident took place.
So Ms. Henderson and Mr. Reeves were a couple, or at least occupied this Lake Allen
I
Road.
believe they were roommates,
Okay.
friends that lived together.
Okay.
According to my victim, and that is Tobias Clark is our victim. He obviously knew where this happened. He was familiar with the defendant and her home. He told officers where this happened. Officers went to that location. They did not knock on the door or anything. They just sat on the location. While they were sitting there, they did notice a vehicle that attempted to leave. That vehicle had several males in it. The officer stopped that vehicle, asked the males to just give him a minute while he checked with the lead to see what he needed to do. At that point, that vehicle reversed, went back to their house. Everyone dispersed, and we believe that Mr. Michael Reeves was in the car at that time. While they continued to investigate this case, at another point, Ms. Henderson was in a car and attempted to leave that location as well, at which point the officers, by this time, had enough information to detain her. And so she was arrested on the scene. Because this incident happened inside of her home, there was a search of the home. Inside of Ms. Reeves' bedroom, there was cocaine and heroin that was found. The heroin that was tested by GBI came back as 14.3 grams. And that's where that trafficking charge comes in at. I have spoken with the victim several times in this case. It's been around for a while. He do believe that these people attempted to kill him that day, or at least wanted to kill him and just didn't follow through with that. And he does believe that Ms. Henderson is the one that orchestrated this entire armed robbery that happened. I decided to no apprise the kidnapping charge because there is no evidence that what took place after they decided to take him out of the house had anything to do with Ms. Henderson, although she still would have been a party to the crime. I decided after speaking with supervisors that we would no apprise that particular charge.
As to her.
As just to her.
Mhm.
And I believe that it's all, and as you know, she is a convicted felon, and that's where the possession of firearm by convicted felon comes in at.
So there are 2 firearm counts.
There was guns found in the home.
Okay.
When they searched the home. There was also guns that were found in the vehicle there was drugs and guns found in the vehicle that Ms. Henderson was pulled over in. But I believe that was a vehicle that was the relatives or something. So the officers didn't charge for that. They just charged and we indicted only the things that were found in the home inside of Ms. Henderson's bedroom.
Okay, I see. And it's different. There's one alleges that a firearm was used in connection with the physical crimes against Mr. Clark, and the other is a firearm used in connection with the trafficking.
Right.
So it's sort of stretching the guns in different directions. Okay.
And that is all from the state.
And you don't have any information as to who the other men would have been. Mr. Clark didn't recognize them.
No, he only he didn't really know Mr. Reeves, but he had seen him a couple times. And we have tried to get that information from Ms. Henderson and Mr. Reeves, but apparently they only know nicknames of the other people involved. Obviously we don't believe that, but here we are today with just these 2 defendants.
Yep. Okay. I think I follow all that. Sounds like we've got the criminal history, 2 priors. Mr. Majeski, tell me about Ms. Henderson and this situation.
Judge, every time I take a plea in front of you, I come in here and say the same thing. I actually like my client. And I've never lied to you when I do that. And, one of the reasons I do what I do is because of cases like this. I don't like the party to a crime law in Georgia. Once had a spirited conversation with now Chief Justice Namias about this up the hill. And until they change it, we're just gonna keep catching people in wide nets. Now, the reason I don't like it is because if I take all the government's facts, it's true. And that's exactly what happened. I'm still left with somebody who was involved in a situation with an outcome that they didn't want and never would have wanted. And that's why I find myself with most of these young people in violent cases and things like that. They think it's a game. They think it's not that serious. They think I'm not the one and everything else like that. Now we're talking about decades in prison. I say all that, Judge, because the facts in this case are bad. And the offer in this case, quite frankly, took us, a couple months to come to. Once it finally got hot again in this division. And I want you to accept it, Judge, because I think it's appropriate to, if you have a retributionist philosophy of criminal justice like I do, I think it matches her maximum level of culpability on the scale which we measure these things in Georgia.
You do often seem to end up with the defendant in the mix who plays the role you described. I don't know how you're retained for these things. It's almost like there is an ad somewhere that says, if you're sort of in this through party of a crime, hire Majeski, because that is often who you seem to end up with. What's the connection, just in terms of relationship, between Ms. Henderson and Mr. Reeves? Roommates, siblings? Okay. Got it. Ms. Hall, I assume you're asking this based on your recommendation. You're asking that I rely on 1710 6.1E to go below the mandatory minimum.
I'm sorry, I didn't tell you.
That's okay. We'll get it. We just need to get it on the record. Okay.
And Judge, thank you, Ms. Hall.
Ms. Henderson, is there anything you want to add? I've listened and Mr. Majeski has helped put some of what I heard in context. It sounds like it was, one other question for Ms. Hall. Are you speaking on behalf of Mr. Clark, or is there a victim impact statement that I need to hear?
No, Your Honor, he didn't want to write anything. He just wanted me to convey that he felt like they wanted to take his life, and he is still having those same effects today, with what happened to him that day, but he didn't want to write a statement or appear.
Okay, got it. Ms. Henderson, anything you want to add to all this?
Just like I let somebody come stay with me, and it was a bad choice because it got out of hand. And
Was the somebody Mr. Reeves, or was the somebody friends of Mr. Reeves?
no, Mr. Reeves, because he's on my lease with me.
He's what? Oh, on the lease with you?
Yeah.
Okay, and he is your brother?
He's my play brother. I was trying to help him out because he said his mom was stealing his money because he was a part-time rapper. He was getting his things up.
Okay. And how did he end up with his name on your lease?
Because I didn't want to have nobody move in my house, and then they stick me with all the bills because I have 3 girls of my own, but they were with my mom because I had just got out not too long ago and I was trying to get back on my feet, and I didn't want to be stuck with the bills.
Okay. All right. And then Mr. Reeves, I guess, got these other folks involved and things like this happen.
Yes.
Okay. All right. Well, Ms. Henderson, I find there's a factual basis for your plea. I don't know what was motivating those folks. And it's certainly what happened to Mr. Clark is inexcusable and frightening. I also find that your plea is knowing and voluntary. Knowing, I think, is the easy part. That means you've understood what we've been talking about. You are smart, getting your GED on your own accord, all that kind of stuff. Do you have any questions about what we've talked about so far?
No, sir.
Okay. Voluntary means that while you may not be enthusiastic about what's happening right now, as you weigh your different options, going to trial, recidivist, et cetera, you, after consulting with Mr. Majeski, have decided that it's in your best interest to go forward with this plea. Is that correct?
Yes.
Okay. Then I'm going to accept your plea. I'm sentencing you under the Probation Options Management Act, which means simply that while you are on probation in this case, should you have a technical violation, you miss a meeting, maybe you test positive once or twice for something, you and probation will deal with that. If it's more serious, new charges, anything like that, that comes back to me and we figure out what to do with that. You are telling me, Ms. Henderson, that the other guys who showed up and joined Mr. Reeves in mistreating Mr. Clark are people that you know only by, that's his friend Rico, or you don't know him by full name?
I didn't know him, period. Them was his friends. I didn't know him.
Okay. Were those people who had been in your house before?
No, like she said, they pulled up, like most of the time we would miss each other. We had different schedules because I took my children to school, pick them up, you know, so we missed each other a lot.
Okay. Well, I'm going to follow the joint recommendation, and I will sentence you, get all the counts up on the screen here. Count 1 has been dismissed by the state. Count 2, I will sentence you to 10 years to serve 8 with balance on probation. Let me see what merges here. I agree with you, Ms. Hall. I think that counts 3 through 5, those are the aggravated assaults, all merge into count 2. Count 6, which is the trafficking in heroin, I will sentence you. Now, that one doesn't get below 10. How does that? Okay.
Right, so.
Or maybe I misunderstood. What was your overall recommendation?
The overall was for it to be a 15 serve 10.
Oh, okay.
The purpose of doing it on the armed robbery.
I got all that part. Okay. So then your sentence on the heroin case is 10 years to serve. That'll run concurrently with count 2. Your sentence on count 10 is 5 years to serve. That's firearm by convicted felon. Well, you're not on that. You don't have that charge. So strike count 10. You just have counts 8 and 9, which will be 5 years. They'll run concurrently with each other. They will be probated and they will run consecutive to count 2. So it's an overall sentence of 5 years to serve 10, 15 years to serve 10 with the balance on probation. Special condition of probation number 1, no contact with Mr. Clark. You leave him alone. He goes his way. Special condition number 2, no contact with Mr. Reeves. He brings you trouble. And special condition number 3, get your GED if you haven't finished it by the time you get out. Okay?
Yes, sir.
Anything else, Ms. Hall?
Nothing else, nothing further from the state, Your Honor.
Mr. Majeski?
No, Judge.
All right. Thank you all for your time. Appreciate it.
Judge, I'm sorry, I did not hear what you said on count 7.
Whoops, did I skip a count? Oh, I said them the wrong way. Look at that. Yeah, so just stay here. It's not going to change your overall sentence, but let me get that. So 6 is the 10 years to serve. 9 is 5 years to serve concurrently with count 2. And 7 and 8 are the 5 years to serve probated. They run concurrently with each other, but consecutive to count 2. And 2 is sentence pursuant to 1710 6.1E.
Okay, thank you.
You're welcome. Thank you for flagging that. You're good.
Judge, can I be excused?
Yes, sir. All right, let's figure out where we are with the jail, and then we need to deal with Mr. Hinton's case. So let me grab that calendar again. What are we doing with DeMarcus Brown? Oh, she's busy right now. We won't. What are we doing? Mr. Barry, and Mr. Bridges is here. Hey, Mr. Bridges. Thank you for coming by on short notice. So we've got Mr. Barry, who is here on a revocation, but he's got 2 unindicted CP cases. And your name came up as maybe being a lawyer who's connected with the unindicted cases. Tell me what you remember about Mr. Barry. If you remember anything. I don't mean to pin anything on you that ought not to be there. Sure.
Barry's the last name?
Yeah, Quadravius Barry. And I can give you the case numbers if you want to look them up. In fact, I'm going to look one of them up now. Yeah, so you're listed, one of them is a heroin trafficking case. And there was a probable cause order entered in July, but there was no probable cause. Oh, she did. It's just they're not new charges. So Judge Rickman found probable cause on the heroin trafficking and the gun charge in late July of this year. Okay, so these are ringing a bell more?
Only one of them, there's two of them here, Your Honor.
They are. Let me look up. I happen to pick the one that you've got.
I have two of them.
You got both.
But what I see, I have two of them. Maybe I can do a picture of them. But this one, yeah. There's the CP 191892.
Yep, that's the one I'm pulling up now. That's a financial transaction card theft. Yep.
Getting those about probation, revocation.
Okay. Yeah, let me get you a copy of the petition, Mr. Barry. Here you go. You can come up and get this. Oh, there are two. Okay, the second one, which is the one on top, includes the CP matters you're involved with. So you know the posture we're in. You've been in this many times before. He's got this older case, probation on it. The primary basis for revoking would be the cases you've got now. So we've got three options. One, not today, but soon, we have a substantive revocation hearing where the state needs to try to prove by a preponderance that Mr. Barry did one or more of these new things. Two, there's some global resolution because you've looked at the new cases and realized he needs to work them out and the state's willing to accuse him. Or three, your preference is please put on hold the revocation because what's really going to drive everything is, I'm assuming, the heroin case, because the other case would go to non-complex.
Is Mr. Barry here today or is he?
He is virtual, so yeah.
So.
If you want to dial in, we can put him in a breakout room and you can speak with him. It is open.
Okay, so I'll just go back there, turn my computer on.
Great. When I see you on, I'll put you and Mr. Barry in a breakout room.
Thank you.
You bet. Thank you, Mr. Majeski.
Thank you, Judge. By the way,
Good save.
thank you for letting me appear personally. I love it that y'all are doing that. I help really.
Happy to do it.
I love it.
And where'd he go? Oh, that's the one that disappeared. Lieutenant Dooley, can we get Mr. Barry in a booth, please?
Dream is there. He's in 5 South.
Yeah, so here's the problem. I put 5 South in a breakout room. Maybe I can get and it doesn't come back from the break. So there he is. Let me see if I can move him. Hold on one sec. Main session. It won't, Zoom won't let me move 5 South back to the main session. It's stuck in a breakout room.
Okay, hold on. I'm gonna see if I can.
So if there's a different, I could do booth 2 if no one's using it. I can connect
just
to that.
about to suggest that. Okay, let me call.
Okay. All right, just let us know. Thank you. What's going on with Mr. Brown? Oh, there's so many different Browns. Let me be clear. DeMarcus Brown.
Oh, okay, sorry. I had an announcement on another Brown.
So if, acquisition's ready.
Oh, yeah, I need to check now.
Okay, we'll pause on that Brown. We will pause on that Brown and let's go back to our trial calendar. What about Benjamin Brown?
I believe we have a resolution, Your Honor. If he could be brought in, I think we got a plea.
Okay, we will do that. You should take a seat or stand, whatever is most comfortable for you. We will take Mr. Hinton's plea before Mr. Brown's because that's been ready for a long time. But let's not lose Benjamin Brown. It'd be great to resolve it. And then your other Brown, Antonio Brown. Oh, he came out here. He heard what he needed to hear. And yep, no, I just want to make sure we were touching all the Browns. Yep.
Judge Barry's being moved to booth 2.
Thank you so much. So 5 South, booth 2.
Yes. Can you ask whoever has 1+ into to either turn the video off? That light is really bothering me.
You bet. Maybe you weren't talking to me. I don't see that.
After the first 2 years.
We're losing 5 North, booth 1. Oh, that's Mr. Bridges. All right. So let me do this. 5 South, booth 2. Where did you go? Hey, Mr. Barry, can you hear me? Mr. Barry, I can see you. Can you hear me? Yeah, great. I'm going to put you in a booth with your lawyer. He's going to talk to you a little bit about your case. I'm not a booth, in a breakout room, okay? Who's this?
Benjamin Brown.
Okay, too soon. Sorry. Hey. All right, Quadravius Barry, breakout room with Mr. Bridges. Okay. So DeMarcus Brown, we're gonna wait on for a minute and we're gonna do Mr. Hinton now. Is that what's left? All right. So when our deputies are ready, let's bring out Mr. Hinton, please. Hinton, please. Mr. Abate, you're still here. What am I keeping you here for? I'm sorry. Oh, all right. No, they are told for maybe the end of this next term, but Chief Judge Brasher entered an order that invoked the last time he can do that. So I think we're good through the end of the year, but I think that's correct. Don't hold me to it.
Does the court want us to use are we going on a copy of the indictment?
I do have, I mean, if you've got one, you can, but I'm happy to use a digital version.
I don't have a clean one.
Okay. All right, we're gonna give Ms. Rivers, I didn't realize she needed a break. So she needs to come back.
What the facts are from their perspective. Judge may ask you some questions. Prosecutors can ask you some questions, okay?
Mr. Hinton, we're just waiting on the court reporter, okay? All right.
Judge is going to ask you, how you sign the charge. The judge is going to ask you that is.
And Ms. Convery, we are not sorting out the Leffridge case today?
No, I guess.
Okay.
Nope.
I mean, that was meant to be a question, not a directive.
No.
Okay.
No, I don't think we are.
I'm sorry, I didn't know you needed a break.
No, I just ran to see if I could catch IT.
Oh, for your laptop?
Yeah.
Do you need a minute to do that or?
She's not picking up.
Oh, okay. Do you want Michelle to escalate it or are you okay?
She can kind of reach out to.
To someone in particular, what we need just to get your laptop back?
Because I use it for Zoom.
Got it. I will do that while we're in the midst of this. Okay. So we are turning to position 9 on our trial calendar. It's State versus Avante Hinton, 18 SC 162373. Mr. Hinton, Ms. Young tells me that after many, many hours of work on your behalf, she has negotiated with your participation a resolution to the charges in your case. Is that your understanding?
Yes, sir.
Okay. Ms. Convery is going to put you under oath in just a minute. Once you're under oath, you need to answer her questions and mine truthfully and completely. If you at any point during our conversation have questions of your own, please let Ms. Young or me know, because we need to answer those to make sure you understand what's going on during this proceeding. Will you do that?
Yes, sir.
Ms. Convery?
Raise your right hand for me, sir, best that you can. Do you swear or affirm the testimony that you're about to give in the matter pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much. You can lower your hand. Please state your true, correct legal name for the record, sir.
Evans Rashawn,
How do you spell your middle name?
RASHUN,
How old are you, sir?
23,
How far did you go in school?
10th grade.
Are you able to read, write, and understand the English language?
Yes,
And at this time, are you taking or under the influence of any alcohol, drugs, or prescription medications?
no,
Do you understand that you are charged in indictment number 18 SC 162373 with the following offenses? 1 count of participation in criminal street gang activity, subsection 1615-4 subsection A. 1 count of participation in criminal street gang activity in count 2, which is 1615-4 C. Count 3 is participation in criminal street gang activity, 1615-4 subsection H. 1 count of murder in count 4, 2 counts of felony murder in counts 5 and 6 of this indictment, 1 count of aggravated assault in count 7. Count 8 is possession of a firearm during the commission of a felony. Count 9, aggravated assault with a deadly weapon. Count 10 is possession of a firearm during the commission of a felony. 1 count in count 11 of the sale of heroin. Count 12 is possession of heroin with the intent to distribute. Count 13 is possession of cocaine with the intent to distribute. 14 is obstruction of a law enforcement officer, which in your case is a misdemeanor. Count 15 is aggravated assault. Count 16 is possession of a weapon by an inmate, which the state intends to null pros today as a result of negotiations. And count 17, possession of a knife during the commission of a felony, which will also be a null pros on behalf of the state today as for this plea. Do you understand all those charges, sir?
yes,
So 16 and 17 dismissing.
That's right. And
Okay.
those are related to the jail incident. And I'll
Yep.
talk with the court during the factual basis about that. Do you understand, sir, that for each of those counts, each of those charges that I just read to you, you have the right to either plead guilty or not guilty to those charges? And if you chose to plead not guilty or to remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Ms. Young, about all the facts and circumstances of these cases, including any and all potential defenses to the charges that I just read to you?
Yes.
Do you need any more time to discuss this case with her?
No.
And are you satisfied with her services?
Yes.
Counsel, do you have a formal reading of the indictment?
We waive reading any defects or variances, objection or appeal as to that, Your Honor.
All right, and the state is unaware of any outstanding warrants related to any of the cases that merged into this indictment. Counsel, are you or your client aware of any outstanding warrants related to any of these cases?
No knowledge of any warrants, Judge.
And Mr. Hinton, has your attorney advised you of the minimum and maximum sentence for each of the charges that I just read to you?
Yes.
Do you understand then that for counts 1, 2, and 3, which are the participation in criminal street gang activity, the minimum is 5 years and the maximum is 20 years to serve? Count 4, which is murder, is a life sentence or mandatory minimum of life to serve. Counts 5 and 6 carry the same sentencing range. And I'll let the court know my global recommendation at the close of this. Count 7, aggravated assault, is a minimum of 1 year and a maximum of 20 years. Count 8, possession of a firearm during the commission of a felony, is a 5-year sentence to run consecutive to the court sentence on the other counts. Count 9, aggravated assault, minimum of 1 year, maximum of 20. Count 10, possession of a firearm, that's a 5-year sentence to run consecutive to the court's sentence on the other counts. Count 11, as indicted, the sale of heroin, has a minimum of 5 years and a maximum of 30 years. Count 12, as indicted, which is possession of heroin with the intent to distribute, 161330C, is a minimum of 2 years and a maximum of 15 years. Count 13, possession of cocaine with the intent to distribute, is a minimum of 5 years, maximum of 30 years. Count 14, which is that misdemeanor obstruction count, is a minimum of 1 day and a maximum of 12 months. Count 15 is aggravated assault, which is a minimum of 1 year and a maximum of 20 years. And counts 16 and 17, the state is recommending a dismissal on those counts. For the purposes of just streamlining going forward, the state's recommendation for the purposes of this plea today, negotiated plea, is going to be a global sentence of 30 years to serve, plus the 2 consecutive counts suspended. I think I can run those concurrently with one another, but the recommendation is for 5 consecutive to be suspended on the back end. The only counts I'm recommending a null pros for are counts 16 and 17. And my recommendation for the deviation on count 4, murder, is under 1710 6.1E. The state's position is that counts 5 and 6, the felony murders, will vacate as an operation of law. And count 7, which is the aggravated assault related to the homicide, will merge into count 4, the malice murder.
Understood. Thank you.
You understand, sir, that by pleading guilty to some of the charges in this indictment, specifically the murder count 4, you're pleading guilty to a serious violent felony.
Yes.
You also understand that that means you will serve the entire prison portion of that sentence imposed for the serious violent felony without the possibility of parole.
Yes.
You understand that neither the court or the district attorney's office has anything to do with parole, or the Department of Corrections or the Board of Pardons and Paroles, and no one could ever guarantee you parole.
Yes.
You understand that today's plea is what's called a negotiated plea, which means that your attorney and I will be making the same recommendation to the court, but that ultimately it's the court that will sentence you within that range as I outlined to you, the range that's authorized by law on each of those counts.
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Do you also understand that if you were currently on probation or parole of any kind, your probation or parole may be revoked based on you entering this guilty plea today?
Yes.
Do you also understand, Mr. Hinton, that if you were placed on probation of any kind as a result of today's plea, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without then being subject to a revocation for the balance of your sentence?
Yes.
Do you understand that also means that you are not allowed to possess or use a firearm while on probation?
Yes.
Mr. Hinton, do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status? And this is true regardless of the advice of your attorney or anyone else.
Yes.
You also understand that neither the court, your attorney, or the district attorney's office, again, has anything to do with parole, the Department of Corrections, or the Board of Pardons and Paroles.
Yes.
You understand also that there may be other adverse or unfavorable consequences as a result of today's guilty plea convictions, just as there would be following a conviction after a trial. For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, and the right to receive, possess, or transport a firearm.
Yes.
Do you understand that by pleading guilty to a felony, if you then receive, possess, transport, or use a firearm in another crime, you would be guilty of a felony, which may carry a sentence of 1 up to 15 years in prison?
Yes.
Do you understand, sir, that today you're going to waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
You also understand then if you went to trial, you would have the right to a trial by jury, including the right to see, hear, and confront the witnesses called by the state to testify against you, or the right to remain silent and not incriminate yourself.
Yes.
So then do you understand that by pleading guilty today, that you're going to be giving up or waiving the following rights? The right to a trial, remain silent and not incriminate yourself, the right to confront the witnesses called to testify against you, the right to the assistance of counsel hired by you, and the right to court-appointed counsel if you could not afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven by the state beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
I'm sorry. Has anyone forced, threatened, or promised you anything to get you to enter today's guilty plea?
No.
Is it your decision to waive the rights that I just outlined to you and enter this plea because you are in fact guilty?
Under Alfred, please.
Right?
As to all counts or certain aspects?
As to all counts, Your Honor, there are significant, and that's the reason we were able to reach the negotiation. So he's
Okay.
requesting that.
Great. And you and it maybe I ask Mr. Hinton some questions about it later, but you can explain the Alfred piece of it.
Thank you.
Sure.
So are you pleading guilty because you have decided after talking to your attorney and your review of this case that is in your best interest to do so?
Yes.
So then are you aware that even if you do not admit guilt, that this is a plea of guilty and places you in the same position as if you were convicted by a jury after a trial?
Yes.
All right. And how do you plead, sir, to the charges in the indictment that I outlined to you? So it'd be counts 1 through 15 of 18 SC 162373, guilty or not guilty?
Yes.
And is this guilty plea freely and voluntarily given with full knowledge of all the charges against you?
Yes.
You understand, sir, that you may only have a limited right to appeal this guilty plea conviction.
Yes.
You also understand that you'll have 4 years from today's date on the felony counts in this indictment and 12 months from today's date on that misdemeanor charge to file a habeas petition, which would challenge the voluntariness of today's plea.
Yes.
And have you had the opportunity to, with your attorney, go over the court's plea of guilty form and the waiver of rights form?
Yes.
And have you been able to initial in the parts that apply and sign this document as well?
Yes.
Judge, I think there's just one thing that may need clarification as
Sure.
to his schooling. Mr. Hinton, did you finish 9th or finish 10th?
9.
Okay.
We're good?
Correct, it's correct.
Okay.
I believe there might have been some confusion when the court, when he was asked, how far did you get to school? And he said 10th.
You got into 10th, didn't finish 10th, did finish 9th.
Yes, sir. Thank you for
Understood.
allowing me to clarify that.
Sure.
And I'm going to send it to the court with the guilty form.
Thank you.
And I understand that we're going to be going on a copy of the indictment as well.
Yes, that is correct.
So I'm going to try to go in chronological order when it comes to the factual basis for each of the counts in the indictment. And I do have members of the victim's family here present. And when I finish with factual basis, I'll inquire if they would like to briefly address the court when it's appropriate.
And when you say there are multiple, that you'll let me know which victims you're referring
Yes,
to.
it's the
Sure.
family related to the homicide victim.
Okay.
But I'll introduce the court. So the first factual basis will be for the incident that occurred on March the 29th of 2016. This is going to be the aggravated assault charge related to Mr. Sean Brousseau.
Mhm.
And his first name is SHAWN. Last name is BROUSSEAU. And the facts that give rise to that incident occurred on that date, March the 29th, 2016, at just about 11:30 p.m. that night. And officers are dispatched at that time to the intersection of Cameron Alexander Boulevard and Elm Street, which is located in Fulton County. All of the incidents that I'm about to describe to the court and the factual basis for this case all occur in an area of the city of Atlanta known as the Bluff, which is a neighborhood that occupies several streets in one of Atlanta's APD's zones. Officers are dispatched to the location as a result of a 911 call made by a female, Ashley Granger, Grainger is her last name, about a friend being shot. That friend is actually Mr. Sean Brousseau. Mr. Brousseau is ultimately able to be interviewed by officers and describe what happens despite sustaining a gunshot wound to the leg. He describes to officers that he was at the intersection of Sunset Avenue Northwest and Jet Street, again, in the city of Atlanta. And he is approached by a male that goes by the name, or that was known to him by the alias of Lil Bro, who I expect the evidence to show to be the defendant. He's approached by the defendant at that date and time and actually accused of stealing from an associate of Lil Bro's. Mr. Hinton is extremely unhappy at that time. He denies the allegation, Mr. Brousseau does, and that interaction sort of turns into Mr. Hinton trying to sell him a certain quantity of heroin. When that sale is refused, Mr. Hinton becomes upset, pulls out a handgun and fires around into the leg of Mr. Brousseau. He takes off from the location and Mr. Brousseau does the same, but is able to come in contact with an individual he has called dispatch. And as a result of that, the Atlanta Police Department works this aggravated assault. As a result of the homicide investigation in this case, Detective Mike Young from the homicide unit sort of reworked the aggravated assault because of the sort of nature of the interaction there, the geographic location, and the concentration of incidents related to Mr. Hinton. And if this case advanced to trial, I would expect to have testimony from Mr. Brousseau that would identify Mr. Hinton and that was consistent with the account he gave to officers back in March of 2016. He was not, unfortunately, extremely seriously injured and is able to walk and has no lasting injuries as a result of the gunshot wound to the leg. The next incident is the March 30th, 2016 undercover drug buy that is related to, and so I'll just say, so it's a little bit cleaner, for the March 29th, 2016 aggravated assault of Sean Brousseau, that's related to counts 9 and 10 of the indictment. Let me make sure I'm not missing anything. And it's also sort of in the mix on count 1, which is the participation of criminal street gang activity as well. So this next factual basis is from March the 30th of 2016. And on that date at 407 Sunset Avenue, an undercover buy was conducted with this defendant, Mr. Avante Hinton, who sold to an undercover agent 0.67 grams of heroin, the quantity or for the price of $60. As a result of that interaction, which occurred again then in the Bluff, there were active warrants for this defendant, and that was later served, and the defendant was taken into custody at another drug business location or trap house, essentially in the Bluff. But that occurred on March the 30th, 2016, at just around 12 o'clock in the afternoon. And that transaction, the March 30th, 2016 incident, is related to counts 11 of the indictment, as well as count 2, 1615-4C. That count is charged that way because as a result of the state's position is as a result of participation in criminal street gang activity, actually made an amount of money through that activity, which is why it's charged with the C subsection. The facts that give rise to the homicide case and all the related charges occurred on May the 31st, 2016. At about 10:40 that evening, Mr. Hinton shot and ultimately killed Mr. Kayshawn. His first name is Kaishaun Bernstein, with a .45 caliber handgun in the driveway of an abandoned house located at 409 Cairo Street, again in the Bluff area of Atlanta. Sort of the situation that gave rise to what would ultimately become the homicide was a group of individuals, including this defendant, Mr. Hinton, being suspicious of Mr. Bernstein. Mr. Bernstein was known by a lot of his friends as the nickname Ace. Around that time, I expect the evidence would have showed Ace had a close relationship with this group of individuals, and back in the months prior to the homicide had actually worked at a few of these drug locations. A couple months before, there is a falling out essentially amongst the group. Ace is accused of stealing from the location, messing up the count on different nights, and using some of the product. As a result of that, he's essentially fired from his job at the trap house, and it cuts ties with the group. This happens with Ace and another one of his close friends who goes by the alias Young. His name is Anthony Sumlar, Sumlar. So those two have not been asked back to the trap house to do any work. The group that is currently working at the trap house, including this defendant, Avante Hinton, takes sort of an annual trip to Miami to celebrate the work that they're doing at these houses. They go to Miami. When they return just after the the Memorial Day holiday, they learn that one of the trap houses has been broken into and counterfeit currency has been taken out of the location. So this is on May the 31st that they sort of return to the location and discover that one of the houses has been broken into. Ace and Young, or Mr. Bernstein and Mr. Sumlar, are suspected of being the individuals that broke into that location. And as a result of that, Avante Hinton uses the cell phone of Daryl Thomas and calls Ace, bites him over and says, "Hey, do you want to come over and make some money at one of the houses?" Mr. Bernstein's friend, Mr. Sumlar, is extremely suspicious of this and says, "Don't go over there. That's not gonna, they suspect us of breaking into the house." Mr. Bernstein unfortunately decides to try to let bygones be bygones and comes over to the house at the Sunset location. When he comes over to the house, there are multiple individuals still present there, but it ultimately trickles down to just 3 individuals, and that's going to be the victim, the defendant, and another unknown male that the state believes is going to be Mr. Carlton Bynum, BYNUM. He goes by the alias Ugg or Uggy. At some point in that evening, I expect the evidence to show that the group leaves from Trap House A under the guise of going to a second location. Mr. Bernstein would have not necessarily been suspicious of that. They sort of work in tandem with multiple houses in the neighborhood. And at some point during that walk, they arrive at the location of 409 Caro Street, where ultimately Mr. Bernstein will be shot and killed. The medical examiner, I expect, would testify that there were 3 gunshot wounds into the back of Mr. Bernstein, one of them being close in range, which we can tell from soot and stippling, and the other 2 from a further distance. It's also consistent with where the 45 shell casings are collected. It looks like he is injured, runs some duration, and sort of collapses in the driveway at that house. At the same time that gunshots are fired along this walk from Trap House A to Trap House B, there are 2 911 callers in the neighborhood that call and describe hearing several gunshots and then seeing 2 males run away from the location. They describe the males as appearing extremely young in age, one being much shorter than the other and having a sort of t-shirt or something wrapped around their head, and the other being more stockier and a little bit taller. And those descriptions are consistent with Mr. Hinton and Mr. Bynum, and they leave the location. I expect the evidence to also show that when they leave that location, they subsequently arrive at a female's house in the area of Newtown Circle. When they arrive there, they are going to discuss the shooting. And then Mr. Hinton goes on the next day to tell an individual that he had to hit Ace 10 times with his handgun.
Yeah, you can hear me.
That handgun was a gun that he was able to essentially with Joshua.
Hold on 1 sec. Okay, sorry.
The gun was, the evidence will show that gun was shared with another individual. His name is Joshua Edwards. And the investigation also revealed that Mr. Edwards did in fact provide his .45 handgun to Mr. Hinton the day of the homicide. So as a result of Detective Young's investigation, he ultimately takes warrants for Mr. Hinton for the homicide. When he is picked up for that is when we have the last factual basis for those charges, and that occurred on June the 10th of 2016. This occurred at 416 Lindsay Street. Again, another one of the trap house locations associated with this group. At 2 o'clock in the afternoon, a series of officers, including Detective Young, executed a search warrant at that location, 416 Lindsay Street. Inside, they were able to locate Mr. Avante Hinton, who takes off from the location but is arrested a short distance away. And they also recovered individual plastic baggies of heroin that weighed 2.6 grams, individual plastic baggies of crack cocaine weighing approximately 2 grams, a lockbox with keys, and other evidence consistent with a drug business running out of the location. As a result of being taken into custody on the June 10th date, Mr. Hinton is ultimately interviewed by Detective Young, and that interview is the subject to that case that went up on appeal before the Supreme Court. I know this court has heard, as a result of our motions, testimony or proffers at least about the criminal street gang evidence in this case. But should this matter have advanced to trial, I would expect the evidence to show that this defendant is an associate of the Bloods, more specifically the Inglewood family gangster Bloods, and that his work being done in that trap house is directly related to that association. That it would have been essentially Mr. Hinton's responsibility in his role, not only through that criminal street gang, but his sort of role in the business there at the trap house, to send a message back when there's something done wrong to the business or to the group. When this group learns that Mr. Bernstein, even if they mistakenly believe Mr. Bernstein broke into the house, it would have been up to Mr. Hinton to sort of assert himself and get some sort of justice for that. He did that by shooting Keyshawn Bernstein 3 times in the back and then bragging about it to other individuals associated with that house. When Mr. Hinton is booked into custody, he's in for a period of time before he picks up the next series of charges that are related there, that are on the indictment.
So there should just be count 15 left.
Right.
Okay. I mean, 16 and 17, but those are, we don't need to hear about those.
So this occurs on the 20th day of May 2017. There's a group of individuals, all who are documented inside the jail as associates of the Bloods, that end up as a result of a dispute with Deontay Knox about affiliation with the criminal street gang. Mr. Knox denies any affiliation with the gang, and there's a dispute with a large group as a result of that. He's struck multiple times, stomped, kicked. Once he's on the ground, continued to be struck about the head and face, and sustains injuries as a result of that encounter inside the jail. I took a close look at that case again this morning, looking first at his injuries, but all of the reports associated with the case. I was not satisfied about my ability to meet my burden on counts 16 and 17, specifically the possession of the shank while inside the jail. And so that's why I'm asking that the court accept my null pros on 16 and 17. So the family of Mr. Bernstein is here in court. They've been here all day, but more importantly, they've been here throughout this entire process and have suffered a pretty devastating loss, not only with Keyshawn, but his mother actually lost 2 boys in a very short period of time. She's shown a lot of grace through this process and has been very patient with it and extremely understanding. I'm going to ask if anybody, she has other members of the family here that are always here every time that we're in court, but I'll ask if she'd like to make a statement to the court. Just give me 1 second.
Sure.
Machine is ready when we take a break. You said you can come.
Just passing on what I've learned. Okay. No, you're stuck. So Ms. Convery, if you will introduce each of the persons, and if they could come up sort of near that Starbucks cup of yours, that way Ms. Rivers will be able to hear them, but they'll be at right there's perfect. Thank you. And how are you related to Miss?
That's my big girl.
Okay.
I'm the first girl. I just want to say, you took a big part of this from this. You took it from my mom. He has a daughter. She got to grow up with a father. He has other younger siblings, not only me. We have another brother and two more little sisters that can take breaks. And I just don't feel like it was right. We had to live with this for a rest of our life. Like I said, my mom lost her first son at birth.
So your brother was the oldest of all the kids?
Yeah, my son learned from me the older oldest. And I just, it would never be right. It would never be
Ms. Bernstein, who is helping take care of your niece, your brother's daughter? Okay, good.
She only has images of her father. She missed him so much. She talked about him all the time.
How old was she? How old was she when your brother was killed?
Around
Okay, really little. Well, thank you for helping raise her. Anything else you want to share? Well, I appreciate you being here, and I'm sorry the wait has been so long before we reach this point. This doesn't solve anything, but it's an important marker in the process. It's a recognition, as you put it, of it wasn't right. It's never going to be right. But I appreciate you sharing that. You're welcome. And for the other members and of Mr. Bernstein's family and friends, I appreciate you being here. You not saying something says a whole lot. This is a very difficult time, and just being here indicates how much you still care. As I was explaining to Lolithia, this has taken too long, and whatever closure this brings, and it's not complete closure, should have happened earlier. And I'm sorry that you all have had to wait this long. But we've reached this point, and I appreciate your patience and working with Ms. Convery and her colleagues throughout all this. Thank you. Ms. Convery, anything else?
Not at this time, on behalf of the state.
Well, that was very thorough. Thank you. Ms. Young, I would like to hear from you about anything and everything concerning Mr. Hinton, but please include in there why this is an Alford plea.
Thank you, Robert.
You're welcome.
I'd like to address that first, if I might.
Mhm.
For reasons that I will go into in a moment, there are a lot of defects in the state's case. There's a lot of extenuating circumstances. There's a lot of arguments that could be made and might ultimately persuade a jury to find Mr. Hinton not guilty on many of the charges. The one, as the court knows, there were 5 cases that got merged.
You're right.
One of the cases, which turned into the counts regarding the heroin and the cocaine, there was an undercover sale that was done not by my client, that was a different drug charge, by somebody else through the window of the house. And then ATF went, I believe, and they executed a search warrant for the house. And Mr. Hinton was in the house. He wasn't in possession, physical possession. It was circumstantial or constructive possession. But because there were baggies described as being throughout, by the window, by the common areas, even through the bathroom, the concern that I had, I've been an attorney now, this is my 31st year. I was a DA in 2 different states and 2 different jurisdictions for about half of that. So the concern as a defense attorney is, how do we rebut the constructive possession? So Mr. Hinton and I had discussions about this. I've spoken to his father, I've spoken to his mother. His father is here, his mother's on Zoom, about what the potential penalties are if the jury found him not guilty on everything but the drug charge drug charges, it's still more time than what we've been able to negotiate. So.
And then you have just the ripple effect of if he's guilty of one, maybe that connects some jurors thinking this. I understand what you're having to deal with because these are connected in a way that I felt was legally appropriate. You have to face that uphill battle of maybe the dominoes start falling from one incident to the next. You may have a great argument on incident 2, but because it's a less compelling argument on incident 1, that weakens your credibility as you're saying, well, but it wasn't my guy in the other one.
Yes, Your Honor, and I thank you for putting that so well. One of the things that I've done on this case, and I've been with Mr. Hinton since almost the beginning. He had another attorney. That attorney passed away before the Jackson Detto hearing, before the appeal, and it's been my privilege to represent him throughout. One of the things that I did file were, I think, 10 defense motions, including demurrers, contesting the indictment, contesting the gang charges, contesting the rest of the evidence, some of which are still pending, such as the motion limine. Pursuant to the plea at this point, I would be affirmative withdrawing any defense motions that are outstanding. But for the reasons that I would like to go into a little more detail, that's the main reason that he's asking for to be able to plea under Alford versus North Carolina, and for these specific reasons. In none of the cases has the court heard, except for the case where he was in a house with drugs, so constructive possession. And we did file a notice of alibi about 15 days ago, within the statutory, just
I heard.
Listing the people that he was, according to the statements, with around midnight that night. Of course, the homicide occurred about 10:44 p.m. But we wanted to preserve that testimony in terms of the overlap because it's such a short period of time. And as counsel said, Ms. Converse said, there may have been some belief that one of those people may have been with him throughout that. Whether he participated or not is a different issue. But what the court did not hear was that there was any lineup. There are no lineups, which pointed out Mr. Hinton. One of the witnesses was shown 7 lineups, failed to identify my client. There's no forensics, there's no fingerprints, there's no fiber, there's no DNA. There are actually 11 different Glock 45 models that exist according to their website, the research that I did, but no gun was found. So there's nothing in the ballistics where they can check the bullets or bullet fragments against the tool markings on the inside of the barrel of a gun. So that, again, there's nothing to connect my client. There was no gun found. Little Josh or Josh Edwards saying, we share a 45. I don't believe that ultimately that would be believed to be credible or persuasive. Even if you believe, even if the trier fact was to believe that my client was in a gang members don't hold on to guns. They don't trade them back. These aren't like you put them over your mantelpiece or something like that. If there's a gun, they're grabbed, they're used, they're disposed of typically. And I expect that from my training as a DA and my training as a defense attorney, that the gang officers would be in agreement with that. This is not something they hold on to. Even if this was true, it's highly unlikely, again, that just because he's alleging he gave a 45, it's easy to do that when they have no 45. So that because of the lack of evidence, it was believed that a lot of these charges or some of these charges, if I was able to get them separated, which is why I filed the motion to sever and the court did ultimately separate the shanking. If all of them had been tried independently, I think he would have had a much greater likelihood of being acquitted on one or more of these cases. But since they were not, the court gave us a lot of time, gave us days. And Judge Reeder also gave us hours, an entire day to argue this. So it's been heavily litigated. At the same time, there's an allegation that Mr. Bernstein broke into a trap house. And in the reports, it says that counterfeit money was taken and it was believed as part of motive that my client was upset about that. But the statements in the case, I think there's like 1,200 pages of transcripts of statements. The statement was that the only person that Mr. Bernstein was proven to be with shortly before his death was a state witness, and that state witness gave the statement, including that they were playing with counterfeit money, and that's where the counterfeit money could have come from. So again, there's so many issues, and that's been part of the negotiation. Is Mr. Hinton was 16 and 17 years old when this all happened. He's been in custody for 5 years. He has a child that he has never seen, and if he was to go to trial, the maximum is life without parole plus 260 years.
Right. There's a significant downside.
It's a huge risk. I even double checked to make sure for the record that because he was a minor at the time, because he was 17 at the time of the shooting of Mr. Bernstein, that he was even eligible for life without. Because it's a homicide he is, if that charge was gone, he wouldn't be. But again, this case has been heavily litigated from the inception. So we're left with Mr. Brousseau, Mr. Bernstein, all the state witnesses that talk about my client, his little bro, he does this, he does that, we know him, okay? They all know him, they recognize him. If they see him at the grocery store, they will know who he is. So the fact that they say, Mr. Brousseau says he shot me, okay, he could have said anybody shot him. There's no forensics tying him to the scene. On the sale of heroin, that is, speaks for itself. But again, that's an officer, not a civilian. So we know that that's a different situation, right? On the homicide, the prosecutor, Ms. Convery says he was accused of stealing, he was fired, there was a trip to Miami, there were shell casings, there's 911 calls, but what do the people in the 911 call say? They say, as paraphrasing, that they heard shots about 10:44. It's not unusual. One person looked out, saw two young Black men running away, one with a towel around his head, who was the shorter one, couldn't see his face, no identifying marks. Usually when you have identification that's corroborative, you have tattoos, you have gold teeth, you have unique clothing, you have eyes, you have scars, you have something. There is absolutely nothing unique. The problem here is that everybody knows my client. So it's easy to say, even if they all got together and said, hey, we've got a chance to advance up the gang, we're going to set up Evante. This is the way to do it, because there's nothing else to the contrary. You can't prove a negative. I tell clients all the time, and I tell friends, don't give your cell phone to somebody else. Happened right here at the courthouse once. Had a client who handed a cell phone to somebody. His mom's a paralegal with a very big firm in town. I said, how? No. And both my client and the other person are giving me dirty looks. What's the big deal? Well, everybody that works in the courts knows the problem is that person calls the victim on a case, calls somebody else, makes a death threat. How do I prove that my client wasn't involved? It's not on video. So you can't prove a negative, or you can't. Yeah,
it's hard to.
Right. So you're left with all the civilians that know him, that say he did all of these things, that are going to come into court because Ms. Convery is going to find them, her investigator will find them, and if necessary, they will ask the court for warrants, and they will put them in jail. And I understand that, and that's all been discussed. How do you combat 12 people who don't want to be here, who don't want to be in a pandemic, who don't want to be around any of this, who are afraid for themselves and their loved ones, overlooking all the evidence of he said, she said? It's the perfect way, like I said, to set somebody up. In terms of the shanking at the room, I saw the video also. My client's room. It's easy again to say he was there, he participated. What you see him doing on the video is a proffer.
When you say room, meaning cell, we've shifted to the jail. Okay.
Yes.
Yep.
Is you see him walking down the stairs, going in the area. You do not see on the video him affirmatively striking anybody. But again, the people that are there, they know him.
Right.
It's easy to say he participated. In terms of the gang allegations, one of the things that's always bothered me about the gang
statute in Georgia specifically, because I came from 15 years in Florida. But it bothers me that almost any act can be in furtherance of the gang. If you go out to dinner with people, it's in furtherance of the gang. If you go to Miami, it's in furtherance of the gang. If you meet and mentor, if he became a big brother, was mentoring somebody, it could be in furtherance of the gang. So it's, in my opinion, in my legal opinion, in my experience, it's overbroad. Unfortunately, it's not my opinion that matters. I'm not the deciding factor of this. And the legislature over and over and over again has said it's sufficient. And they do that to give the prosecutors and the police the tools to combat gang activity. The problem is what happened didn't necessarily have any furtherance of gang activity that they could prove. They can't prove that the sale of heroin, that money was given for the gang. It could have gone to his mom. It could have gone to buy jewelry for a girlfriend or for his baby's mother, excuse me. Okay. The same thing with the homicide. Besides the fact that there's no forensics to tie him, it's just what people are saying and what they say he has said. We don't know that that was in furtherance of the gang. You can connect the dots, but you can connect the dots a lot of other ways too. He wasn't there. He was with other people. He had nothing to do with it. And jealousy, envy, advancement, anything. It could be that somebody wants to date his child's mother, decided, hey, we can get him out of the way. Again, not in furtherance of gang activity. So every single one of these counts that they've looped together to the court, I can make this legal argument to 12 people. They're going to look at me and go, well, is he in a gang or not? If he's in a gang, yeah, it's all gang stuff. And then again, he risks not going home. So to go from a possible life without parole plus 260 years to including a 37 minimum before he's even eligible for parole to the door. No, so for everybody, I want to make sure that means no gain time, no good time. The only credit he gets is for the time that he's actually been in custody. And that possibility doesn't even come up for 37 years, 32 on the homicide, 5 for the consecutive gun, to possibly never going home, to a negotiation based upon all the defects as I see it in the case, not putting the family of Mr. Bernstein and Mr. Brousseau through having to see autopsy photos and trial and all the things that those of us that have seen a murder case tried know the families go through. And that includes not having my client have to sit through trial, his family, his father, his mother, his child's mother, to spare them that. He's asking for the court to accept the Alford plea. I'm asking the court permit the negotiations of 30 years to serve. He has, by my calculations, 1,966 days. And I know, I don't think the court usually gets into those calculations, but for the record, in case it's helpful, on case number 1607303, he got 4 days or should have credit for 4 days for being in custody from April 13th, 2016 through April 16th, 2016. In case number 1611352, credit for 6 days for being in custody from June 10th, 2016 through June 15th, 2016. And then on case number 1612352, credit for being in custody from June 26, 2016 through today, which should be 4 days, 6 days, and 1,956. And the reason I'm asking to put, and I appreciate the court allowing me to put that on record, is if it says back to credit time served, ordinarily the jail or the clerk or somebody will look at the last conviction date. But because there were 5 cases, I just wanted to helpfully facilitate this being a little bit
Sure,
easier.
it's more moving parts. That's helpful.
Thank you, Judge. I don't know if Mr. Hinton's father, who's here, wants to speak. You want to say anything on your son's behalf? Yeah, you can come up.
So if you could come up, sir, to the corner of the table there, you can see the multicolored tissue box. That would be great. Right. Good afternoon, sir. If I could have your name? Antonio Johnson. Mr. Johnson, good to meet you.
Like it's a kind of or sent on. No, you really ain't had no, you know what I'm saying? The childhood of life, pretty much all that good. I wish that you could be a little lenient on, you know, of the sentence. I had to talk to Ms. Young, and I was trying to get him to go down on the plea. But I'm just asking, could you be a little, possibly be a more lenient on the sentence? Because I think 30 years is a kind of hard sentence. So no evidence, they ain't got no strong evidence on them, and then like that, I think 30 years is a hard sentence on them. You know, I'm just asking for a lenient sentence.
Okay, I hear what you're saying, and it's natural for a father to seek relief for his son. It's been very helpful to hear from Ms. Young, her perspective of the evidence. I suspect if we had a back and forth, Ms. Convery could go on for about as long as to why she thinks the evidence is strong. In the end, your son's very experienced, we've heard 31 years, attorney has evaluated the risks of going forward. One can never know what a jury's going to do, but given all the charges that were brought against your son, there is a risk. I don't know how to calculate that risk, that the trial would not go well for him. And the minimum I could give him if he were found guilty of those offenses would be life plus a bunch of years. So you're not hearing me say 30 is a small number, 30 is a gigantic number. But some of the other options make 30 years seem like a pretty reasonable number when you look across all these allegations. Neither you nor I was present for any of this. And so I very much appreciate your perspective, and I'm factoring it in. It's significant to me that Mr. Hinton has family here after all these years coming forward to say he's a good kid and you need to show some lenience. I appreciate you sharing that. Okay, thank you, sir.
Your Honor, Ms. Brown is, Tanisha Brown is on Zoom. Ms. Brown, do you want to say anything to the judge? You're muted. Can't hear you.
Yes, hello.
Hello, Ms. Brown.
Hey, Judge, how are you?
I am okay.
Okay, this is a really, really hard situation for me, and I can't be in the courtroom while this is going on. But first of all, I would like to send my condolences to the deceased family, because the one time I did come into court, I was not aware of a lot of this stuff that's happened. I wasn't aware of. I'm learning a whole lot of facts today. My son ran away from home at 14 years old to the place called the Bluff. Whatever goes on in the Bluff, I guess you guys know better than me. I became angry with him. When I couldn't control him to make him come home, this is the result. I sympathize, but it hurts. It hurts traumatically to even witness him standing in that courtroom right now. And I understand that you're at a loss. I'm at a loss too. He has a 5-year-old son that he's never met. And I don't even know how to explain this situation to him. A few months ago when we had this thing where we could have did the plea out, and it would have been a little bit more, I'm not gonna say lenient, but I don't think it would have felt as bad as it's feeling right this second. So on the behalf of my son, he was not raised with all this drug activity and this stuff that in this indictment. And he really don't even know anything about that life. Whatever he learned over there in that Bluff and all this little bro, that's not the name that I gave him on his birth certificate. And it's aggravating, but I do want to apologize to each and every last one of you. And I ask you, Judge, to take in consideration that he has been there for over 5 years, that he does have a child. Although we can't bring back the deceased, I do want him to have an opportunity to get things right. And again, ask for your leniency during this time.
Thank you, Ms. Brown. I have a question for you, if you would take it. Do you know if your son knew someone in the Bluff? What drew him out of your household into the Bluff? Because I take it from what you were saying, you don't live anywhere near there. And so when he ran away, he was going to a different place, not just down the street.
No, he was going to a way different place. He has kin folks that's near the Bluff, but he didn't go to them. I guess these are outside friends, people he linked up through school or something. I have no idea, but the Bluff, no.
Okay. Well, thank you for sharing that, and I very much appreciate you being here on behalf of your son.
Thank you.
Ms. Young, anything else?
Just briefly, Judge, I want to make sure that that I state for the record that this is a good faith from my perspective. And if I said anything that gave a different impression, this is a good faith prosecution. Ms. Convery is a fabulous attorney. I know that she's given us a lot of time. I'm grateful that she was willing to reoffer the plea that my client accepted and then rejected and then wanted to plea again. Because there's a lot of time that I know goes into getting ready for a case like this. And my arguments in terms of what's missing in no way was intended to infer that there wasn't enough evidence to get the conviction. And I just wanted to make sure that I was clear about that. And if I said something that came across a different way. Okay.
No, well, to me, it didn't come across that way. You were highlighting what you felt were weaknesses for the state, strengths for you. And in many cases, those exist in tension. Sometimes there's not a whole lot to say for the defendant because it's on video, there's a confession, there's DNA. That's not this case. Now, there may have been a statement that was not particularly helpful to your client, but that's not coming in thanks to your hard work. So that's not something Ms. Convery could rely on. But I did not hear from Ms. Convery's presentation anything that made me think, wait a minute, we shouldn't even go forward with this plea because you wouldn't be taking care of your client by allowing him to
Or
plea.
vice versa, that I was in any way impugning.
Right. Nope, didn't hear that.
Okay, great. Thank you, Judge, for
Sure.
allowing me to make sure that that was clear.
Yep. Mr. Hinton, you have a right to say something. It can be a lot, it can be a little, it can be nothing. But this is your plea. And other than the victim's family always has a right to be heard from them. You do as well, should you choose to exercise that right. But just like if it were a trial, you don't have to testify. So let me know if there's anything you want to say. And if there's not, we'll keep moving forward.
I like to say, I feel like, life was taken, but I didn't take it. And I had nothing to do with it. But in my best interest, I had to take this plea. As far as everything goes, my lawyer, she basically said everything. But it's a hard plea. It's 30 years. Like they say I got a 5-year-old son, never seen. But, it is what it is. But I know I'm gonna stand on what I've been saying. I never murdered this man, and that's all I have to say.
Sec. I don't know who that lady is. She keeps unmuting. All right. Mr. Hinton, I hear you loud and clear. That's the point in many cases of an Alford plea. So I got a few questions for you, but first, Ms. Young, you waive any issues that might arise from the fact that we're working off a copy of the indictment?
Yes, Your Honor, I would specifically request that the court sign.
I will electronically sign for you. Mr. Hinton, normally you'd sign the indictment, but it's electronic right now. We're not passing paper around. You authorize me to sign for you?
Yes.
Yes?
No,
And
I don't mind.
Pardon me?
I don't mind.
You don't mind? Okay, I'll take that as a yes, I may. Ms. Convery, may I sign for you?
Yes.
All right. Mr. Hinton, this case that you've heard people talk about, Alford, US Supreme Court case, North Carolina versus Alford, it authorizes a trial judge like me to accept a plea, even when a defendant says something like you said, which is, I didn't do it. Sometimes a defendant concludes that it is in his best interest to go forward with the deal that his lawyer has negotiated, even though he's saying it's the wrong guy. Maybe I was there, I didn't have the gun, maybe I wasn't there, whatever the deal is. I'm hearing you say both those things, not to all the charges, but to some of the charges. Obviously, the most important one, the murder. I, Mr. Hinton, didn't shoot Mr. Bernstein, but ... I still want to take this deal because going to trial could be a whole lot worse. Does that describe your situation?
Yes, sir.
You understand that an offered plea results in a conviction anyway. It's not going to change what it looks like on paper. And if I go along with the joint recommendation, which I intend to do, it's not going to change the sentence. It's just your way of making clear to everyone who's paying attention, and these are the folks who matter in this case. You're saying you're describing the wrong person when you say Vontae Hinton shot and killed Mr. Bernstein.
Yes, sir.
Okay. I'm going to accept your plea. I find there's a factual basis. And by that, I mean that if the evidence went the way Ms. Convery described, I think a jury could find you guilty. Would they? That's a tough call. And Ms. Young has helped me understand, and I know she's worked with you on this, there are reasons why a jury might not find you guilty, but there are reasons why they could. And if they did, I would not stand in the way of that verdict. And that verdict would mean a life sentence and beyond for you, given all these charges. It's pretty clear to me that you were active in the bluff, doing stuff you knew wasn't legal, whether it's just the selling the drugs or it's enforcement behind that. You were moving with the crew that scared your mom didn't understand and really wasn't what she wanted you to be involved with. But that's where you were, and those are the people you moved with. And you're not the only one to get wrapped up into situations like this. There are a couple tragedies here. I'm not going to rank them, but I certainly need to acknowledge that Mr. Bernstein's senseless death is a big one. He's not coming back as a result of this. 30 years from now, and it's really 25 years from now, Mr. Bernstein's sister can't hug him. Mr. Bernstein's daughter can't say, Dad, look, I graduated from college. Here's your first grandkid. Mr. Bernstein will never experience that. Similarly tragic is your son's upbringing, because his dad's not going to be there. A difference is that when your son turns 31, you could be at that birthday party. But when Mr. Bernstein's daughter turns 31, he won't be there. You're going to be out of commission for a while, as you put it, as a big sentence, but it has an end date to it in a way that Mr. Bernstein's sentence that was imposed on him by you or folks in your group doesn't have an end. And that's real unfortunate. And I think that plus these other things, Mr. Brousseau getting shot, I haven't heard you saying anything about, I didn't shoot Brousseau. We're lucky Brousseau's still alive. You shoot someone in the leg, maybe they bleed out, maybe they don't. He didn't. So that's not another murder charge. But it's a series of pretty violent, scary things. And I do think there's a factual basis for your plea. I also find that your plea is knowing and voluntary. Voluntary means even though you are not excited about what's going on, you've decided, you've already told me this, that it's in your best interest to go forward. No one's forcing you to do this. You may feel caught between kind of a rock and a hard place. Trial, it's a hard place. This plea is the rock, but you are freely picking the rock over the hard place. Is that correct?
Yes.
And I find that your plea is knowing, meaning you've understood all the things we've talked about. I know you and Ms. Young have gone over this a number of times because we almost got there once before. But just to make sure, do you have any questions about anything Ms. Convery said, Ms. Young said, or I have said?
No.
Okay. Then I'm going to accept your plea as an offered plea. I'm sentencing you pursuant to the Probation Options Management Act. All that, oh, I'm not, because you're not going to be on probation because that last bit is suspended. I am going to sentence you pursuant to 1710 6.1E. that gets the murder count out from underneath that life sentence to what your lawyer and Ms. Convery have jointly recommended. So let me look at this indictment and tell you how the sentence will be structured. Your sentence as to counts 1 through 3 will be 20 years to serve. Your sentence as to count 4 is 30 years to serve. Those are all running concurrently with each other, meaning at the same time. Counts 5 and 6, you've pled guilty to those through Alford, but those are vacated by operation of law. No sentence for those. Count 7 merges into count 4, so there's no sentence as to count 7. Count 8 is 5 years. It has to be consecutive to count 4. That will be suspended. Count 9 is 20 years to serve, concurrent with count 1. Count 10 is 5 years consecutive to count 4, concurrent with count 8, and it is suspended. Count 11 is 30 years to serve, concurrent with count 4. Counts 12 and count 12 is 15 years to serve, concurrent with count 4. Count 13 is 30 years to serve, concurrent with count 4. 14 is 12 months to serve, concurrent with count 4. And 15 is 20 years to serve, concurrent with count 4. I may have misspoken because it's lots of counts, so let me be clear as to what I intend the sentence to be. It is a sentence of 35 years to serve 30, with those remaining 5 years suspended. And Mr. Hinton is to get credit for all the days he has been in custody in connection with any of the indictments that were consolidated into this one indictment. Ms. Young has provided the dates on the record. I intend those to apply. Mr. Hinton, if when you get your projected release date, you are given less time than you should have received, you let Ms. Young know that, she will let me know that, and I will correct it. So it's not exactly 5 years. I think it's a little short of 5 years, but if you get 1 year credit or 2 years credit, someone's made a mistake and I'll make sure that mistake gets corrected. If it's 4 years, 320 days versus 4 years, 321 days, I'll fix it. If it needs to be fixed, that may be a harder fix because that could be a disagreement on which day did something start and which day did it end. But if there's a big chunk of time missing, I intend for you to get credit for the big chunk of time that you have been here in the Fulton County Jail. Ms. Convery, anything else you think we need to do in connection with Mr. Hinton's sentence in this case?
No, Your Honor.
Ms. Young? Mr. Hinton, any questions about that?
No, sir.
All right. To the Bernstein family, again, this doesn't fix anything. We're closing a chapter, and I hope the closure of that chapter helps you all open up a new one that has a little more joy in it. Thank you for being here.
Judge, that concludes my business, and I have excused.
Yes, ma'am. And thank you for your work on this case. You have demonstrated a commitment to a defendant that we don't always see. And I appreciate the work that you've done.
Pleasure. Thank you, Judge. It's been a pleasure to be here in front of you and work with Ms. Convery.
Okay. All right. Do you need a break, Ms. Rivers? Let's figure out what we're going to do next, and then we'll take a quick break just to give everyone a minute, because it's been a long day, but we've been dealing with some real important things. Mr. Bridges.
Yeah, my battery went dead, so I had to come back out here.
Okay.
Judge, I just wanted to apologize for being late. There were so many houses.
We couldn't get to the case till now anyway, so it's all right. All right. Mr. Bridges, talk to me about Mr. Barry's case.
I spoke to Mr. Barry and I spoke to the ADA.
Ms. Hall?
And we're gonna do a global, try to do a global resolution. We're gonna waive the
Indictment?
Yes.
They'll accuse them?
And have her.
How soon should we get them back, or should we find out from Ms. Hall? She should be able to accuse whenever. How soon? Okay.
I'll do that today and tomorrow, and then hopefully she can get it guided and we'll be good to go.
Okay, so we can get this back on a calendar for, it's effectively, I don't know if it'll be one accusation or two, but it's a plea / a revocation. Thank you for coordinating all that. We'll get Mr. Barry, and he knows this.
Yes, we did online.
Fantastic. Okay. All right, we'll get you a plug next time.
Right, yeah, that concludes my business. Maybe excuse.
Yes, sir.
Go ahead, okay.
All right, Mr. Fox, we took care of, I think from our Zoom calendar, all that's left is Mr. Brown.
Yes, Judge. So the plan on that case was to handle the revocation and 3 new cases, plea on all 3 of those. Globally, we waived indictment a couple of weeks ago. I think the holdup is one of the cases just doesn't have the SC number yet.
Okay.
The SC numbers on the other 2. I think that's what Ms. Hall was attempting to straighten out with the clerk's office.
Okay,
So
so we can hold for that to see. Otherwise, we'll get Mr. Brown back here shortly. Was the plea going to be to you are released, or was he going to be in custody a while longer? Okay, so if we need to reset it for a couple weeks, he's not spending 2 bonus weeks in.
Yes, Judge.
Okay, so we'll hold on that. So Lieutenant Dooley, Mr. Brown, position 2 should be the only one still hanging on. Is that you, Mr. Brown? Can you wave if you're in 5 North? Yeah, it is you. Great. So Mr. Brown, we're gonna wait a little bit more. I appreciate Lieutenant Dooley and her team's patience, but if we can get all the paperwork, we can take care of everything today. If we can't, we will do it soon. It may be you get brought over here. It just depends what day of the week we can get ready, or we'll do Zoom again. But Ms. Wood has reassured me that the way it's going to be resolved, you'd be in custody a little bit longer. So we're not, by not being ready with the paper, we're not making you stay longer in jail, if that makes sense. So, but sit tight. We may be able to do it today. So I've got Mr. Brown as the other Mr. Brown. I need to be very careful. Benjamin Brown as a plea.
I think so, Your Honor. I was waiting on Ms. Hall.
Okay, so we're waiting on Ms. Hall. Mr. Abate, you are still here because you're still providing.
Mr. Brown, hold on. Judge, about how long do you want him to wait? Because he's getting ready to walk off.
Oh, yeah. We're going to take a 10-minute break. Our court reporter needs to go pick up her laptop so she can keep doing her work, and it's on another floor. So we're going to take a 10-minute break. In just a minute, I want to know what we're going to do. During that 10-minute break, we'll find out whether DeMarcus Brown can do his pleas today or not. So when we get back, yes, we'll do it. No, we're done for the day with the Zoom stuff. And we'll also find out what's happening with a Benjamin Brown who is here in lockup.
Okay, so deep down, 10 minutes and come back, okay?
Yep.
Thank you.
All right.
Judge, I have a question.
Just one
Number
second.
5.
Just a second.
Are we good on Mr. Williams? I know the wrong Mr. Williams was brought out.
We are. I told you may have all of it. Kare Williams, we thought was Ramel Williams for a moment. And I said, hey, you're up on the 14th. But Shamal Patel fixed that for Kare Williams to say, no, you're up on the 30th, although it sounds like it'll be a plea. And then Ramel Williams was told by Shamal Patel, you are up on the 14th of December. And he didn't need to come out here to hear that again from me. So you need to work out Kare Williams if you can. Let me just see what's left for, you got nothing on the 8th. Kare Williams is now because of that plea, Kare Williams is number 1 on the 30th. Interesting to try, but I don't know why he'd want to do that. So that is it for you. Nope, you have Roberson and Marable as a way back up, but it's behind Miles, who sounds like will be a trial. But for sure, Williams, he's number 1. And then you've got Oliver on the 14th. All right, thank you. Yes, Ms. Nelson.
I didn't hear any announcement on number 5, Johnson, off the jail Zoom calendar.
It's going to be a virtual PTI. But Ms. Wood's team is looking for a program for him that Ms. Hall is comfortable agreeing to. So it's a virtual PTI, but you and I are gonna put it on the status calendar about 30 days out so that we keep everyone straight on that.
Okay, thank you.
Although I have his waiver of arraignment. So I've got Mr. Johnson's waiver of arraignment, which I'll get to you. And then we'll want to see him again in 30 days if it hasn't been put on the dead docket equivalent. You can go get the computer now. We're not getting anything on the record. Before then.
Okay,
Does that work?
yes,
All right.
thank you.
So we have potentially two things left, maybe a plea for DeMarcus Brown, and it sounds like a plea for Benjamin Brown. We'll see. We need Ms. Hall. Great. Thank you for sticking around, Mr. Webb. And I'll be back out in a little bit. I told you it's gonna be a long day. I told you. We'll get out by 5 at the latest, even if we've got 2 pleas. So Hinton. So if you guys want to move people around, the only one we need to keep up is Benjamin Brown. You don't need to talk to anyone else?
No, Your Honor, I think the rest of my class were set.
Okay, so Benjamin Brown needs to stay put. Everyone else, if you want to move some people around, go for it.
I told you, tell him to take one down. Are the vending machines on this side of the building or the other side? I was on the other side, you know. On the second floor or? No, it's on the. You can go on the 8th floor, but. What the vending machine? 7th floor. Where the cafeteria used to be? Yeah, or the 7th floor. Is that where that is? Yeah. 7th or the 1st? The 7th have one too, it's all the way at the back. Oh, this side of the building? This side, yeah. 7th floor? Okay. So you get off the elevator, just walk all the way down to the other side, just make that right, you'll see the vending machine. Okay, thank you. Everyone is gone.
I know, I'm like, what?
Where's Mike Webb?
He was literally just sitting here. And he went that way when he should have went that way. Oh, is this it? Yeah, I don't know why that's. Ms. Nelson?
Ms. Nelson is on a break and we're waiting on you, so you just have to wait until she gets back.
I was waiting on you, and I was writing back. I just took an hour plea. Who's Crawford so dramatic? I won't do that.
Okay.
Yes, sir. How long is the breakfast gonna be?
He said 10 minutes. That was like 4 minutes ago. Do you need help? You got it? Okay.
You do three when you're.
We were trying to do that and I had waived, it was one that had a bunch of unindicted cases. And so we had waived indictment and there's been an issue with getting the SC numbers in time. So I think it's gonna have to be like a small reset.
Oh, okay.
What about you?
Well, I was helping him do that plea I was talking to you about,
Yeah.
and the deputies brought my client out in the courtroom by mistake, and I was trying to explain to him at the podium what the offer was, and I don't know if he got it or not, so I'm thinking it's such a good deal.
Yeah.
What I was gonna ask the judge to do, I was just gonna say, would you please have the state put the offer on the record? And then if he wants to answer my client's questions, then maybe my client would be inclined to do it. I mean, I don't want to coerce the client, but I'm not above, when I think it's in the client's best interest, trying to push him a little.
So has he been brought out before Judge McBurney yet? At all? Or we don't know?
No, I don't think he was earlier.
Okay.
I mean, he was out there just for a brief second, but the judge said, no, he's out of order, take him back, so.
Oh, that's right. Yeah, it could be helpful. To have him.
Sometimes he's so much better at explaining things than I am to the clients, because the clients don't trust me, but he does such a good job of it, and they listen to him. Sometimes it helps, sometimes it doesn't, like that.
They didn't take him back to, he's still here though, right?
Yeah, he's still here, I asked him.
For some reason, I thought one of yours was taken back earlier, or maybe they took him down, but they didn't take it back yet.
Right, that was Benjamin Brown.
Oh, okay.
Because she had given me a revised offer, and I didn't really understand that when she called me. I guess it was yesterday or day before. Must have been yesterday. The days are running together because I'm so frustrated with the jail, trying to telling me the clients that I know are there aren't there, or they can't find them,
Right.
Let's get them.
Do you have anyone on the calendar tomorrow?
Well, I have a revocation on for tomorrow, and that's the client that I've been trying to see to take Cassie's offer to him.
Are you gonna appear via Zoom tomorrow?
I don't know.
Well, the judge can probably, if you still have not been able to speak to him because I think you said he was a trustee.
Yeah.
So the judge can probably, I don't know if you were in here earlier, but I had a client who was here on Zoom and I needed a breakout session. So the judge just put us in a breakout session. So that might be something you could do for tomorrow with that client.
I think Cassie was gonna ask for a continuance. What time is that revocation calendar tomorrow?
I don't have it with me. It's tomorrow afternoon.
Oh, it's in the afternoon, okay. Because there's that rights parade downtown.
Right. Yes,
I don't know if
correct.
the judge, I don't know if anybody's planned for that, but that's gonna start traffic probably for.
So I think it's a 1 o'clock calendar, but I'm not sure.
But I think she was gonna ask for a reset because, she had clients, she had witnesses that had to fly in or come in from North Carolina or something like that. And that's why I was trying to get the offer to my client so she could not have to make those arrangements. But, I guess I should go back and ask her about that. She's back there.
Yeah, she is right there. I just talked to her about my parents' case.
Yeah.
Miss Nelson, are you there? Ms. Hall, are you there?
It's just me.
It's just you, okay.
I'm here. I just had, but I had to plug my device into a different location.
I have to run to the school, Miss Nelson. It'll take about 12 minutes. I'll be back.
Miss
Okay.
Crawford,
Yes, ma'am.
before you leave, I'm just gonna go ahead and tell you, I think, and Mr. Brown, I'll tell you while you're here, I think that case is gonna end up getting reset. I don't know what Mr. Webb is doing with his cases, but Mr. Brown has one other unindicted case that we need to get ready, so it can be a global resolution.
Which Brown is this? DeMarcus Brown on the?
Yes,
on the-
ma'am, DeMarcus Brown,
Okay.
20 C 176900.
Okay,
Okay.
thank you. I'll be right back, guys.
Okay, so you're gonna reset that, Ms. Wood?
Yes, ma'am.
Okay.
They said it, I said it out loud.
What, were you talking to me? Maybe not.
Ms. Nelson,
Yes, sir.
put us on mute. I'm sorry. Put everybody on mute. I'm really sorry.
It's okay. I'm telling you, it's okay. I'm not mad at you at all.
So they got here. Oh, so I told him, listen, he didn't understand what you said. Yeah. And then stay out of this. He said, I'm about. Why? Yeah. Sleeping. Oh, yeah. That nigga's he's on my blow. He can have some goddamn season on his mind. But I break out, I still have time. Skip. What are you playing? Go over there. Really have it. Oh, man. Yeah, call for the stretch and everything. He fired. Yeah, I'm like, no, I ain't getting started to come 5 minutes in the middle of the 2. I'm like, yeah,
We're still missing, Ms. Hall is the critical path here.
Judge, I did find her, and I confirmed that I'm still missing one of my needed indictment numbers, or
Okay.
accusation numbers.
So should we get Mr. DeMarcus Brown back here in the near future?
Yes, Judge, I think part of the confusion was that there were like a number of pending CP cases in the system, and one of them actually ended up already getting intertwined with this probation, but then there's apparently another one that, I don't know what happened, but there's one that needs to be caught up.
Okay, I'm turning his microphone on. There he is. We can hear you now. DeMarcus Brown, how you doing?
I'm all right. I heard.
Good. Well, you've been very patient. I know the booth isn't where you wanted to spend your afternoon.
It's all right.
The good news is you got the prosecutor working for you now too. She has been trying to flag down. You've just been a busy guy. So you got 3 different cases that needed to be accused, and there's just one piece that they didn't have. So what I'm going to do is ask Ms. Nelson, who is my litigation manager, to get you on a calendar in the next couple of weeks. So not months away, next couple of weeks before Thanksgiving, ideally, to tie all this up, because it sounds like you all have negotiated it. So it's not a question of what's it going to look like. We just need all the magic paperwork here so it can happen. And it maybe you get brought over. We have 1 day a week where we bring folks over. We have 1 day a week where people appear virtually. I'm going to leave that to Ms. Nelson to decide. But as long as you're comfortable proceeding remotely, it could fall on that day. Otherwise, we'll have you over here and you and Ms. Wood will be here in person. Okay?
All righty.
Any questions?
No.
All right. Well, thank you for your patience, sir. And with that, Lieutenant Barry, we are done with the Zoom booths. I appreciate you guys being patient. We had to weave in some non-booth stuff that carried over from this morning. Busy day for the McBurney division, but thank you out at the jail for all your support.
You're welcome. Have a great day. Y'all be safe going home.
Okay, you too. Go Braves.
Judge, may I be excused?
No, of course. Thank you so much. About tomorrow,
Yes.
it is fine for anyone who wants to be virtual. I will be here.
Okay.
Because I need to be, and it's not gonna be a problem getting here in the morning. The problem is gonna be all these defendants trying to get here on time because Freddie Freeman's gonna be riding by on a float at the same time they're trying to get here. If they are coming from the west or the south, I think getting here won't be a problem. But if they are coming from the north, that'll be trickier. And so I'm gonna be, I told Shamal Patel, I'll be particularly flexible on the whole bench warranty thing. We got a bunch of stuff on the calendar, and even if we can knock out a few of them, fine, but that'd be good. I'd like to do that. But if each of you is in a different place because coming downtown scares you / why would I hassle with it, that's fine. I do think that if you get here in the morning, you'll have no trouble leaving by mid-afternoon. The parade is going north, so getting to Cobb might get complicated. But if you're going any other place, it ought to be okay. That said, not a requirement. If I'm here all by myself tomorrow, that's okay, as long as you've plugged in virtually.
Yes, Judge. And before I do leave, I will be with Judge Glanville in the morning, but I don't think that'll bleed over into this calendar. But if I'm a little late, that's where I am.
You're helping with Veterans Court?
I am.
Great. Thank you for doing that. We will be flexible.
I will see you on Wednesday for drug court. So.
Fantastic. Ms. Primmett, have you, you've got a full-time job here.
I'm just covering.
Okay.
I think she's picking a jury with Dunaway's courtroom.
Okay. Got it.
Thank you. Y'all have a good one.
You too. Now we have Ms. Hall and we have Mr. Webb. Are we going to be able to sort out Benjamin Brown? What says Mr. Webb?
I think so, Your Honor. The state made a really good offer, and he's having a little trouble understanding the law. And sometimes I know you can't insert yourself in the plea bargaining negotiations, but you were so good sometimes at explaining things.
Well, let's bring him out and we'll see what we can do.
Okay.
Um,
And while we're doing that, I just wanted to inquire about, there's a revocation tomorrow on Quentin McKenzie that Ms. Hall and I have.
I was just looking at that. Doesn't he have a murder case?
I think he does, doesn't he?
Or it's attempted murder. This is the co-defendant of Mr. Franklin's guy who ran from the police, and that guy's pled. Then Quentin McKenzie has a pretty big fish to fry beyond this. I was just sort of surprised that he was on for a revocation because the basis of the revocation did not seem to be attempted murder. Oh, it includes that.
I'm the one who requested it. I put all 3 cases on there, and I wanted to have actual revocation for you to resist it. He's on first.
Oh, so there's a lot of room to work with.
However, I did make an offer, but they've been messing with Mr. Webb. He's been going all week to the jail and apparently not there, and they were sending out other
Quentin McKenzie's?
Quentin McPherson is what they told me twice last night.
All right.
So we were gonna ask for a reset, just for like a week, because I was gonna actually have the actual revocation. This will be the first time the petition has been in the court, but I do wanna have it before I get transferred.
Okay.
Before his first offender in, which is in a month.
So you intend to actually call witnesses. It's not a revocation of people agree to it kind of thing.
But I did make the offer, if he wanted to call the offer, if it's open cases, I made the offer, so if he wants to accept it, I want to give this way of time to convey that before I bring it on.
Yep. Okay. So I don't know that we can stop Mr. McKenzie from being brought over tomorrow, but you are letting me know that it may be as basic as we call the case and say it's being reset for a week or so. But the state is red, so he needs to know this, and you can help explain it, that it's going to be an evidentiary hearing. The state is ready to prove up these new violations. And we'll work through that. Okay,
The
Mr.
reason
Brown,
I-
I'm sorry, we're keeping you standing there.
The reason I brought that up is because I had gotten an email that said my office building is closed tomorrow. None of the other state ones are, but mine is because of the parade.
Yeah.
So, and I was told, I was encouraged to work from home, but if you need me here, I can either do it by Zoom or I can come here if you want me to.
No. I would like, if you have cases on the calendar and you do, it's Mackenzie, please dial in to the calendar. Your
Okay.
appearance may be brief because it sounds like for Mr. McKenzie, we'll be saying, we'll see you soon, very soon. Ms. Hall is packing a lot in before she goes,
I
but
know.
it's all right. Good to leave with a bang. So please do dial in, but you don't need to come down here.
Okay, well,
All
I just wanted to check. If you wanted me here, I'll come. I just
Got it.
may have a problem with.
No, I'm not requiring anyone to be here tomorrow other than folks who got a summons and they're on bond. They need to try to make it here. I'll just work with them if the parade made that difficult.
Yes, sir.
All right.
Okay.
Benjamin Brown.
Yes, sir.
Hold on one sec. You sure? That last one cleared it? Yeah. Mr. Brown, give me 1 second. I'm just calling your case up on my screen as well.
Let the judge explain, I'm gonna let them explain to you what the offer is and the judge explain the law to you. And then you can decide what you want to do. Okay. Does it make sense?
Yes. I don't know. Yeah.
Okay.
We won't hear that anymore. There's your indictment. Okay. So, Mr. Brown, I'm Judge McBurney, and you've got a case with me that charges you with 2 counts of aggravated assault. There's an allegation that in June of last year, you and a Mr. Holmes, the Darius Holmes, you got into it somehow. I don't know all the facts, and we're not going to talk about them quite yet. But something about maybe you chased him with something that Mr. Holmes thought was a knife, and you may have had a BB gun. Maybe you plunked him with a BB gun. But again, I don't want to talk about the facts. I want to talk about where we are with your case. I am ready on Monday to try your case. You have been sitting in jail for a long time. And if this is not a case that can work out, then we ought to let a jury hear about what happened with you and Mr. Holmes. And the jury can decide, did you shoot him with a BB gun? Did you chase him with a knife? And if the jury says you did, I need to give you a sentence. If the jury says you didn't, you get out. But there's a risk to going to trial, which is why most folks end up entering a plea. Ms. Hall, what is the offer that you have made to Mr. Brown should he want to resolve his case short of going to trial?
I'm going to say this for aggravated assault, 5 years to serve, 15 months, credit for time served.
How many months do you estimate Mr. Brown has already served? 16.9. Okay. So, Mr. Brown, what Ms. Hall would recommend if you decided you wanted to work the case out today and not risk going to trial, Ms. Hall would recommend a sentence that gets you out probably tomorrow, maybe Saturday. It just takes processing of paperwork. But her recommendation would be, and I don't have to follow her recommendation. I may think it's too steep. I may think it's not steep enough. Her recommendation would be 15 months. You've already served 15 months. So it's basically a time served sentence followed by some probation. That's what she's recommending. I don't know what Mr. Webb has told you about that recommendation, if he thinks it's reasonable or not. It seems reasonable because it gets you out of jail, but that is not a decision for me to make. That's a conversation for you and Mr. Webb. I want to know if you are interested in working the case out today, time served, you get out, or if instead you want to stay where you are until we can get you your trial, which could be Monday. And if it's not Monday, then it would be at the end of November. Tell me your thoughts about that.
Well, I don't know. I guess I've been sitting there with innocent, but with trial, it could go the wrong way. I don't want to jeopardize, any more of my free time because I haven't sat there for 17 months for something I didn't do, but.
So, Mr. Brown, there's something called an offered plea, and I don't know if Mr. Webb got a chance to talk to you about that, but an offered plea, and that's just the name of a famous Supreme Court case. An offered plea is when a defendant says, I'm going to plead because that's the smart thing for me to do, but I didn't do the crime. Those things the state said, that's not how it happened. Maybe it was Mr. Holmes who had the knife, or I wasn't there, or look, he was drunk and I was trying to keep him off me. You'll get a chance to tell me your version of events if we go forward. But the offered plea is the defendant saying, it did not happen the way the state says it happened, but I don't want to run the risk of going to trial. And the jury hears the story and like, you know what? We buy the Holmes version of events rather than the Brown version of events. Guilty. And then, aggravated assault's 1 to 20, and there are 2 counts of that. So I don't know what would happen at sentencing. So that's what I'm here. I think I heard you say, now, this isn't something I did, but you don't want to serve any more time than you've already served. Is that a fair description of your situation?
Yes, it is.
So
I'm sorry.
I just got one more question, and then I certainly want to hear from Mr. Webb, and he may want to talk to you some more. I think then where you are right now is, Judge, I'm not happy. I've been in jail for so long, but I am prepared to pursue an offered plea to resolve this and not risk going to trial and having a jury take this away that I, meaning you, don't like. Is that a fair description? Because I don't want to put words in your mouth, but I think I'm understanding you.
Yes.
Okay. Mr. Webb, what did you want to add?
I was going to add, I think he's eligible for first offender treatment, Your Honor. If that's eligible, if aggravated assault, one can get first offender.
One can. I don't, like Mr. Brown and I are having one of our first ever conversations. And so if he is eligible as a first offender, then it's not even a conviction if he does fine on probation. Do you have any insight into Benjamin Brown's criminal history, Ms. Hall?
Depending on where any prior conviction is, and we did talk about first offender, so we're not opposed to that if we choose to go that route.
Okay. So, Mr. Brown, if you want to go forward with the plea, we'll have a more detailed conversation about it. But there is this notion of first offender where if you've not had a felony conviction before, you can say, I'd like to be treated as a first offender. And if there's a good basis for it, it sounds like there may be in your case. If I sentence you as a first offender, you will be on probation for a little while, but you don't have a conviction. So if you're looking to work or get benefits or go to school, you don't have to check that dreaded box that says, are you a convicted felon? You wouldn't be. You would not have a conviction. And assuming while you're on probation, you stay out of trouble, you successfully complete your sentence, it all gets wiped away. So that's a possibility if that's something you're interested in. I think it would be smart if you and Mr. Webb just huddled up for a minute. You don't even need to go back into lockup, but I want to make sure that you are making a decision informed and voluntarily. That is what you want to do, because you've got this absolute right. If you want us to get those jurors, we've got them coming, and we've got cases behind yours, but you're moving up the list. And so it's coming up to be your turn. Gosh, you've been in jail for so long. We need to get you to that jury if you are not otherwise resolving your case. So why don't you two talk for a minute, and then you tell Mr. Webb what you want to do, offered plea, first offender, trial, and I will oblige. Okay? All right, you guys can sit right there, however you want to do it.
She wanted to do some supervisors would reduce it. Because that's what it's doing. So if you get a first offender, you won't have that. After this, after 2 years. Well, what it just means is if you got into trouble with this thing, you don't have to report it, you don't have to pay obligations and correction fees. That's correct. Well, I gotta handle that. If you do first offender treatment, nobody can access it if you go to apply for a job and it's. You're not really Social Security benefits or anything. Not necessarily, it's up to the probation officer. You have to talk to them. We might a mistake.
No, I'm just saying about travel.
You might have to get permission at least for the first 2 years. If you want to get permission. Yeah. Shouldn't be a problem. You can do it with the record. Then respect. But if you do the other plea, you decide to continue to take a board risk. Well, I always suggest the 2 years as a compromise, and she wanted to do that with her supervisors. She has to answer the supervisors when it comes to.
So what's the plan? You need a little more time, or you guys in a place to move forward?
I think we're in a place to move forward, we are.
Okay, well, let's get all this on the record. All right, Ms. Rivers, you ready? This is position 35 on our trial calendar, State versus Benjamin Brown, 20 SC 177085. Mr. Brown, as I understand it, you are interested in pursuing an offered plea to your charges, what we call a best interest plea, where you don't admit to the charges, but you decide that it's in your best interest to plead guilty. Is that correct?
Yes, sir.
Okay. And you're interested in being treated as a first offender as your sentence. Is that also correct?
Yes.
Okay. Well, you and I will cover that more in a little bit. Just want to make sure that was your plan. Ms. Hall, who's the prosecutor handling your case, is going to put you under oath in just a minute. Once you're under oath, you need to make sure you answer all of her questions and mine truthfully and completely. Part of that process means you need to let me or Mr. Webb know if you have any questions of your own. If someone says something that you don't understand, or it's different from what we've been talking about and it confuses you, you need to call a timeout so that we can walk through what your question is. Will you do that for me?
Yes.
Great. Ms. Hall?
Thank you, Your Honor. Mr. Brown, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
I do.
Please state your true, correct, and legal name.
Benjamin Brown.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 49 and went to high school.
And are
Did you finish high school?
Yes, completed high school.
And are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with 2 counts of aggravated assault?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with his services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
I do.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
We do.
And do you waive moving forward on a copy of the indictment?
Oh, yes. I didn't understand. I'm sorry.
No, you're fine.
Yes.
Mr. Brown, have you been arrested on these charges?
Yes.
Yes.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No, we're not aware of any.
And I know the judge just went over this with you, but do you understand that the minimum maximum sentence for aggravated assault is 1 to 20 years to serve?
Yes.
Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 5 years to serve 15 months, balance on probation, credit for time, the time that you've already served. But the court does not have to accept that recommendation. The court can sentence you to the maximum on each of these charges or can run those sentences consecutively or one after another. Do you understand?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being sentenced to revocation for the balance of the sentence?
Yes.
Do you understand you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
So we'll keep talking about this. I just got some information that you may have a case out of Coweta County, but we'll consider the whole first offender thing. I don't want anyone to be surprised. We'll talk with probation in a little bit. Got to make sure it's the same Benjamin Brown, et cetera. But that doesn't change your ability to enter an offered plea. It just affects whether you're eligible for first offender or not. But I'll talk to you about that when it's my turn, okay?
Okay.
Ms. Hall?
So for now, do you want me to just skip the?
I'll cover the first offender aspect with him when we get clarity from Ms. Crawford.
Okay, I just read the same information, so.
Okay.
Sorry, Mr. Brown, do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty? I'm sorry, I already know what, I restate my
Yeah,
question.
she asked the wrong question because you're not entering a guilty plea, you're entering an offered plea. So she's gonna ask a different question.
Yeah. Strike that.
No striking.
Are you pleading guilty because you have decided that it's in your best interest to do so?
Yes.
And are you aware that even though you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
How do you plead to the charges of 2 counts of aggravated assault in indictment number 20-SC-177085?
Guilty.
Excuse me one moment. As part of the plea negotiation, was it going to be guilty to 1 count and another count would be no pros?
Oh, yeah, I did. I forgot about all of that.
Okay, well, that's another benefit for Benjamin Brown. So Mr. Brown, I mentioned you had 2 counts of aggravated assault. One alleged that you chased Mr. Holmes with a knife, and the other alleged that you plunked him with a BB gun. Which count is the state null processing, if that's accurate?
The knife.
The knife. Okay, so count 2, aggravated assault, the state is dismissing. They're only moving forward on one of the 2 counts. Thank you for that reminder, Mr. Webb.
Well, thank you I appreciate it.
So I'll re-ask you, just to be clear. How do you plead to 1 count of aggravated assault in indictment number 20-SC-177085?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And do you understand that you only have 30 days from today to appeal this guilty plea conviction?
Yes.
And do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Mr. Brown. Your Honor, had this case proceeded to trial, the state expected the evidence to show that on June the 10th, 2020, one moment. At 30 Alabama Street, that is the actual 5 Points model station, Atlanta, Georgia, and Fulton County. Officers responded to that location in reference to a dispute with a weapon. When they got to that location, they spoke with the victim, Mr. Darius Holmes, who told them that he had gotten into an altercation with the defendant. The altercation had become physical, and at some point, the defendant pulled out a gun, which the officers later found out it was a BB gun. He hit the victim hit him in his head with that gun, with that BB gun. And
As in struck him with the weapon or fired it and a BB hit him in the head?
sorry, struck him in the head with the butt of the weapon.
Okay.
At some point, the BB gun fell to the ground, at which point the defendant pulled out a knife and chased the victim with the knife. Officers were able to talk with the defendant, and the defendant did admit to the altercation happening, but of course he had a different version of what happened in his events. He did admit to pulling out a knife though, after he claimed the victim had kicked him. And this was a dispute over $15 that apparently the defendant had given to the victim. The defendant was arrested. During the investigation, officers were able to locate a modern CCTV video surveillance that showed the incident. And after reviewing that surveillance video, it actually corroborated what the victim said happened. And that's how they were able to locate what happened to the gun or the BB gun. And they did ultimately arrest the defendant and charged him with these 2 counts of aggravated assault.
Did they recover the gun?
They did.
Okay.
And that is all from the state.
All right. Ms. Crawford, good afternoon. Tell me what you found in connection with Benjamin Brown. You think there's a case out of Coweta County from 06 or so?
Good afternoon, Judge McBurney. After I looked this offender up, Mr. Brown, there's a case from 2006, 2 counts of theft by taking and 1 count of theft by taking misdemeanor. Appears to be the same person. He took first offender on that. And the case closed out in 2011.
Okay, thank you. And when you say appears to be, you're looking at Mr. Brown on the camera or based on his identifiers, his FBI number or whatever?
I'm looking at him on the camera. I also have a photo of him in my system and date of birth. What is your date of birth, Mr. Brown? 11/18/71?
Correct.
Okay,
Yes.
same guy. Thank you. All right.
I'm sorry, Your Honor. I was unclear. Did you use first offender on a misdemeanor or was it a felony?
No, it's 3 counts, 2 felony theft by takings, 1 misdemeanor theft by
okay.
taking.
Okay.
And the sentence, it looks like was 4 or 5 years. So it was a felony sentence. It's been closed out. He did it successfully, but he's used first offender.
All right.
Mr. Webb, tell me about Mr. Brown and this situation, some of which apparently was caught on video. I know you got the video. I don't know if Mr. Brown got to watch all of it, but it makes the Alford piece a little more confusing to me. So I want to hear you out.
Well, thank you, Your Honor. Actually, I have not had a chance to view the video because it wasn't in the file that I inherited.
Right.
And I know Ms. Hall was doing her best to get it to me today, but I still haven't seen it.
Okay.
I've been relying in good faith on what the state has represented and what were in the police reports. Mr. Brown tells me a slightly different version of the facts. He says that they got into the altercation and that he, at some point, when he was fighting with the victim, that he threw the gun down or dropped the gun down, and then the victim kicked him. And I think the piece of the case, which is not favorable to him, was that he chased him after the victim kicked him. He ran, and I think Mr. Brown was alleged to have taken the knife and chased him with it. Although it was in a case, it wasn't open.
Right.
And we're grateful to the state for agreeing to null pros that because it certainly, would look not good with the knife being involved as opposed to a BB pistol.
Sure.
But and that's where I had a little difficulty. I was trying to explain to Mr. Brown what the law is in Georgia about aggravated assault, and he, was under the impression that it was a simple assault. And I was trying to explain to him that aggravated assault can occur even if the victim has a reasonable apprehension that they are going to be seriously hurt and that it is a legitimate weapon. That's what counts.
It's a very flexible law, Mr. Brown. I've seen aggravated assaults where the prosecutor has charged because it's a stick, and it's presumably not a stick that would snap just like that, but it really is, what does the victim perceive? And so if you're big and the victim's small, your fist could cause an aggravated assault because that's a weapon which, when used offensively against another, could cause serious bodily harm. I mean, people die from getting punched enough. So there are lots of ways that something that to you might seem kind of minor could be charged as and proven to be aggravated assaults. And certainly if there's a knife involved, whether the blade is out or not, if there's a replica of a firearm, the moment you point a BB gun, unless it says on it cartoon gun or something, the person's not going to know, and they're going to think, uh-oh, I could die right now if the trigger got pulled, or it could break my nose if I got smashed with the butt of the gun. I'm not saying you did any of those things. It's not necessarily what you do as it is the perspective of the victim. Like, he's got a gun, anything could happen. So that's just a little bit on the law. I understand why you were a little concerned about how could this situation have turned into an aggravated assault. But it's helpful to hear Mr. Webb describe your side of the situation. Did you have anything else, Mr. Webb?
Well, I was going to mention, I believe he was homeless at the time that he was arrested. Of course, he's been incarcerated for 15, 16 months now. So technically he's not homeless at the moment, but I wanted the court to take that into consideration in imposing any sentence with probation requirements on it. Did you have a job before this, Mr.?
No, self-employed.
Oh, he was self-employed. Okay. So any, fines or fees the court might be inclined to impose could set him up for failure.
Okay.
But I do think the offered plea is appropriate, even though he's not eligible for first offender. And we'll ask the court to accept that.
Mr. Brown, I got a few questions for you, and then if you've got any questions for me, you can ask them. How did you know Mr. Holmes?
From downtown in downtown Atlanta, in that area.
Around 5 Point Marta?
5 Point Marta and the Gateway.
Okay, he spends time there as well?
Yes, sir.
Have you guys had a peaceful relation in the past, or has he been trouble for you?
No, it's been peaceful. That's why I couldn't understand why it elevated to this.
What was the $15 about, or was
I loaned it to him.
Okay.
Loan.
At the time, were you living out of Gateway, or where?
No, the Sheraton Inn, they had a program that I was into.
Okay.
Stand there, but
where will you go? You, like I said, if I accept this plea, you're going to get out tomorrow, Saturday. Where do you think you'll go?
Either to the Sheraton, see if they already accept me, or contact my sister in McDonough, Georgia.
Okay. Because before we're done, Ms. Crawford, who's with probation, is going to need to get some contact information from you. Tell me, you said you're self-employed. That's a broad term. What kind of work did you do?
Handyman, any kind, plumbing. I usually help my brother with, different job. He's in real estate, and I help do fix-up work for him.
Okay. And he deploys you to, hey, we're going to try to sell this house. The sink leaks, and boom, you fix the sink.
Right.
Okay. Mr. Brown, I'm asking this not because it's going to change your sentence in any way, but because I want to try to set you up as a guy who's going to be half a century old soon to succeed here. Is there any drug or alcohol angle to your struggle finding a house and kind of your self-employed situation?
No.
No?
I don't drink or smoke.
Okay. Well, there are things you can consume that don't involve drinking or smoking that would make it hard to keep a house or keep a job.
No.
That's not your situation? Okay. How is it in your mind that you ended up homeless or sort of on the edge?
Well, basically, I was trying to start anew here because I just came back from living in Alabama. Well, I took care of my oldest brother who passed with cancer. And I came back to Georgia to take care of my dad who passed from dementia and cancer, brain cancer. And that's why I was staying. My sister's in McDonough, Georgia, but I thought I could find work in the city. That's why I tried out,
If I asked your sister or the brother who's the real estate agent, hey, why's your brother Benjamin kind of like at Gateway or at the Sheraton thing? What would they say? Like, why is he not a real estate? What does your sister do?
She's with the post office. She's IP.
Okay. So why isn't your brother with the post office, or why isn't your brother doing real estate? What would their explanation be?
I don't know. I guess because I hadn't applied.
Okay. All right. Fair enough. The case that Ms. Crawford was describing from Coweta County, the theft by taking, is that ringing a bell? That you got in front of a judge at some point? It would have been a while ago, been 15 years ago, but you had a court case and you pled it out?
Yes.
Okay. All right. We've talked about it before, but we're in the middle of the plea now where we have to talk about it formally. That's this offered plea. An offered plea is when a defendant says, Judge, I disagree with what the state says happened in this situation, but I, meaning you, still want to work this case out rather than go to trial. I'd rather not risk the trial. Maybe I'd be found not guilty, but you don't know. And so I'd like to take this offer. Does that describe your situation?
Yes, sir.
Okay. I'm happy to accept an offered plea in your case. I just need to make sure you understand that even though it's an offered plea, it's still a conviction. It's your way of saying it didn't happen the way the state says, but it's still something that's going to result in a sentence. Do you understand that?
Yes.
Okay. Do you have any questions for me?
I was just concerned about the aggravated assault and the 5 years probation.
Okay. Well, what your lawyer has negotiated for you would be, it's actually less than 5 years probation. It'll be like 3.5 years probation, because 15 months of it would be the time you've already served. But either way, the overall sentence is 5. You subtract 15 months and that leaves the rest that would be on probation. I understand you say you're concerned about it, but that's what everyone's asking me to do. Do you have an issue with that?
No.
Okay. All right. I find there's a factual basis for your plea, Mr. Brown. If Mr. Holmes came in and testified and the jury believed him, I don't know that they would, but if they did believe him and maybe they looked at this closed circuit TV camera footage, they could find that you did these things that the state said. I don't know that that's what the jury would do, but they could. And because they could, I'll accept your plea. I find that your plea is knowing and voluntary. Voluntary means even though you're not real excited about being here, you've decided after thinking about it and talking with Mr. Webb that it's in your best interest to move forward with the plea rather than go to trial. Is that true?
Yes, sir.
Okay. And a knowing plea is simply one where the defendant understands all the things we've been talking about. And you've stopped us and asked questions when you had questions. Do you have any other questions, or do you feel like you understand what's happening here today?
No, I believe I would understand.
Okay. All right. I'm sentencing you pursuant to the Probation Options Management Act, which means simply, Mr. Brown, that while you're on probation, if you have what we call a technical violation, small violation, maybe you miss a meeting or you fall behind in something, you and probation will sort that out. You don't have to come to court. But if it's a significant violation, you get arrested for something, you and Mr. Holmes get into it, you get arrested, that comes back to me and we'll need to work through what the consequences are. Okay? Mr. Webb, do you authorize me to sign the copy of the indictment for you electronically?
Yes, Your Honor.
Mr. Brown, can I sign for you as well?
Yes, sir.
And Ms. Hall?
Yes, Your Honor.
All right. So I'm going to sentence you. There's only one count left, count 1. And to that count, I will sentence you to a term of 4 years to serve 15 months with the balance on probation. You will get credit for all the time that you served, and the balance will be on probation. You've served more than 15 months, so you ought to get out sometime this weekend. If Monday arrives and you're still in jail, you need to reach out to Mr. Webb.
Yes.
And he'll let me know and we'll fix it. It takes a little while to process the paperwork. It's real late today, so it may be you get out on Saturday rather than tomorrow. Plus tomorrow's gonna be a little cuckoo with some stuff that's going on downtown. But like I said, if you're still in on Monday, you reach out to Mr. Webb. I'm going to waive your probation supervision fees for the first 4 months. It's time for you to get a job, get into a program, doing something. Your answer to me was not, Judge, I got a drug problem or a mental health issue. I just haven't applied for the job. Well, go apply for the job. Get the job and start earning some money. You can get your own place or help your sister if you're going to be staying with her. And as I said, after 4 months, you'll be responsible for paying the probation supervision fees. You'll also need to have no contact with Mr. Holmes. So if you and he end up in the same space, you need to get out of that space. If he's already there, you got to go. If he walks into a Waffle House, you need to leave the Waffle House. Hopefully your guys' paths don't cross, but whatever happened on June 10th of last year, it didn't end well for you, and it's just going to be smarter to stay away from Mr. Holmes. Does that make sense?
Yes.
Okay, good. Ms. Hall, any other conditions for Mr. Brown?
Nothing from state.
Mr. Webb?
No, Your Honor. I did mention to him, and I don't know if I'm wrong about this, but I think under the law, there's 2 years of active probation supervision on a felony like this. And then after the 2 years, it maybe comes non-reporting.
So there are lots of policies surrounding that, Mr. Brown. What I can tell you with certainty is that if you're doing well on probation, probation is going to want to make your case first non-reporting, meaning unsupervised, and ultimately they'll want to close it out early. So you do what probation asks you to do, and you're heading in the direction of that case being closed out early. You don't have any financial requirements. That's the one thing that tends to keep things open. If you owed restitution, $1,000, you need to pay that. It takes a while to pay that, but you don't owe any restitution. That's not this kind of case. So that's where we are. I'm going to let Ms. Crawford take over now. She is with probation. She's on the screen in front of you. She's going to ask you some questions about contact information. And Mr. Webb, if you don't mind writing this down, she's going to give Mr. Brown some reporting information.
Yes, sir.
And I want to make sure he leaves here with that on his person.
Yes, sir, I'll do that right now.
Because Mr. Brown, the last thing you want to do is miss your first appointment with probation. If you're not there, they fill out, well, I put it away, but one of these warrants, which I'll sign. I'm like, oh my gosh, Mr. Brown, you didn't even show up for that first day of probation. So make sure you make the meeting that we're about to hear about. Okay. Do you need a piece of paper? I got plenty of paper.
I think I have one here. I'm making it work. Right.
Okay.
I like my briefcase.
On the fly. All right, so Mr. Brown, you focus on the screen in front of you. Ms. Crawford's going to ask you some questions, and Mr. Webb will write stuff down.
Hey, Mr. Brown, Ms. Crawford from probation. The first thing I need to get from you is an address. Do you have an address that you can provide to me?
My sister's 30 Carl Lane, McDonough, Georgia. It's 30253, I believe.
So the address is 30, just the number 30, and then what's the street name?
Carl Lane.
How do you spell it?
K-A-R-A.
K-A-R-A, Lane, in McDonough?
Yes.
Do you have a contact person's name or telephone number? Do you want to provide your sister's name and number?
Yes, my sister, Annette Brown. Her phone number, as far as I believe, is 678-866-4170.
When you're released, where will you be going? Or would you prefer that I have you report to probation that's right down by the jail, or do you want to report in McDonough where your sister lives?
Right now, I probably will report near the jail until I get in contact with my sister, then I'll have it moved to McDonough.
Okay, so I'll give you reporting instructions 48 hours after you're released. I won't give you a date, but 48 hours. So if you're released on Saturday, Monday, you need to report to probation. If you're released on Monday, then you need to report Wednesday. So 2 days after your release date. If it's on the weekend, make it that first weekday to report.
Say within 48 hours or you're gonna wait 48 hours?
Within 48 hours of your release.
Okay.
So if you get out on Saturday, don't worry about showing up on Sunday. They're not open, but you want to go on Monday. And it's it's right near Gateway. I mean, you may know, well, you haven't been on probation in Fulton County, but he's writing the address down.
Okay. The address is 276 Memorial Drive, Southwest. That's Atlanta, Georgia. 30303 is the zip code.
All right. And a phone number there? Does he need that?
I can give you my telephone number. It's 470-303-6860. And I'm Miss Crawford.
I'm sorry, what was that again? I
Yeah,
apologize.
you sort of broke up on us, Ms. Crawford. What's the number again?
It's 470-303-6860.
Okay. 6860, did you say?
Yes, 6860.
Okay, thank you.
Okay. You have any questions for me?
Mr. Brown, any questions? Okay.
Report within 48 hours.
That's right. But again, you can't go there on a weekend. So chances are you should just be there on Monday, because you're either going to get out tomorrow. You guys do releases on Saturdays. So you're going to get out tomorrow or you should get out before Sunday. You should get out tomorrow or Saturday. Monday, you need to be at that address. Benjamin Brown, here I am. They'll greet you and get you set up.
Okay.
Any questions?
No, just.
Mr. Brown, let's make this work. You're almost 50. No
Yes.
more jail, okay?
Yes, sir.
Stay away from Mr. Holmes. Don't walk around with a BB gun. All right?
Yes, sir.
All right. See ya.
Thank you.
Sheriff's Office, thank you. This was a crazy day. I had no idea I ordered up so many defendants, but I've been chastised and that's right. I was hiding. She may ask. I knew we had a lot. I thought we had borrowed from folks, but we apparently went over. But that's all right. Ms. No, it's not all right, actually. But Ms. Alexander has tasked Judge Ingram and myself with, we got to come up with a pretty clear policy. And we're probably going to want to sit down with Chief Johnson and you and some others about, oh, that it's happening? Who said this? Oh, all right.
Is it an ideal number?
Yeah, I think it needs to go up a little more so that we don't, because we're starting to bump into it too much. But there also needs to be an enforcement mechanism, and it needs to be one that your team is comfortable using. Because what doesn't work is for it to be woe is us, but then I mean we need to be able to tell, like in the old days where he's like, hey, you need to use bus 2. It's just there's no bus 2. It's like, you've given us 17 names, pick the 15 you want. We'll bring over any 15 you want, but we can't bring 17 because those are the rules. Partly the chief judge needs to enforce that, but ultimately when that judge slips up and says, oh, I miscounted and it's 18, someone needs to reach out to the litigation manager or whatnot to at least flag it. And that email probably should go to the chief or someone as well, because in the end, it's not fair for anyone on your staff to have to do this with the judge. That's when the chief might need to get in there, but there at least needs to be a way to flag it so it doesn't, you guys just keep tearing your hair out saying like, well, no one's following the rules. So
What's number you looking at? You know, so I could start predicting.
What Judge Ingram and I had talked about, I understand the number to be 40 right now. Yeah, which is 4 groups of 10. There are 3 judges every day who get inmates, and they're supposed to limit it to 10. And then there's that column of 10 that's prelims or drug court. And so what we talked about is just a natural step up would be, we'll just add 5 to everything. So it's 60. It's 4 groups of 15. Each judge can have 15. And then there's this buffer. Drug court's not going to need 15. They can't have 15 prelims, but that way, if someone goes over a little bit, tell me when there's a buffer, but if someone goes over a little bit, it's not hitting your capacity, which is 6-0 instead of 4-0. I think that's reasonable, but I also understand that on the heels of breaking the rules we agreed to, it's kind of weird to come in and say, give us more, but that's really what we're coming to. Right. Well, and that's why I think moving it gradually, if we keep it too low for too long, some judges are going to say, I want 30 and you can't stop me. And like, well, we can, but then it gets ugly. So if we're able to send out, Shay and I can send out an email to all the judges saying, great news, 15 per judge. Then everyone goes, we'll be calm for a while. Because there's some judges who still don't bring anyone over. And others are like busy. But if you knew that every week you could have 15 people, then you know what? Don't bring 17 this week, bring 15. And next week, bring those other 2 guys. So that's what I'm thinking. And I didn't realize we had a meeting, but okay, good. All right, well, good. Then we will be saying the same thing and it will sound much more rhythmic to Chief Johnson. Yeah. Yeah. Thank you.
That's why when you try to ignore me. All right, I have to leave you. Yeah, tomorrow.
Is the calendar at 12:30 tomorrow, or what?
Let me tell you, and then I need to let everyone go on this thing. It is, what is tomorrow? The 5th. It is a 12:30 calendar.
Okay, and the Zoom link will be different than what it was for today. I mean,
Right, you've got a Zoom link. It was sent to you, so it's out there.
Okay.
All right. Ms. Crawford, thank you so much. Is this your last day?
No, I'll be here tomorrow.
Okay.
And I'll be here next week. I'm just taking leave, but I'll still be answering, burning up some of my time, but I'll still be answering emails and warrants and all those.
Because we didn't have a lot of luck getting a replacement for you when we needed someone. And I'm hoping that whether it's Smith or whoever the supervisor is aware that starting soon, we need someone. We can't, we could call you, but you'll come up wearing your DA costume instead of your probation costume.
He knows that my last day is Friday. I think what happened this morning, I had one stuck in my head. So I was at the school doing some paperwork for my son, and I didn't realize that we were gonna start early, but he never replied. So I'll be doing court from the office tomorrow. So I'll, be getting everything situated and finding you guys somebody.
Got it. Excellent. All right. Let me see if there's anyone else. Ms. Nelson is still here. Hey, Ms. Nelson, thank you for sending me all those final dispositions. I will look at some today, but I may do others tomorrow and get them your way.
Perfectly understandable. It has been a long day.
It has, but a productive day. Who would have thought we would resolve Avante Hinton short of trial? I did not see that coming.
Yeah, that was a sad but good case that we got rid of.
Yep. And we got a few more that we know will go away. We just need to get the lawyers in here. Mr. Reeves, I don't think we'll have a trial on Monday, but we can send out an official email to that effect tomorrow, because the only thing I see remaining would be Mr. Robinson, who is Mr. Webb's client in that jewelry store robbery. And I want to wait till Slayton pleas, because that may, as Mr. Parrish was saying, said it very aptly, like, Judge, there's a certain order in which the pleas will go that may work like dominoes. So I think we will not use jurors on Monday, the 8th, which will make next week a lot more relaxed.
Right, and then we can bring a couple people over on Tuesday to take the pleas if I can hunt down Walker's client or
Yep.
Walker.
Yep.
And
Get Reeves over here, and it may, I don't know when Mr. King's going to be ready to go on Slayton, but that would be great if we did stuff like that.
okay.
All right.
Okay.
Well, we'll be in touch tomorrow. I have some, it's like a CLE where I'm presenting with some other judges that's all morning, but it will go slowly, and I will likely be actively emailing. So feel free to reach out if there's stuff we need to discuss.
All right, then. Thank you.